with the right procedure, you don't end up in such a situation where the next procedure becomes so difficult. So I think that is one of the important things here. Thank you, Dr. Nupur. So with that, we'll move on to our next presenter, and Dr. Pragya Ahuja will be talking about corneal cross-linking tips and tricks. Is Dr. Nisha Bharti over here? So this will be the last talk of the session.
Thanks, Dr. Pui, for wonderful presentation. I will ask the panel to add something on the Pui's presentation.
Kind attention, everyone. The guest of honor will be arriving shortly. I would request everyone to please ensure that the mobile phones are on silent to avoid any interruptions during the conference. Thank you.
Deflection of the band, and that tells us that it's a high risk for hydrox. So you need to integrate into it.
Thank you, ma'am, for your kind word. We'll take the question. Meanwhile, we request next speaker, that Ashok will come. Anyone at the panel to add something? Yes, ma'am.
Question. We have a question for you. How much of a role does eye rubbing play in keratoconus? Can it be one of the causes of keratoconus?
Ma'am, studies have proven that it can be one of the causes, and if we see the journals or the studies that have been published, eye rubbing is always mentioned as one of the first risk factor and the causative factor for keratoconus. So,
Yeah, that is one with us with the frequent change class syndromes, and they have
Hello, check one.
It's a reminder, kindly ensure that all your mobile phones are on silent mode, just to ensure that there are no disturbances during the conference. Thank you. Good morning. All rise for the national anthem, please.
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उज्जल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Namaskar, greetings to everyone. I am Ashish Padam, Counsel at the India International Arbitration Center. On behalf of the Department of Legal Affairs, Ministry of Law and Justice, the India International Arbitration Center, and the ONGC, I am delighted to extend a heartfelt welcome to all of you to the conference. It is indeed a tremendous honor and privilege to have you all here. We extend a warm welcome to our esteemed guests. We are honored to have with us the guest of honor, Shri Arjun Ram Meghwal, Honorable Minister of State, Independent Charge, Ministry of Law and Justice. We also acknowledge the august presence of Dr. Anju Rathi Rana, Secretary, Department of Legal Affairs, Ministry of Law and Justice, Mr. K. Moses Chalai, Secretary, Department of Public Enterprises, Ministry of Finance, Mr. Arun Kumar Singh, Chairman ONGC, and Honorable Mr. Justice Hemant Gupta, former Judge of the Supreme Court of India and Chairperson of IIAC. We also want to take this opportunity to express our gratitude to the distinguished panelists who have graciously agreed to share their expertise and knowledge with us. We eagerly anticipate the valuable insights they will provide. Now may I please request Mr. Naveen Kumar Singh, Chief Executive Officer, IIAC, to felicitate our guest of honor, Shri Arjun Ram Meghwal, Honorable Minister of State, Independent Charge, Ministry of Law and Justice. Thank you, sir. Now I request Ms. Sandhya Yadav, CGM, Chief Legal Services, ONGC, to felicitate Dr. Anju Rathi Rana, Secretary, Department of Legal Affairs, Ministry of Law and Justice. Now I request Mr. Ganesh Chandru, part-time member, India International Arbitration Center, to felicitate Mr. K. Moses Chalai, Secretary, Department of Public Enterprises. Thank you, sir. Now I request Mr. Avneet Singh Arora, Director, Department of Legal Affairs, Ministry of Law and Justice, to felicitate Honorable Mr. Justice Hemant Gupta, former Judge, Supreme Court of India and Chairperson, IIAC. Thank you, sir. Lastly, I request Mr. Vinay Kumar Sandhuja, Registrar, India International Arbitration Center, to felicitate Mr. Arun Kumar Singh, Chairman, ONGC. Thank you for the honor, sir. Now to commence today's session, it gives me great pleasure to invite the esteemed Chairperson of IIAC, Honorable Mr. Justice Hemant Gupta, for the welcome address. Justice Gupta, former Supreme Court Judge and current Chairperson of the India International Arbitration Center, has made significant contributions to India's legal and judicial landscape. With a judicial career spanning over 2 decades, he delivered landmark judgments in civil, contract and arbitration law. As Chief Justice of Madhya Pradesh High Court and Acting Chief Justice of Patna High Court, he strengthened judicial administration. A pioneer in judicial digitalization, he spearheaded e-filing, case management, and record digitization at the Punjab Haryana High Court. At IIAC, he is dedicated to advancing institutional arbitration in India. His legacy includes judicial reforms, arbitration development, and modernization of court systems, and that is making him a key figure in shaping India's dispute resolution framework. We now welcome you, sir, for the welcome address to set the tone for the day.
नमस्कार, आदरणीय अर्जुन राम मेघवाल जी, श्रीमती अंजू राठी राणा, डॉक्टर Arun Kumar Singh, Mr. K. Moses, and other distinguished delegates. It is in fact a great day for us when we are meeting today to discuss the challenges faced by us in the arbitration, in the field of arbitration. The technical sessions are multifaceted and wide. First technical session is strengthening dispute resolution in PSUs. Actually, PSUs are the most important instrument of development of India, because all development activities are undertaken by PSUs on behalf as a representative of the state, like it may be National Highway Authority or like ONGC or the GAIL and multiple. There are probably 30-40 public sector undertakings who are dealing with the development works. So we'll discuss all this in detail later in the day. You know, the basis of today's meeting was my meeting with the Honorable Law Minister about a month back, with the Law Secretary, where I was pointing out the difficulties faced by IIAC in the arbitration ecosystem. There were valuable suggestions, but soon thereafter, this meeting has been convened for the discussing the challenges faced by arbitration ecosystem. The IIAC is in building initially possessed by Indian Council of Alternate Dispute Resolution, a society formed in 1995. It was laudable object, but somehow or the other on way, it lost its track. So the primary objective of the ICADR was rental income from the 2 floors of the building which it possessed in the Vasant Kunj. The ICDR as on today is not functional. The sole representative is one Rajkumar Rathore, who terms himself as a Secretary General, but he is in fact an associate of another senior advocate of Punjab. Rajkumar Rathore is also from Punjab. I know Rajkumar Rathore and the senior advocate, who is his mentor from my days when I was in Punjab, from actually much older than much earlier. We receive many people saying that ICADR is not there, how do we deal with the arbitration? Sometimes we say that we can deal with the arbitration provided you submit to the jurisdiction of IIAC. We'll seek consent of the opposing party. If the opposing party also gives consent, then we will take up the arbitration. And I must say that we have been quite successful in persuading parties for arbitration by IIAC. Recently, the Honorable Law Secretary has also written a letter to public sector undertakings that wherever ICADR is the institute to nominate to conduct arbitration, India International Arbitration Center should be nominated, because ICADR was also nominated on the basis of a letter from the Government of India. So once the letter has been written on behalf of Government of India, probably there should not be any difficulty in choosing IAC as the arbitral institution. Coming to the mindset, the biggest problem of institutional arbitration is the mindset. We have grown with the ad hoc arbitration. Even under the Arbitration Act 1940, it was ad hoc arbitration. The court used to appoint arbitrator, although it was sub-judge at that level, at the grassroots level. But now the High Courts or the Supreme Court in the matter of international arbitration appoints an arbitrator. But the fact is that the court appoints an arbitrator. Institutions are not generally preferred. One of the oldest institutions was established in 1965. They are having some work, but then ICADR was established in 1995. They are also, it became a defunct institution. So we have to deal with the arbitration. Institutional arbitration has to be promoted. People will understand institutional arbitration only they opt for institutional arbitration. Sitting outside and to criticize will not help. One has to feel the difference between ad hoc arbitration and institutional arbitration when people will opt for institutional arbitration. The difficulty with us is we are all aware of our rights, fundamental rights, right of freedom, right of speech and expression, but what are our duties, although made part of the Constitution way back in 1976, but that's more in theory rather than in practice. The other difficulty which needs to be discussed is that litigation in India is cheap. Apart from the lawyer's fee, which also in the matter of, in the cases before the Supreme Court, the litigation is really cheap and the costs are not following the result. We have section 35 in the Code of Civil Procedure, 35A, 35B and 35A in the Commercial Courts Act, but the cost don't follow the result. The Supreme Court has also said number of times that cost should be imposed, but it has not gone down well with the litigating public or the courts. In Western countries or in European countries or USA, the litigating court is prohibitive. The people are not opting for litigation because they have to pay litigation cost through their nose. So they have an alternative of arbitration, because for generally the trend is arbitration is only if nothing goes in court, we'll fight it around arbitration. The arbitration is also conducted like a court proceedings. That is the biggest problem which we are facing. These are the challenges which will be discussed in the following sessions. I welcome all of you who have spared your time to attend this conference and to gain from it. It will be our gain also from the deliberations which happen during the course of the day. Thank you very much.
Thank you, sir, for your enlightening words. Next, we have scheduled a presentation on institutional arbitration, legislative and policy initiatives by Department of Legal Affairs, Ministry of Law and Justice, for which I would like to invite Mr. Avneet Singh Arora, who's currently serving as a director in the Department of Legal Affairs. He specializes in legislative policy and advisory matters relating to the ADR mechanism. Over to you, sir.
May I request for the PPT to be uploaded, please? Good morning, sir. With your permission, sir, over the next 10 minutes, we'll try and understand over the last 11 years the various policy and legislative interventions that have been taken by the Government of India to overall support the ADR ecosystem, including institutional arbitration, sir. So over the last 11 years, the attempt has been to enable an ecosystem of justice dispensation which recognizes our jurisdiction as a rule of law abiding jurisdiction. We all understand that as a country we are growing. It is most important that enforcement of contracts and resolution of commercial disputes is at the forefront to support businesses to grow in our country. Because any business which intends to grow wants a stable jurisdiction where rule of law prevails. So alternative dispute resolution mechanism, we all understand, support the court systems in enabling resolving disputes quickly. To enable that, the Government of India has taken various steps, both legislative and policy, to make these mechanisms more efficacious, cost-effective, and expeditious. Special emphasis is on institutional arbitration and mediation, including by enough statutory support for these kind of mechanisms. So this is to give a broad overview of what the government has done over the last 11 years. To go into further details, the Department of Legal Affairs is concerned with 3 major enactments which govern commercial dispute resolution. We have the Arbitration and Conciliation Act of 1996, we have the Commercial Courts Act of 2015, and the Mediation Act of 2023. As we are all aware, Arbitration Act governs the procedure for conducting arbitrations. Commercial Courts Act intends to focus on having established specialized commercial courts for adjudication of commercial disputes. And Mediation Act, which is the recent enactment, focuses on institutionalization of mediation as a mode of dispute resolution which is outside court, which is through amicable dispute resolution. The Arbitration and Conciliation Act of 1996 has undergone amendments in the last 11 years 3 times. And the focus of the first amendments in 2015 was to make the proceedings more time-bound and effective. It was also focused on ensuring that the arbitrators who are appointed for adjudicating disputes are independent and impartial, because as a judge who decides the cause between 2 disputing parties, it is quintessential that the arbitrator is independent and impartial. That apart, there has also been a focus on making court as a supporting function to arbitration rather than enabling intervention by courts. To that extent, also there were amendments in 2015. The 2019 amendments focused on institutional arbitration. An Arbitration Council of India has been envisaged. That apart, there are other definitions which have undergone a change vis-a-vis institutional arbitration. So this is a broad overview of the amendments in 2015. As we have just highlighted, the importance of independence and impartiality of arbitrators has been ensured under Section 12. A 4th schedule was introduced in the Act which provides for a model fees for arbitrators, because there has always been a grievance against the arbitration ecosystem that the fees charged by the arbitral tribunals is generally on a higher side. So the idea is to make a model fee available under the Act for the parties to adopt. The time-bound aspect of arbitrations we have enabled through ensuring that there are various timelines which have been included. For example, 90 days within an interim order being given, the arbitration is required to be commenced. Fast-track procedure has been provided. We've also provided that the entire arbitration is required to be completed within a period of 12 months, which may be extended by another 6 months. As far as the intervention of courts is concerned, prior to 2015, there was an automatic stay against an arbitral award as soon as an application under 34 for challenging that award is filed, which has now been done away with. So the idea is to focus on the arbitral award's finality, and unless there is a specific stay by courts, the arbitral award is enforceable under law. So that was also one major change to ensure there is lesser court intervention. As we have briefly discussed, in 2019, the amendments focused on institutionalization of arbitration. There is an Arbitration Council of India which has been envisaged to augment and focus on promoting institutional arbitration. Two more smaller amendments were made, ensuring there is confidentiality during the arbitration process under 42A. And there is also a 42B, section 42B, which was added to protect any action taken in good faith by the arbitrator, to strengthen the role of arbitrator in the process. So coming to the focus of today's discussion, sir, we have tried to highlight what is institutional arbitration, how it is different from ad hoc arbitration, and over the next 2-3 slides, we'll also see how, what are the advantages of institutional arbitration. So institutional arbitration, as Justice Gupta also referred during his opening remarks, enables conduct of arbitrations through an institution. So there is an institution which has its rules, which supports the entire process of appointment of arbitrators, payment of fees, case management services, providing venues and administrative support for arbitration. So instead of ad hoc arbitration, where the procedure, etc., everything is decided by the presiding arbitrator, generally in consultation with the parties, but it is the arbitrator, what he decides is what takes or holds ground. So the supervisory role of an arbitral institution then enables the process to go on more smoothly, whereas in ad hoc there is a possibility of lack of consistency in the processes. The fee also in institutional arbitration is predominantly provided in the rules of the institution, sir. And as far as ad hoc arbitrations are concerned, the arbitrator generally decides the fees. It says by consultation, but what the arbitrator says is generally prevails. Institutional arbitration also prevents dilatory tactics to be adopted, because in institutional arbitration there is a check and balance which happens on the part of the institution during the entire process, rather than ad hoc, where there is a possibility of dilatory tactics being used. So just to highlight the advantages, as we have discussed, institutional arbitration focuses on a predetermined procedure, so that the parties are aware about the stage-wise timelines, the fees that is to be payable. It also enables a ready access of verified arbitrators to be available on the panel. The institutions which are experts in the field are expected to know the latest developments globally also, so that they can keep pace with the changing times and the requirements of the stakeholders. It's a professional and process-driven approach which, with infrastructure facilities being made available as well. And the most important facet is because we all understand the arbitration is as good as the arbitrator. So the impartiality of the arbitrator, the quality of the arbitrator, so that the awards which emanate out of such arbitrations also have a minimum standard, whereby the court's intervention may also get reduced if the quality of the award is good, which can also be enabled by ensuring that there is a good arbitrator. Towards this effect, the India International Arbitration Center has been set up under the enactment of the India International Arbitration Center Act of 2019. The focus has been to create an independent and autonomous regime for institutional arbitration, and all the qualities that we have discussed about institutional arbitration have been enabled by IIAC. IIAC has a process for empanelment of arbitrators, which is done by a chamber of arbitration, which is also comprised of very eminent people. So there is an entire scrutiny process through which each application undergoes, and thereafter a person gets empaneled on the panel for arbitration. And IIAC has approximately empaneled around 180 arbitrators for domestic arbitration and 86 for international commercial arbitration as well. And the process and the criteria is also laid down through the rules and regulations of IIAC. There is a separate session on how IIAC conducts arbitration under the under the regulations of 2023. But just to give a macro view of the two major regulations about how the arbitration process is conducted by IIAC. So IIAC has come up with a conduct of arbitration regulations of 2023, and another focused on conduct of arbitrations for micro and small enterprises also. So the idea of having two separate procedures is to have a more simpler process for MSME disputes and a more detailed and globally benchmarked procedure for other arbitrations. So as we have discussed, it's efficient and time bound. There is a option of emergency arbitrator to be appointed. An advisory panel has been constituted to recommend the names of arbitrators to the Honorable Chairperson for appointment for a dispute. Fast track procedure has been enabled. There's a fee structure which is provided. And it is also enabled to have online filing for arbitrations. As far as the MSE disputes are concerned, the regulations are focused on making it fast track. There is a separate panel also which is being proposed for micro and small enterprises arbitrations. There is a very interesting provision which has been under the guidance of the Honorable Chairperson about legal aid to MSMEs. So assuming if there is an MSME which can't afford to take recourse to arbitration, there is also a possibility of supporting the MSMEs to that extent. So this was what has already been attempted and done over the past 11 years by the Government of India. And what we look ahead possibly is to, now that the legislative enablement has been done for institutional arbitration, there is a requirement of actual adoption of these clauses by the parties in dispute, which are all the stakeholders. So the idea is to move from ad hoc to institutional arbitration, which is what is globally prevalent. Capacity building and the quality of arbitrators is of immense importance, because it is the arbitrators are the ones who then ultimately lead the show. The awards rendered by qualified arbitrators are expected to be more recent, and the possibility, as I was saying, of court intervention gets reduced. Paperless is the way ahead, because we are a large country, and if we want the smaller tier 2, tier 3 cities also to adopt arbitration, I think the online mode of dispute resolution can also go a long way in ensuring this. And as we have discussed, there's the Mediation Act which has been enacted. So a MEDOP process where the parties first attempt mediation, and if it fails and arbitration goes ahead, is also one way of ensuring that disputes are settled efficaciously and efficiently. So thank you so much for a patient hearing, sir. Thank you.
Thank you, sir, for this insightful presentation. Next, I would like to invite Mr. Arun Kumar Singh. Sir is the chairman of ONGC and its group companies. With nearly 4 decades in the oil and gas industry, he is a mechanical engineer and NIT Patna topper. Formerly CMD of BPCL, a Fortune Global 500 company, he also chaired IGL and served as president for Africa and Australia at BPRL. We welcome you, sir, and request you to please address the gathering.
Honorable Minister, Law and Justice, Sri Arjun Meghwal ji, Honorable Justice Hemant Gupta ji, Dr. Anju Rathi ji, Rana, Secretary, Department of Legal Affairs, Mr. K. Moses Chalai, Secretary, DP, and Chairperson, India International Arbitration Center once more for the obvious reason, and distinguished guests, ladies and gentlemen, good morning to all of you. In fact, I will just not give you some practitioner's view of last 40 years of handling disputes. So first and foremost, thank you, sir, for India International Arbitration Center for inviting me and giving this opportunity to speak and share some of our views. And also, this is a real privilege to be with you, sir. Now, public sector enterprises, I've heard the word once in Supreme Court, which was he says, most of the time you all guys are frivolous litigants. And most of the litigation lands at the door of courts because of PSUs, and earlier even between PSUs. So now, of course, that those litigations are gone, or between state government or our agency. Sir, to be very frank with you, in my parlance, the dispute are on 3 accounts. The excessive conservatism of our executives is also the source of dispute. When we don't know how to handle the situation, because of the being government and so many agencies behind you, you tend to be extra conservative. And you allow the things to pass so that somebody else has to decide, you don't have to save your own skin. Second, there is reason of our system that many times excessive optimism of the vendors also cause dispute. Many times you end up getting a job, sir, at L1 level, quoting abysmally low. And when you are not able to manage site and manage people, then you look for opportunity to create disputes. Often you'll find that it is bordering on insanity. Third reason is, sir, in our view, which is 30-40% of the disputes, in our case at least, is on account of not having adequate provision in the contract. If the contract is so rigid, that contract doesn't leave any room for any new, because situation is dynamic, you keep moving project from one stage to another, and many times it requires little flexibility. But our problem of the system is that if you, including all the legal fraternity of all the companies, they tend to rigidize the contract by giving a provision which makes it so rigid that if there is a flexibility required during the currency of the contract or execution of the contract, you don't know what to do. In fact, 1.5 years to 2 years in a project life of 4 to 5 years. Rigid contract, if the contract is rigid, 2 to 3 years goes in resolving the dispute even for work to proceed. If midway work is stuck and you come across an item which is required, suppose structural steel or something which is a different type is required. Sometimes the contract is so rigid, it presupposes, sometimes we senior people presuppose that we have all the answers of future. And we make a very rigid contract saying that everything is frozen in steel and cast, and therefore there is no room to negotiate. Invariably the word comes, there is no such provision in the contract to deal with the situation. But how do we deal with the situation? Particularly a private company gets over it because the owner has a right to, educate and say that fine, we'll pay you this much, move. In public sector system, it gets entangled. And we get hurt massively. Suppose a 40,000 crore, because we have projects which are 30, 40,000 crores. If it gets delayed by 1 year, you lose 3 to 4,000 crore on the interest alone, because most of the time 70-30 debt equity ratio is the normal parlance for most of the project. So in any case, bankers will have to be paid. But here, for 30-40 crore decision, you will not take, because if you take, if the chairman is bold enough to take, then all the time somebody is gunning for him that he took that decision. And however good you are in speaking order, like judiciary writes all the orders and all that, but still there is a fear. So what I was trying to, sir, propose that mediation, ONGC experience I'll share you, sir, which is different from after this mediation got passed by Parliament, we became more emboldened. And because there is at least a judicial framework, at least a legislative framework, if not judicial framework, to give us some credence. And we appointed OEC, to the best of our knowledge, people of impeccable integrity. Those who society or system knows as one of the best. So once a mediation decides something, we get something, a comfort that it is reasonable and somewhere midpoint. But if mediation also fails, but mediation fails in two conditions. If the vendor mediation is successful today, sir, our experience is 60% of our cases, if I remember correctly, we are succeeding now. Because of the fact that mediation, the chairman of mediation committee and all that are people of very high stature and all that. So generally both sides tend to agree. But if the model of dispute is to create additional revenue or a stream of revenue which somebody sees an opportunity to create because of the arbitration experience of past, then there is no choice but to come to arbitration. We, sir, adopted institutional arbitration as a policy in our company that will not go for ad hoc arbitration, and we were probably one of the first to sign up for institutional arbitration. But I like the word, somebody said, if I remember correctly, sir, it says global, efficient and credible. But sir, our experience of foreign arbitration, because I was involved in foreign oil and gas assets, they're very fast. They're somehow, some cases will linger for long but generally small arbitration cases, international arbitration, gets delivered very fast. I was wondering that how Singapore has ended up with handling our cases. Because Singapore also, our country is blessed with, something called English came to us in legacy. And English is still the language of foreign courts, particularly the arbitration courts, London and all that. And our judiciary capability and all is proven for impartiality and all that. So my only submission, sir, for that, with all due respect for all those people sitting here, timelessness seems to be the essence of legal system. Arbitrators also are equally timeless people. Particularly it drags for years together, for 5 years, 6 years. Even ad hoc arbitration drags for 6-7 years. So the credibility of the whole system, last word is here, credible. Whole system is not there, and sir, you would be aware that in Oilfield Regulation Act, which is recently Parliament passed, because our context of nation is that we'll find an oil and gas now mostly in frontier areas. Frontier areas are basically deep water, ultra deep water. Entire world is finding oil and gas in those areas. In fact, ONGC today 65% of oil and gas is produced from Bombay offshore. And now 98/2 we added 35,000 barrels plus in future. Sir, unless our comfort, and here we need foreign collaboration. In fact, sir, we awarded a contract to BP for enhancing our production in Western offshore. Similarly, sir, if country has to grow, our trust of foreign partners in us and in them has to grow, because we don't have still technology to know how to handle ultra deep water wells. We need them, and once we need them, they don't have great faith in our system. I'll be very frank. So institutional arbitration was a point where our initial survey revealed that they were more comfortable with, because of the international experience, instead of individual ad hoc arbitration. But in this law we have provided in the right to go for any arbitration anywhere in the world, because we needed them for growth of our country. So this institutional arbitration, sir, my invite and humble request to all of you who are sitting here, particularly PSU, I can see many PSU faces here, that bring timeliness into the scheme of things instead of timelessness. Legal system has traveled to our corporates to make our system also timeless. In fact, somehow, we executives in corporate worlds, all the merits and demerits of the project or money we make because of timeliness. Time is the money. And if the timelessness trickles in, then we lose all the fronts. So only submission to you is that institutional arbitration somehow 1 year is also, is long. Our mediation series are getting over in 3 months, 6 months. 6 months. 6 months we are able to finish our mediation from beginning to close. If we can be, I was thinking of that those who are not interested in mediation, possibly they can come to arbitration, institutional arbitration is outside the court system. If it can figure out a way of handling small matters in 6 months, maybe 2 billion, 3 billion matter can wait for 2-3 years. So that is the only submission, and sir, and this was the only thing I wanted to share. Then institutional arbitration will fly, because somehow the system has to be corporate. I should not be saying this word. More of corporate and less of legal system. If it can come in IIAC, then we are winner. Because corporates are known for, speed, because otherwise they won't exist. They won't exist for long unless you are in monopoly business. So time is the essence. Fortunately, our orders, legal orders, are very well written. In fact, we should be proud of the way we draft our orders and all that. It is much better than some of the Singapore awards that we had in previous company. And is much better, our system, but somehow, without meaning any offense to anybody, so timelessness has to become timeliness. Thank you.
Thank you so much, sir, for your insightful address. Now, I would like to invite Mr. K. Moses Chalai, Secretary, Department of Public Enterprises, Ministry of Finance, to please address the gathering. Mr. Chalai is a seasoned administrator with over 3 decades of service. He has held key positions in Manipur and the Government of India. He served as Secretary, Northeastern Council and Interstate Council Secretariat, leading major infrastructure and policy initiatives. He holds deep expertise in governance, development, planning, and intergovernmental coordination. We welcome you, sir, and request you to please address the gathering.
Thank you. Honorable Minister, Ministry of Law and Justice, Sri Arjun Ram Meghwal, Dr. Anju Rathi Rana, Secretary, Department of Legal Affairs, Honorable Justice Hemant Gupta, Chairperson, India International Arbitration Center, Sri Arun Kumar Singh, Chairman, ONGC, and all the distinguished participants of this conference today. Sir, I would like to share that yes, it is indeed very, very important to have institutional arbitration mechanism and its robust function, which will instill efficiency, fairness, confidence, continuity, and ease of doing business for all the stakeholders. I would like to just give a very brief, picture or the snapshot of the CPSC world. It's a big world. Arun Saab has, he knows, he has been in this game or in this life for much longer, but to give the holistic picture, sir, there are 448 CPSCs in the country. It's only increasing, I don't know somehow. But as on 2023-24, 24-25 figures will mature only around October-November. So in 2023-24, 272 of them were functioning, of which 212 make profits, 58 making loss, though comparatively not too big loss, and 2 without profit and loss. I don't know how this happens. Anyway, very interesting. Sir, the total gross turnover is very big. It is 36 lakh crores. That is something like $418 billion. All of them put together. And the net profit is 3.22 lakh crores. Everything is in lakh crores, if all put together. Sir, the overall and cumulative contribution to central exchequer in that financial year was 4.85 lakh crores. This is by way of excise, GST, corporate tax, dividends, and of course taxes of various nature. The CPSCs, all of them put together, have about, their net worth is about 20 lakh crores, yeah, and employ about 38 lakh crore capital. And then they employ about 15.12 lakh people, employed, of which half are regular and half will be about, contractual. And then the ancillary around them, of course, will be as big or will be huge. So surely our CPSCs are contributing in a big and huge manner to the country and its overall economic journey. And they are present in various sectors, as we know, in energy, oil, energy, they can become the oil, then power, steel, infra, road, coal, aviation, shipping, mines, defense, telecom, and so on. So, and so their presence is very, very big all over the country. Even the capex is 3.28 lakh crores in 2024-25, capex contribution. And the market, about 66 of them are listed, and their market capitalization is about 44 lakh crores. Again, this little dynamic, as we know. So, given all these figures, so as to appreciate that how significant are they in our country's life and economic life of ours. But having such a huge setup and huge presence, naturally there will be many, many cases. And I think this is one area that we really need to pay attention. As on that, there are about 211 cases, involving about 17,507 crores, and 51 cases, I'm told, have been rejected by the FAs of the administrative ministries of 1,914, and 160 cases need to be considered, involving about 15,592 crores. 50 cases have been decided, but implementation, again, is difficult. They are at different levels of implementation. And 110 cases are still yet to be touched. For both CPSCs and stakeholders, fair and speedy resolution of disputes are key to good governance, trust building, and will help to move better and also have a headache-free progress and growth. Very, very important. The two speakers also have mentioned the importance of it, and my sense is that we need to pay much, much more attention to this. We from DEP will see how best we can contribute and work together with DLA and the ministries and CPSCs. And also I was just having a short conversation with Madam Secretary that if current mechanism needs certain amendments, certain support, certain involvement, let's really look together into all it, and from DP side we give our assurance to that, so that we can have a much better way of resolution disputes, and our business and our work can go on, progress on better. Thank you so much.
Thank you, sir, for your enlightening words. Moving on, now I invite Dr. Anju Rathi Rana, Secretary, Department of Legal Affairs, to address the gathering. Dr. Anju Rathi Rana, ILS, is the Law Secretary to the Government of India, heading the Department of Legal Affairs, Ministry of Law and Justice. With over 30 years of experience, she has served as Additional Public Prosecutor, Legal Advisor, and has held top advisory roles for key ministries. A gold medalist with an LLB, LLM, and PhD in law, Dr. Rana is India's first Law Secretary. Her leadership reflects a profound commitment to legal reform and institutional governance. We welcome you, ma'am, and request you to please address the gathering.
Honorable Minister of Law and Justice, Shri Arjunram Meghwalji, Shri K. Moses Chalai, Secretary, Department of Public Enterprises, Honorable Mr. Justice Hemant Gupta, Chairman IIAC, Shri Arun Kumar Singh, Chairman ONGC. Good morning, distinguished dignitaries, officials from the Ministries of Government of India, representatives of Central Public Sector Enterprises, legal professionals, and esteemed guests. It gives me great pleasure to welcome you all to this National Conference on Institutional Arbitration, organized by Department of Legal Affairs, Ministry of Law and Justice, in collaboration with ONGC and the India International Arbitration Center, IIAC. Our gathering here today is not just to talk about arbitration. It is a step forward in India's journey of legal and economic forum. We are here not merely to deliberate, but to drive. We are here to take forward a shared national objective to strengthen India's institutional arbitration framework, to establish IIAC as a world-class arbitral institution, and to place India firmly on the global map of credible dispute resolution hubs. In a country marching ahead with confidence and clarity, under the visionary leadership of our Honorable Prime Minister Shri Narendra Modi ji, institutional arbitration is now a strategic imperative. As we mark 11 years of transformative governance under our Honorable Prime Minister, this moment offers a timely reflection. The 11 years of Seva, Sushasan, Garib Kalyan campaign is more than a retrospective. It is a testament to the consistency of delivery to structural reforms rooted in this purpose. In these years, India has dismantled colonial-era legal relics, simplified procedural laws, and embraced technology to make the law more accessible, more responsive, and more attuned to the needs of a fast-growing economy. In the past decade, our government has also recognized the importance of arbitration in the country. In one of his addresses, our Prime Minister specifically highlighted the role and importance of arbitration, which I quote, "Businesses seek assurance of the prevalence of rule of law in the Indian market. They need to be assured that the rules of the game will not change overnight in an arbitrary fashion and that commercial disputes will be resolved efficiently. A robust legal framework backed by a vibrant arbitration culture is essential," unquote. This vision has guided the Ministry of Law and Justice, Department of Legal Affairs, as we have worked to modernize dispute resolution, reform arbitration law, and build accessible legal institutions. Over the past 11 years, the Ministry of Law and Justice has been at the forefront of legal transformation in India. Many obsolete laws have been repealed to declutter the statute books. Landmark reforms like the digitization of court records, expansion of virtual hearings, enactment of Commercial Courts Act 2015, and the recent Mediation Act 2023 have significantly improved access to justice. In alignment with the government's broader effort to reduce the burden of litigation and improve dispute resolution efficiency, the recent directives for efficient and effective litigation management by Government of India promotes institutional arbitration over ad hoc mechanisms for better reliability and predictability. The brief presentation made by my colleague on initiatives taken by Department of Legal Affairs include amendments to the Arbitration and Conciliation Act in 2015, 2019, and 2021, were our landmark efforts to reduce judicial interference, fast-track proceedings, and improve enforcement. In today's India, a nation determined to rise as a global economic power, our dispute resolution mechanism must reflect our aspirations and must match the pace and precision of our commercial ambition. But for arbitration to fulfill its full potential, it must be institutionalized. There is where the India International Arbitration Center steps in. A defining moment came in 2019 with the enactment of the New Delhi India International Arbitration Center Act, now renamed as the India International Arbitration Center Act. With this legislation, IIAC was established as an autonomous institution of national importance, tasked with providing a credible, structured, and internationally benchmarked platform for arbitration. Under Section 4 of the IIAC Act, the IIAC has been declared an institution of national importance. This declaration reflects the Government of India's resolve to make India a serious player in the global arbitration landscape at par with major international arbitration institutions like SIAC, Singapore International Arbitration Center, IIAC, that is International Chamber of Commerce, and LCIA, London Court of International Arbitration. So in furtherance of this vision, the IIAC Conduct of Arbitration Regulations 2023 and IIAC Criteria for Admissions to the Panel of Arbitrators Regulation 2023 offer updated rules, a vetted panel of experienced arbitrators, and streamlined case management. At present, there are 188 arbitrators for domestic arbitration and 86 for international arbitration. These regulations set out a modern efficient and transparent framework for arbitral proceedings, tailored for the commercial realities of today and user-friendly mechanisms aimed at both domestic and international stakeholders. Recognizing the specific needs of MSMEs, the IIAC has also notified dedicated regulations in 2024. These include fast-track process, provision of legal aid, nominal fees, and simplified arbitration mechanisms for micro and small enterprises. That is a crucial move considering the financial vulnerability of these enterprises. But regulations alone cannot build an institution, and no institution can thrive on intent alone. Institutions are built by practice, by use, by trust, and on a track record of performance. While the legal architecture is in place, the active involvement of public sector undertakings is absolutely critical for realizing the full potential of IIAC. As entities that handle large-scale and high-stakes commercial contracts, PSUs are amongst the biggest stakeholders in India's dispute resolution ecosystem. We heard Chairman ONGC, wherein he had pressed on to focus on time instead of timelessness in arbitration matters. It is imperative that their dispute resolution clauses in such contracts designate IIAC as the preferred institution for arbitration. We appeal for that for all the PSUs, not because the law demands it, but because the future demands it. This isn't just about routine disputes differently, it is about building credibility and recognition through institutional practice. Fragmented arbitration cannot serve a global economy. Institutional coherence is the need of the hour. Accordingly, I, on behalf of Department of Legal Affairs, appeal to all the PSUs to consider incorporating or amending their arbitration clauses in ongoing and future contracts to refer disputes to IIAC as the designated arbitral institution for institutional arbitration. Additionally, in cases where the existing contracts refer disputes to the erstwhile International Center for Alternative Dispute Resolution, we urge that those clauses be amended to refer disputes to IIAC as per the regulations framed by the Center. This will harmonize the government's arbitration framework under a unified institutional umbrella. This is not just a procedural adjustment, it is a shift towards professionalism, consistency, and enhanced investor confidence. Therefore, by institutionalizing arbitration through IIAC, PSUs will benefit from structured case management, expert arbitrators, and a neutral institutional framework that upholds the integrity of the process. Let us not forget, more than 63 lakh cases are pending before the high courts in India, and many of them are commercial disputes. So when resolution is delayed, the cost is not only legal, it is economic, reputational, and systemic. Every prolonged dispute is a cost to a public trust, to governance, and to the taxpayer. India cannot afford judicial bottlenecks if we are to achieve our ambition of becoming a 5 trillion economy. A modern economy demands modern dispute resolution, so institutional arbitration anchored in the IIAC is the answer. India's aspiration to emerge as a global economic leader required dispute resolution mechanisms that are credible, swift, and transparent. IIAC is positioned to serve this function very well. Let me reiterate, the world's most respected arbitration institutions did not earn their reputations through legislation. They earned it through consistency, neutrality, and delivery. IIAC must do the same, and with your partnership, it will do it. Arbitration must not be an afterthought. It must be built into the way we contract, the way we plan, and the way we resolve. To move this vision forward, today's conference is envisioned as a platform to disseminate information, clarity procedures, and emphasize the advantages of institutional arbitration. We look forward to an interactive exchange of views, experiences, and challenges faced by PSUs in dispute resolution. Ladies and gentlemen, With your collective will and cooperation, the India International Arbitration Center can truly evolve into a world-class arbitration institution. If India wants to stand shoulder to shoulder with the world's leading economies, we must also offer dispute resolution system that match the world's best. With favorable laws, a strong judiciary, and a dedicated arbitration institution, India is well positioned to make IIAC the next global seat of arbitration and position India in the global market. Let this be the turning point where we take institutional arbitration out of policy paper and into real-world application. If we can align on this today, the long-term impact will be visible not just in better dispute resolution, but in smoother contracts, faster projects, and a stronger economy. Together, let us ensure that India not only keep pace with global standards, but sets them. Thank you for the patient hearing. Thank you all. Jai Hind, Jai Bharat.
Thank you, ma'am, for your encouraging words. And finally, I have the honor to invite Honorable Arjun Ram Meghwal, the Minister of State, Independent Charge, Ministry of Law and Justice. Sir is distinguished former IAS officer from Rajasthan. He has served as a member of Parliament representing the Bikaner constituency since 2009. Renowned for his integrity and simplicity, he is often seen cycling to Parliament, symbolizing his commitment to sustainable living and public accessibility. He has been conferred with the prestigious Sansad Ratna Award 3 times and the Sansad Maharatna for exemplary parliamentary performance. An author of 3 insightful books, he reflects on themes of the governance, Indian traditions and social values, contributing both as a policymaker and a thought leader. We are profoundly appreciative of your esteemed attendance, sir, and now we invite you to share a few words of wisdom. Ladies and gentlemen, please join us in welcoming the Honorable Minister.
क्यों भाई, आपने few words का ही बोला है तो कितना बोलना है? Few words में क्या 5 मिनट 10 मिनट कितना करना नवीन? मैंने थोड़ा इसको लाइट मूड में इसलिए किया कि आप बहुत गंभीर हो गए थे इस कॉन्फ्रेंस में। जगह बहुत सुंदर है और मेरे ख्याल में चिंतन भी बहुत अच्छा होगा। देखिए, सबसे पहले तो मैं जो 11 जून अहमदाबाद में जो प्लेन क्रैश में जो मारे गए हमारे सभी यात्री और पायलट और क्रू मेंबर्स और जो मेडिकल क्षेत्र में काम करने वाले, कुछ पढ़ने वाले डॉक्टर्स और कुछ अन्य लोग जो अब हमारे बीच में नहीं हैं, उनको सबसे पहले श्रद्धांजलि देते हुए मैं मेरी बात को प्रारंभ करता हूं। ये कॉन्फ्रेंस है जिसको आप नेशनल कॉन्फ्रेंस का नाम भी दे सकते हैं और कॉन्फ्रेंस भी इंस्टीट्यूशनल आर्बिट्रेशन एन इफेक्टिव फ्रेमवर्क फॉर डिस्प्यूट रिजोल्यूशंस पर है। जो आपने बैग दिया, वो बैग कितने लोगों ने पढ़ा ये तो पता नहीं है, लेकिन अरुण कुमार सिंह जी ने उसको अच्छी तरह से पढ़ा और उसमें लिखा हुआ क्या है उसको भी नोट किया। तो जो इस तरह से अगर आप हर चीज को ढंग से देखेंगे, परखेंगे और जीवन में उतारेंगे तो मुझे लगता है कि ये कॉन्फ्रेंस सफल होगी। मैं ताली बजा रहा तो बजा दीजिए ताली पे। तो अब आराम से, मैं कोई उद्घाटन के लिए या कोई बहुत गंभीर बात कहने के लिए आपको नहीं आया हूं। जो आपके पास चीजें हैं उनको ही आपको बताने आया हूं, बस इतना ही काम है मेरा। लेकिन मैं सोचता हूं कि इस उद्घाटन सत्र से भी ज्यादा महत्वपूर्ण ये जो 4 टेक्निकल सेशन है, ये महत्वपूर्ण है। इसमें आप संवाद करना, ऐसे बैठे मत रहना। जैसे टेक्निकल सेशन 1, स्ट्रेंथनिंग डिस्प्यूट रिजोल्यूशन इन PSUs, द रोल ऑफ इंस्टीट्यूशनल आर्बिट्रेशन, बड़ा महत्वपूर्ण सब्जेक्ट है, आप सबके लिए काम आता है। दूसरा टेक्निकल सेशन है इंडिया इंटरनेशनल आर्बिट्रेशन सेंटर, कंडक्ट ऑफ आर्बिट्रेशन रेगुलेशन 2023, ये भी बहुत महत्वपूर्ण सब्जेक्ट लिया है। फिर आपका तीसरा टेक्निकल सेशन है बेस्ट प्रैक्टिसेस ड्यूरिंग आर्बिट्रल प्रोसेस, ये डिस्कोर्स, ये भी अभी हम लंदन में थे तो यही इसी तरह का एक सब्जेक्ट था जिसमें हम बैठे थे। और टेक्निकल सेशन 4 जो है, लर्निंग फ्रॉम इंटरनेशनल जुरिस्डिक्शंस, वे एट फॉर द आर्बिट्रेशन इकोसिस्टम इन इंडिया। अब यहाँ एक शब्द आया इकोसिस्टम। ये चारों सेशन आपके बहुत अच्छे, इस पे अगर आप चिंतन मनन मंथन करोगे तो निश्चित रूप से कोई अमृत निकलेगा, और हम अमृत काल में भी बैठे हैं। इसी से ये इकोसिस्टम से ही एक बहुत अच्छा एक कोट है हमारे प्रधानमंत्री जी का, जो आप लोगों ने सुना भी होगा और बहुत हमने कई जगह उसको बोला है। मैं इसको रिपीट करता हूं, दोबारा रीइटरेट करता हूं। ये 23 अक्टूबर 2016 को भारत में आर्बिट्रेशन को मजबूत करने की दिशा में एक राष्ट्रीय पहल हुई थी। उसके समापन भाषण में भारत के माननीय प्रधानमंत्री श्री नरेंद्र मोदी जी ने कहा, अब मैं इसको कोट कर रहा हूं, इसको मैंने मेरी भाषा में लिखा है, कोट, हमें अल्टरनेटिव डिस्प्यूट रिजोल्यूशन के लिए एक वाइब्रेंट इकोसिस्टम, यहां भी एक इकोसिस्टम की बात प्रधानमंत्री जी कर रहे हैं, आप भी एक टेक्निकल सेशन में इकोसिस्टम की बात कर रहे हैं, हेमंत गुप्ता जी अभी इकोसिस्टम की बात कर रहे थे, और इकोसिस्टम जो इनके यहाँ लिखा हुआ फोल्डर में, इसकी बात अरुण जी कर रहे थे। तो इसका मतलब इकोसिस्टम कॉमन है सब में, और प्रधानमंत्री जी भी इकोसिस्टम की बात कर रहे हैं। मैं फिर कोट कर रहा हूं उसको, हमें अल्टरनेट डिस्प्यूट रिजोल्यूशन के लिए एक वाइब्रेंट इकोसिस्टम की सुविधा प्रदान करने की आवश्यकता है, जिसमें आर्बिट्रेशन, मीडिएशन एंड कंसिलिएशन शामिल है। इससे निवेशकों और व्यवसाय करने वालों को अतिरिक्त सुविधा मिलेगी। इससे भी महत्वपूर्ण बात यह है कि इससे भारतीय अदालतों पर केस का बोझ भी कम होगा, अनकोट। तो इसका मतलब केसेस बहुत हैं कोर्ट में, वो भी कम होने चाहिए, ये भी प्रधानमंत्री जी इसमें कह रहे हैं। अब आप देखिए, ये जो वनडे जो कॉन्फ्रेंस है, इसको मैंने जैसे आपको पहले कहा कि एक बार हम प्रधानमंत्री जी के पास बैठे थे, तो मुझे वैसे बैठे हुए देखते तो हो, कई बार आप चलते हुए भी देखते हो ना, ये तो पक्का ही है ना, का इसमें भी कोई डाउट है? आप इसको तो मान लिया करो भाई, मान लिया ना। तो वो बोल रहे थे कि एक फाइल हमारे पास ऐसी आई जिसमें 2 PSU आपस में लड़ रहे थे, कोई अवार्ड था, कॉन्ट्रैक्ट था, पता नहीं क्या था। एक के लीगल ऑफिसर ने लिख दिया कि नहीं नहीं ये हमें मिलना चाहिए, दूसरे PSU के लीगल ऑफिसर, आप सब लीगल ऑफिसर ही हो ना, उसने लिख दिया कि वही है ना कि हमें ये मिलना चाहिए, और दोनों ही भारत सरकार के, और दोनों हाई कोर्ट से लड़ते लड़ते सुप्रीम कोर्ट में पहुंच गए, और दोनों की अपील की परमिशन की फाइल एक साथ ही आ गई साहब के पास। तो उन्होंने देखा ये दोनों क्यों लड़ रहे हैं। अब इसमें एक PSU समझ रहा होगा मुझे घाटा हो जाएगा, दूसरा PSU ये समझ रहा होगा मुझे घाटा हो जाएगा, लेकिन देश को घाटा हो रहा है ये कोई नहीं समझ रहा है। ये भी तो समझना पड़ेगा ना भाई, कि देश का नुकसान कर रहे हो ना आप, और कितना पैसा हाईकोर्ट के वकील के फीस को, सुप्रीम कोर्ट के वकील के फीस को। तो इसका अल्टरनेट जो डिस्पोजल मैकेनिज्म है, इस पे प्रधानमंत्री जी ने बहुत जोर दिया, और आते ही जोर दिया। आपको जानकारी होगी कि आर्बिट्रेशन एंड कंसिलिएशन एक्ट 1996 का है। उसके बाद अगर चेंज किसी ने किया है, मुझे लगता है कि आपने उसमें बताया कि नहीं बताया, एक ऑर्डिनेंस आया था, प्रधानमंत्री जी 2014 में PM बने, 11 साल हो गए, और 11 साल का आर्बिट्रेशन का लेखा जोखा आपने इसमें पेश किया था। तो इसमें एक ऑर्डिनेंस भी आया था, 2014 में आ गया था, 15 में आया है, 15 में आया। तो शुरू में इसका मतलब 14 में बनते ही समझ में आ गया कि भी हमें कुछ करना है, ऑर्डिनेंस आया, फिर एक्ट आया। अब ये 96 से अगर किसी ने सोचा इसके बारे में कि भी हमें अमेंडमेंट करना चाहिए, ये टाइम बहुत लेते हैं, ये इतना समय नहीं लगना चाहिए, तो ये 2015 में अमेंडमेंट किया इसमें, आर्बिट्रेशन एक्ट में, फिर 2019 में किया, फिर 2021 में किया, एक अभी अंडर कंसिडरेशन और है। तो आप अगर इस कॉन्फ्रेंस के माध्यम से चिंतन मनन मंथन करके कुछ सुझाव देंगे तो इस दिशा में हम काम करेंगे। भाई भारत को आगे बढ़ाने का ही काम है हम सबका। मैं गवर्नमेंट में काम कर रहा हूंगा, मैं किसी स्थान से मेंबर ऑफ पार्लियामेंट हूंगा, मैं भारत सरकार में मंत्री हूंगा, ये सुप्रीम कोर्ट में जज रहे हेमंत गुप्ता जी, अभी IIAC के चेयरपर्सन हैं, आप अरुण कुमार सिंह जी ONGC के चेयरपर्सन हैं, आप हमारे अंजू राठी राणा जो मैडम बैठी है लीगल ये अफेयर्स में सेक्रेटरी है, हमारे DP के सेक्रेटरी साहब बैठे हैं। इनका सबका क्या काम है? देश को आगे बढ़ाना ही है। आप भी उसमें सम्मिलित हो जाओ, यही कॉन्फ्रेंस है और कुछ नहीं है। इसमें जो अरुण जी ने कहा मैं उसी को आगे बढ़ाता हूं कि टाइम इज मनी। क्या हम इसमें उसको भूल गए क्या कि टाइम मनी नहीं है, या ध्यान नहीं है, या हमारे ध्यान में आ गया कि भाई L1 को ही मिलना चाहिए, ये गलत है तो भी इसी को दो। मैंने कईयों को पूछा भी आपने इसको ऐसा लिखते समय, क्योंकि मैंने भी हैवी इंडस्ट्री में काम किया है, सब आपके मंत्रालय में काम किया है, तो एक केस मेरे पास भी ऐसा आया था बैल का। मैंने कहा क्यों भाई आपने, जब L1 काम करने की क्षमता नहीं थी, ये पता था कि साहब L1 हम नहीं लिखते तो GF&R आगे आ जाता है। GF&R कोई चीज है क्या शायद मेरे ख्याल, हाँ GFR अपृष्टि जी है ना कोई, कहिए आगे आ जाता। तो मैंने कहा आप तरीके से लिखते, उसका भी कार्ड ढूंढनी चाहिए थी आपको। कह नहीं साहब कोई RTI वाला आ जाता। तो भाई ऐसे डर के काम करोगे तब तो कैसे काम होगा? आप अपना, अच्छा वो खुद जान रहे थे कि ये गलत है, लेकिन फिर भी वो डर रहे थे। तो ऐसे ये डर तो निकालना पड़ेगा। हम देश हित में काम कर रहे हैं, ऐसा क्या हो जाएगा जी? अगर कोर्ट में भी जाएंगे तो हम हमारी बात कहेंगे कि मैंने तो मेरे इस ढंग से ऑर्गेनाइजेशन का भला करने के लिए काम किया था। लेकिन सही बात तो लिखनी पड़ेगी ना। हम सही बात नहीं लिख करके जो लकीर है खींची हुई उसी के साथ 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 चलते हैं, सही गलत जा रहे हैं हम। हमें पता है गड्ढे में जाएंगे हम, लेकिन हम उससे निकलते ही नहीं है। इसलिए अरुण जी ने ये अपनी जो दुख प्रकट किया वो इस कारण से किया। और ऐसे ऑर्गेनाइजेशन को फिर नुकसान होता है, फिर कहते हैं ये घाटे में कैसे आ गए। ये जो टाइम इज मनी, ये तो हमें वैसे भी ध्यान रखना चाहिए कि हमें अगर समय पे काम पूरा नहीं हुआ, हमारे किसी नोट से नुकसान हुआ, बोल हम तो बच गए, कोर्ट में जाओ तो जाओ, ये कोई तो तरीका नहीं है ना। इसीलिए ये मंथन करने के लिए मैंने सेक्रेटरी साहब को कहा, मैं क्या आप शुरू करो मंथन करना, जो होगा देखेंगे, एक बार चर्चा करेंगे, मंथन से कुछ अमृत निकलेगा तो निश्चित रूप से आगे बढ़ेंगे। अभी आप देखिए, आप मेरे ख्याल में अपना ब्यौरा दे रहे थे हमारे के मोसेस चलाई साहब, मेरे ख्याल में कितना आप कंट्रीब्यूशन बता रहे थे जी? बहुत ज्यादा आप तो बता, तो वर्किंग कितना बता रहे थे? 272 ही बता रहे थे शायद वर्किंग। तो क्यों? लेकिन आप ब्यौरा तो बहुत अच्छा दे रहे थे कि जो नेशनल इकोनॉमी है हमारी, इसको आप आगे बढ़ाने में महत्वपूर्ण काम कर सकते हो। ये हम 11th पोजीशन से जंप करके 4th पोजीशन पे आगे इकोनॉमी में, 3rd में हमें पहुंचना है। तो इसमें हमारे पब्लिक सेक्टर अंडरटेकिंग और ये हमारे दूसरे ऑर्गेनाइजेशन ये बहुत बड़ा रोल अदा कर सकते हैं। आज की कॉन्फ्रेंस का यही पर्पज मैं समझता हूं। अभी अरुण सिंह जी ने कहा कि कभी कभी हम बहुत रिजिड हो जाते हैं, हमें फ्लेक्सिबल रहने की जरूरत है। कभी कभी हम बहुत फ्लेक्सिबल हो जाते हैं तो हमें रिजिड रहने की जरूरत है। तो इसको हम संविधान से सीख सकते हैं अरुण जी कि हमारा सबसे बड़ा कानून क्या? संविधान। तो संविधान कभी कभी फ्लेक्सिबल है और कभी कभी रिजिड है, दोनों हैं। तो हम ऑर्गेनाइजेशन में किसी में भी काम करें, हम देश काल परिस्थिति के अनुसार जब हमें लगता है कि हमें देश को आगे बढ़ाना है, देश की तरक्की के रास्ते पर हमें चलाना है देश को, तो कभी कभी हमें रिजिड होना पड़ेगा तो रिजिड होंगे, कभी कभी हमें फ्लेक्सिबल होना होगा तो हम होंगे। इंटेंशन उसमें महत्वपूर्ण है। अगर किसी के कारण वो गलत इंटेंशन से फ्लेक्सिबल और रिजिड होते हैं तो गड़बड़ है। वो इंटेंशन कैसे कौन जज करे? वो आप जैसे आदमी जज करेंगे ना, क्या इस आदमी का इंटेंशन ये था लिखते समय। अगर आपने इंटेंशन को ढंग से, आपका सबका इंटेंशन ठीक रहा और कुछ गलत भी लिख दिया तो कोई फर्क नहीं पड़ता है जी। मैं तो आपकी जैसी सर्विसेज करके ही आया हूं यहां, मेरे खिलाफ भी बहुत सी चीजें आई होगी, लेकिन यहां बैठ गए ना यहां आकर के, इसलिए आप भी अच्छा करोगे तो निश्चित रूप से अच्छी चीजें आगे बढ़ेगी। अब आर्बिट्रेशन के बारे में जब बात करते हैं तो ऐसा लगता है कि हम क्या बात कर रहे हैं। आर्बिट्रेशन तो हमारे सिस्टम का पार्ट है। हमारे प्रेमचंद जी एक प्रसिद्ध कहानी लिखते हैं, उसका नाम पता है किसी को क्या है? पंच परमेश्वर। आपको पता है ध्रुव जी? हाँ, देखिए इनको पता है, आपको भी पंच परमेश्वर। अब उनकी वो बाकी कहानियां भी फेमस हुई होगी, लेकिन पंच परमेश्वर बहुत फेमस हुई कि पंचों ने जो निर्णय किया वो परमेश्वर के अनुसार हुआ, इसलिए हम उसको मानेंगे। लेकिन यहां पता नहीं कोई आर्बिट्रेशन का, कोई कह रहा है कि आर्बिट्रेशन का ये टाइम बहुत ले लिया, समय बहुत ले लिया, निर्णय ठीक नहीं, ऐसा आता रहता है। लेकिन हमारे यहाँ आर्बिट्रेशन या जो ये मध्यस्थता, ये हमारी प्राचीन संस्कृति का हिस्सा है। कहीं बीच में हम डिस्टर्ब हो गए होंगे, लेकिन हम अब तो आगे बढ़ना पड़ेगा। अभी हम लंदन में थे, अभी थोड़ी बात बताऊंगा, आप अंजू जी भी हमारे साथ ही थे, और फिर कौरव और पांडवों का झगड़ा हुआ तो हमारे मीडिएटर कौन बने? भगवान लॉर्ड कृष्ण बने मीडिएटर। वो ही वॉज द फर्स्ट मीडिएटर। वो मध्यस्थता करने ही गए थे, माने नहीं, वो अलग बात है। तो अगर कोई मध्यस्थता ढंग से कर रही है और कोई मान नहीं रहा है, उसका काम भी हमारा कि क्यों नहीं मान रहे हो आप, आपको मानना चाहिए। और उसके बाद हमारे इस सिस्टम में जो हमारे पूर्व न्यायाधीश थे, न्यायमूर्ति BN कृष्णा, उनकी अध्यक्षता में कमेटी बनी। उन्होंने जो सुझाव दिए उसके अनुसार हमने आगे काम किया। उसमें न्यायमूर्ति RV रविंद्रन भी थे, अटॉर्नी जनरल के वेणुगोपाल भी थे, वरिष्ठ अधिवक्ता इंदु मल्होत्रा भी थे। ये सब लोगों ने सुझाव दिया, उसके बाद ही हम अमेंडमेंट लेके आए। तो अगर आप कुछ आज इस कॉन्फ्रेंस के माध्यम से सुझाव देंगे तो निश्चित रूप से हम इसमें आगे काम करेंगे। मैं ये कहना चाह रहा हूं, देखिए एक बार थोड़ा मैं डिफरेंट ले जा रहा हूं आपको। आर्बिट्रेशन हमारे सिस्टम का ही पार्ट है। आप भी जानते हो कि आर्बिट्रेशन अच्छी चीज है, इंस्टीट्यूशनल आर्बिट्रेशन भी अच्छी चीज है, ये भी जानते हो। अभी हमारे हेमंत गुप्ता जी, न्यायमूर्ति हेमंत गुप्ता जी काफी समय से संघर्ष कर रहे हैं। आज की कॉन्फ्रेंस के बाद शायद मुझे लगता है कि आपके इनमें भी कॉन्फिडेंस आएगा, आपके में भी कॉन्फिडेंस आएगा कि इंस्टीट्यूशनल आर्बिट्रेशन ठीक है। लेकिन ये इंस्टीट्यूशनल आर्बिट्रेशन की हमारे अंदर एक भावना है, लेकिन ये जागती नहीं है। तो एक बार कबीरदास जी ने अपने शिष्यों को पूछा कि भगवान नाम की चीज है क्या? पूछने वाला आदमी बैड इंटेंशन से पूछ रहा था, क्योंकि कबीरदास जी पाखंड विरोध की बात करते थे। लेकिन यहां कबीरदास जी एकदम जो मनुष्य के अंदर क्या है वो कर रहे हैं। ऐसे ही आर्बिट्रेशन आपके अंदर है, लेकिन आपको दिखता नहीं है। तो कबीरदास जी ने कई बार तो बोला नहीं, 2-3 दिन ऐसे निकल गए। रोज वो सत्संग करते थे, फिर आए, बोला साहब वो आपने बताया नहीं, भगवान नाम की कोई चीज है क्या और कैसे पता चलेगा? तो कबीरदास जी कोई भी चीज कहते थे, जवाब देते थे, या दोहों से कहते थे या अपने भजन से कहते थे। और उन्होंने लिखा, लोगों नहीं है, उन्होंने कुछ नहीं लिखा। तो उन्होंने कहा, सुनो भाई, क्या कि ज्यों तिल मा ही तेल है। तिल के अंदर तेल होता है ना, दिखता है? बोला दिखता तो नहीं है, पर अंदर होता है। कि ज्यों तिल मा ही तेल है, ज्यों चकमक में आग। चकमक होती है, पत्थर होता है, उसमें ऐसे भिड़ाओ तो आग निकलती, दिखता है? बोला नहीं दिखता। ज्यों तिल मा ही तेल है, ज्यों चकमक में आग, तेरा शाही तुझ में बसे, दुनिया देखत ना है। अरे भाई, हम लंदन में जाकर के आर्बिट्रेशन देख रहे हैं, हम सिंगापुर में जाकर के आर्बिट्रेशन देख रहे हैं, हम हांगकांग में जाकर के आर्बिट्रेशन देख रहे हैं, हम दुबई में जाकर के आर्बिट्रेशन देख रहे हैं। भारत में क्यों नहीं देख रहे हैं भाई? क्यों नहीं देख रहे हैं? ये कॉन्फ्रेंस का यही पर्पज है कि हम आर्बिट्रेशन का हब क्यों नहीं बन सकते। हमारे अंदर ही है, हमारे सिस्टम के अंदर है, भारतीय कल्चर के अंदर आर्बिट्रेशन है। जितने हमारे संस्कार होते हैं उनके अंदर आर्बिट्रेशन है। कोई न कोई हमारा मध्यस्थ करने वाला, आर्बिट्रेशन करने वाला आदमी रहता है। कॉन्ट्रैक्ट में भी सिस्टम में डाला हुआ है, लेकिन फिर भी हम पीछे हैं और वो आगे हो गए। जिनके सिस्टम में आर्बिट्रेशन नहीं था वो आगे हो गए। इसलिए हमें आज की कॉन्फ्रेंस के माध्यम से, मैं लंबी बात नहीं कहूंगा, मैं फिर कहूंगा कि टेक्निकल सेशन बहुत महत्वपूर्ण है। फिर मुझे एक दुष्यंत कुमार की 4 लाइनें याद आ गई है। आपका इच्छा हो तो मैं कह दूं क्या है? दुष्यंत कुमार को सुना है किसी ने? है? सुना तो है ना, या नहीं सुना? अरुण जी ने सुना, मुझे लगता है ये कह रहे हैं सुना, खूब सुना। दुष्यंत कुमार एक बार अपने गांव की एक नदी के पास बैठ गए थे जिसमें पानी कम था, लेकिन हवा बहुत अच्छी आ रही थी। तो एक आदमी गया कि दुष्यंत कुमार जी आप कहां बैठ गए, इसमें तो पानी कम है। तो उन्होंने कहा मेरी गांव की है इसलिए मुझे अच्छा लगता है, मैं यहीं बैठूंगा। फिर भी वो आदमी माना नहीं। फिर उसने जिद की कि नहीं, ये पास में एक नदी है जिसमें अच्छा पानी आया हुआ है, वहां बैठेंगे तो आपको अच्छा लगेगा। उन्होंने कहा नहीं, मेरे ये गांव की है नदी, मेरे को लगाव है, इसलिए मैं यहीं बैठूंगा। फिर भी नहीं माना तो दुष्यंत कुमार जी ने 4 लाइनों से उसको जवाब दिया। इस नदी की धार में ठंडी हवा आती तो है, नाव जर्जरी से ही लहरों से टकराती तो है। ठीक है, मेरे नदी है, इसमें पानी कम है, मेरी नाव भी जर्जर है, लेकिन लहरों से तो टकरा रही है, मुझे अच्छा लग रहा है, मेरा गांव है। इस नदी की धार से ठंडी हवा आती तो है, नाव जर्जरी से ही लहरों से टकराती तो है। एक चिंगारी कहीं से ढूंढ लाओ दोस्तों, इस दिए में तेल से भीगी हुई बाती तो है। अगर आर्बिट्रेशन की ये बाती जो जगा रहे हैं हेमंत गुप्ता जी, आपको लगता है कि ये दिए में तेल में बाती तो है, तेल कम है तो तेल आपको डालना है, तेल आपको डालना है, बाती जगेगी, प्रकाश होगा, भारत आर्बिट्रेशन का हब बनेगा। बहुत बहुत धन्यवाद।
Thank you, sir. Thank you, sir, for your inspiring words and gracing us with your august presence. Ladies and gentlemen, we'll have a short tea break. Tea is being served at level 1, that is 1 floor below. We'll reconvene here at 12 sharp for the first technical session. And we humbly request everyone to please adhere to the time schedule. Thank you, sir. Thank you once again.
Session 1, please. Please, requested to take your seats.
Yes.
Should we start? Where? Vanessa, start. Good morning, everyone. I'm taking the liberty of calling the House to order so that we can get started.
Thank you, ma'am. Ladies and gentlemen, I am Akanksha Tripathi, Counsel, India International Arbitration Center, welcoming you on behalf of Department of Legal Affairs, Ministry of Law and Justice, ONGC, and IIAC. As we progress, let us commence our first session of the conference, which focuses on strengthening dispute resolution in PSUs, the role of institutional arbitration. I am delighted to welcome the moderator for the session, Ms. Manani Brar, who is an advocate and solicitor at England and Wales. We are also honored to have a distinguished panel with us today for the technical session. One, Mr. Ajay Kumar Arora, Joint Secretary, Arbitration, Department of Legal Affairs. Mr. Ajit Kumar Mishra, Director, IRCON International Limited. Mr. Sanjeev Gemawat, Managing Director and Group Counsel, SR Group. Mr. Naveen Kumar Singh, Chief Executive Officer, IIAC. Ms. Kadambari Singh, Senior Advocate and Independent Arbitrator. With that, I now invite Ms. Brar to kindly take over and lead us into the panel discussion. Over to you, ma'am. Thank you.
Thank you. Thank you so much for that introduction, and good morning to everybody, all the officers and representatives of various ministries, public sector undertakings, leading practitioners in the field of dispute resolution, and the organizers, with a special hat tip to the young force that has been running around on a Saturday morning trying to get the best organization underway for this conference. Welcome to the first technical session of the day on the topic Strengthening Dispute Resolution in PSUs, the Role of Institutional Arbitration. It is a wide-ranging topic with many interesting sub-issues, and we have the benefit of a wide-ranging wealth of experience on the dais to discuss it. From the government, we have Ajay sir. From the courts, we have Kadambari ma'am. On the corporate side, we have Sanjeev sir and Ajit sir, and of course the remarkable institution that has brought us all here together, Naveen sir. One must commend the excellent organizing that has put in place this panel on behalf of ONGC and IIAC and the Ministry of Law. Because if you were to think of this topic and think of the right people to answer questions around it, you would probably think of the very people on this panel. So you are all familiar, I'm sure, that there have been questions around the benefits of arbitration, especially when government entities are involved. But one thing that is clear and has been clear from the beginning is that institutional arbitration is an exception to that questioning and uncertainty. And the reason for that is that with the proper institutional intervention in the administration of a dispute, you can have a well-conducted arbitration, which is timely, which is cost-effective, and at the end of the day, you can have an award which is enforceable in any court. So that is perhaps a very good starting point for this discussion, which is to get the views of this panel on how you think institutional arbitration will help in strengthening dispute resolution in PSUs. Ajay sir, I'd like to give the floor to you and invite you to say a few words.
Thank you, Manani. First of all, very good afternoon. Right now, Manani said the representative of the government. I would like to share that I had been, throughout my service career, I have been part of the CPSUs as you are, I'm one of you only. And I'm thankful to the government that the government has, made me Joint Secretary Arbitration, first ever appointment as a representative of the CPSU as well as the nominee of the government. So I am representing both right now. So far the arbitration is concerned, are ad hoc and institutional. I had been in PSUs for the past 24 years into litigation, typical litigation part. So the CPSU representative, I can very well understand their point of view, their pain, their problem, their issues. So for me, ad hoc arbitration, of course, had been a very, 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 failure, you can say. No, I won't say exactly failure, but of course, it burdened a loss to the public sectors, particularly the CPSUs and the government as a whole. Therefore, this idea of institutional arbitration has come up. So during my period, most of the cases I have dealt on ad hoc arbitration basis. So my experience is, during all this period, I think there are few cases I still remember which took approximately 20 years to just take its feet. Just imagine, 20 years, even after coming into enforcement of the amendments, because the contractors declined to opt for the new environment, new enactment, new provisions. They better suited them. I won't say that I'm not against the arbitrators, but as a stakeholders, we have to strike balance between all. So just imagine, once you go for institutional arbitration, at least you have in advance knowledge of the fee structure of the institution, the working atmosphere, working environment, structure of the institution, and how they will dispose the matters and in what manner. And you know very well the team of the institutions that usually remains available on the website itself, that who are the enrolled arbitrators and paneled arbitrators they may appoint. Another thing which I have seen, that once the CPSU opts for the ad hoc arbitration, again, the judicial people, the people from the legal background, they take front seats during arbitral tribunals. That is another problem. CPSUs can better judge that their contacts they have some expertise, they need the people from the expert side, from the technical side, but unfortunately, in most of the ad hoc arbitrations, although in certain cases they are appointed as arbitrator among us the three, but of course they hardly, not able to speak much, not able to deliver much in front of the, high stature judicial people. So institutional arbitration is another way where we can at least make arrangement in such a manner that balance be maintained among these, where we can opt for the experts, the technical experts, because the infrastructure like civil industry to which I belong, I had been there in NHPC for more than 24 years. So particularly encountering the geographical, site conditions. So what happens? You don't know what will happen. Initially, the DPR is conducted, but the DPR, again, it's a nature. You don't know what would happen in future. We have a classification of rocks, class A, B, C, D. We don't know. Ultimately, when the excavation work will be done, again, the delay is there. No, basically, there are two things, although I know that I am here to speak on the institutional arbitration, but I would certainly suggest you people that first of all, we must avoid disputes. Why disputes? In public sectors. But in case we have no option but to resort for the disputes, then of course institutional arbitration is the only option right now. My 24 experience in ad hoc arbitration is very, very, very painful. I know how the awards are made in the arbitral tribunals. I know how the things are pleaded before the arbitrations, because I was also one of the stakeholders like you. As a law officer, there are a lot of law officers representing CPSUs are here. Lot of directors and other managing directors of the CPSUs are here. So my request to you would be, of course, now whenever you talk about CPSU, says arbitration क्या करना है, लेकिन मेरी आप सबसे एक प्रार्थना है कि अगर आर्बिट्रेशन के अलावा कोई रास्ता नहीं है तो हमें एक चीज़ अपने मन में रखनी पड़ेगी, अपने दिमाग में रखनी पड़ेगी कि तब हमें इंस्टीट्यूशनल आर्बिट्रेशन का कोई ऑप्शन नहीं है। सीपीएसयू के लिए सेफ भी है। दूसरा, आईआईसी एक स्टैट्यूटरी बॉडी है, आईआईसी एक एक्ट से एस्टेब्लिश की गई बॉडी है, तो एज ए सीपीएसयू रिप्रेजेंटेटिव्स अगर आप आईआईसी को ऑप्ट करते हैं तो यू आर सेफ। आपके पास आईआईसी की अकाउंटेबिलिटी भी है। आईआईसी क्योंकि स्टैट्यूटरी बॉडी है तो ऑफकोर्स इज ए गवर्नमेंट बॉडी, तो आपकी इसकी अकाउंटेबिलिटी भी है। इसके जो आर्बिट्रेटर्स होंगे, अगर वो आपको लगता है कि कोई आर्बिट्रेटर ठीक से काम नहीं कर रहा या फेवर कर रहा है या इम्पार्शल नहीं है, ठीक है, और ट्रिब्यूनल जब तक है इट्स ऑलराइट, बट वंस द ट्रिब्यूनल मैंडेट इज ओवर, ऑलवेज इन फ्यूचर केसेस, इन फ्यूचर रेफरेंसेस आप इस इशू को टेकअप कर सकते हैं और अकाउंटेबिलिटी हमेशा आर्बिट्रेटर रहेगी इंस्टीट्यूशन को। तो आज मैं 24 साल के अनुभव से आपको ये ज़रूर बता सकता हूँ कि मेरे आपको एडवाइस है कि इंस्टीट्यूशनल आर्बिट्रेशन सर्वोपरि है। आपके एडहॉक आर्बिट्रेशन में आपको मालूम नहीं है, आप अपना आर्बिट्रेटर कैसे अपॉइंट करते हैं आप सबको मालूम है, मुझे बताने की ज़रूरत नहीं है। कॉन्ट्रैक्टर कैसे करता है ये भी आपको मालूम है, और प्रिजाइडिंग कैसे होता है मैं बोलना नहीं चाहता। तो इसलिए पर्टिकुलरली इंस्टीट्यूशनल आर्बिट्रेशन एक रास्ता है जो हम सबको इन सब प्रॉब्लम से निजात दिला सकता है। तो मैं आपसे रिक्वेस्ट करूंगा कि एडहॉक आर्बिट्रेशन के ऊपर हमेशा हमेशा आज की डेट में मेरे 24 साल का अनुभव यही बताता है कि इंस्टीट्यूशनल आर्बिट्रेशन बहुत 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 बेटर है। टाइम फ्रेम आपको देती है, एक्सपेडिशियस डिस्पोजल आपको देती है। फीस की जो प्रॉब्लम यूजुअली सीपीएसयू फेस करते हैं, उस फीस के पहले दिन से हमें मालूम है कि इनकी फ़ीस कितनी होगी। तो इसके साथ ही थैंक यू माननीय, और मुझे कुछ नहीं कहना।
Thank you, sir, and thank you for giving us a broad overview and really touching on the key points, which is expertise, timeliness, and something that is unique to the IIAC because it is a body that has been initiated by the government, accountability. I'd like to invite Ajit sir now to add to this discussion.
Very good afternoon. Obviously, the topic is very sensitive and lot has been said by Honorable Minister and also Chairman of one of the leading public sector, ONGC. I have had the experience of working with government, that is Ministry of Railways, which is dealing with large number of cases, and also had the opportunity to work with 2 Schedule A CPSEs. And based on my experience in working with these 3 distinct organizations, the question I pose to myself when I have to decide on the this issue is, do I have a choice of going for ad hoc arbitration or institutional arbitration? And my fellow panelists will further elaborate on this, but I'll first answer the question and then I'll try to little bit deliberate on this. My simple answer is, one must avoid ad hoc arbitration in all perspective. And why institutional arbitration is better, this is the moot point. Again, it will be discussed by other panelists, but I'll give you few examples how ad hoc arbitration can give you troubles. In CPSEs, particularly in the public sector or even in the government cases, the arbitration or disputes are the one thing which is very sidelined. There are project officers who deals with the project, and then they also have the responsibility to deal with the disputes also. And obviously the project delivery is their first responsibility. Their entire focus is on that. And somehow the officers have in their mind is that if they insist or if they deliberate too much on the dispute, probably the other party will get annoyed they will stop working, and it will affect their project delivery. So they try to push it aside. Another thing is that it requires decision making. If there is a dispute, you as a project coordinator or officer, you have to take a decision. And if you are taking a decision, probably you have to own the responsibility also. And again, in bureaucratic setup, probably it is more onerous on one to take the decision and less if you are not taking decision. I don't think any CVC or any this 3Cs cases on officers who have not taken decision. All cases are on the when an officer has taken a decision. So this is very deeply rooted in our mind that if you defer the decision of dispute resolution, particularly in this context, probably we will be safe. And unfortunately, that officer may be safe, but that is very detrimental to the organization's project delivery and financial interest. Because dispute delayed that means not only the amount of dispute is enlarged, rather the interest component and all other things will also be piled up. When different institutions are pitching for adopting institutional arbitration in the contracts, it has to be started right from at the drafting stage. And I had my personal experience that whenever you are approaching to the management or the one who is approving the contract documents that let's adopt the institutional arbitration rather than going for the ad hoc arbitration, one of the apprehensions, and it is not only particular to my organization where I have been working, it is across the other PSUs, that the management thinks that as if their power to pick and choose the decisions of selecting arbitrators and other processes of arbitrations are being taken over by the arbitral institutions. And believe me, no management would like to surrender his power. But it is the responsibility of the law officers to explain their management is that, look, even if there is institutional arbitration, your liberty to take decisions are no way compromised. If your management thinks that he has the power to choose an arbitrator, that is available even with an institutional arbitration. So you have to convince your management. And if you are having an institutional arbitration, it is like something like you are having a monitor who is guiding your entire dispute resolution process, especially through the, especially that of arbitration, where at every stage, someone from institution will prompt you what is your next stage, what you have to do and what you have not to do. In ad hoc arbitration, why Section 11 are so prevalent is because there is no one who is taking care of arbitral appointments process. If contractor or one party has given the request for arbitration, the department is completely unaware that they have only 30 days time to respond with their nominee arbitrator. It is lying for years, and then Section 11 application comes. If had it been an institutional arbitration, the institution would remind you that, look, you have this much time, and if not, there is a default rules where institution will pick up the arbitration. So you have been saved of this court hassle or litigation process right at the selection or appointment of arbitrator itself. So there are many advantages one must, this institutional arbitration poses, and I have been beneficiary to this. Even after 3rd June 2014 memorandum, we have consciously taken decisions to incorporate institutional arbitration. We have not panicked by that OM, and we have not eliminated the arbitration clause from our contracts. We are very well continuing with this. We have shifted our focus, yes, towards institutional arbitration, and then we have shifted our focus to mediation and conciliation. I mean, I'll take both, use both the words, but predominantly it's conciliation. Over to you. I mean, I think with the paucity of time, I'll stop here.
Not at all, sir. That was a very great summary given the amount of time that we have. You spoke about the sidelining of arbitration, both at the time of signing the contract and during the execution of the project. But my limited experience on this is that this is both in the PSUs and otherwise on the corporate side also. We are constantly confronted with clients who have really not thought about the arbitration clause until the dispute is at their door. Sanjeev sir, would you like to come in on that and generally on the benefits of institutional arbitration to any corporate?
Good afternoon. I think first let me thank Ministry and the IIAC for inviting me to share my views. First, let me also, appreciate the candid views of Ajay ji and my friend also, Ajit. The way in which I look at this is that out of that $4 trillion economy what we have, the contribution of the public sector enterprises is nearly between, say, 15 to 20% of the GDP. And the 15 to 20% of the GDP is a huge number. Just link this with what our vision is, the India at 2047, and we are talking about $30 trillion economy. And if I assume that this number would continue at 15 to 20% of contribution by the public sector enterprises, and which I include nearly over 250 central public sector enterprises or over 1,000 state public sector enterprises. This number is huge as far as the economy is concerned. Now, this number and this growth is dependent on two large factors, two broad factors. One is the technology and innovation, and the other is the capital. Now, for both these things, internal resources are not sufficient. We will have to necessarily depend on the outside, support, which is, the foreign companies and foreign sectors. Now, it needs to be understood in this scenario that with this 15 to 20% of the contribution in GDP, there would be lots of cross-border transactions which are happening today also. So when we talk about the public sector enterprises, which all are the counterparties? The counterparties are the domestic private sector players and the foreign players, the support services, and so on. And even the, some of the other governments of other nations also, those are also the counterparties. Obviously, we need a better infrastructure in terms of resolution of disputes. And we deserve a better infrastructure, certainly, because we have experienced that litigation has been an inefficient and ineffective system as far as the business world is concerned or business-related disputes are concerned. Now, last nearly 3 decades, we have experienced the Arbitration Act. And if I just see what is the arbitration infrastructure or the dispute resolution infrastructure, one is the legislative framework. I think we are up to date in terms of the Arbitration Act, and which is basically an unsettled model. We are also fine in terms of the New York Convention, because the kind of contracts we enter into those countries, and also with which we enter into the contract. So legislative framework is in place. When I talk about the ADR infrastructure or the arbitration infrastructure, this is largely comprising of 4 facets. One is bench, another is bar, third is the institutional arbitration infrastructure, and the physical infrastructure. Now, on these 4 items, we are certainly lacking. Ajit did mention about 3rd June 2024 office memorandum. The way in which I see this, that is one of the best pieces of introspection by the government, that where we are heading with this ad hoc arbitration. Now, business world needs resolution of disputes, because just appreciate this, that we can't keep the disputes ongoing where so much of investment is at stake. You need speedy resolution, timely resolution, cost-effective resolution, and above all, there should be some certainty as far as award is concerned, and that award should be enforceable. Now, the experience suggests, and OM is the best piece of introspection, that the things are not good. Ad hoc arbitration has not met these 4 basic parameters, which is time, cost, certainty, and enforceability. So what is the next solution? The globally institutional framework has been the best solution for this. And I think that is how I'm looking at it. In fact, I would say, just to, because of time constant, just to conclude this. In fact, I have suggested the ministry also that let us phase out the ad hoc arbitration. If it can't happen overnight, perhaps 3 years, 5 years, 7 years down the line, we need to phase out ad hoc arbitration, because institutional arbitration is the only solution, the kind of growth which we are looking at, in the next 2 decades or 3 decades. So this is how I would like to summarize. Thank you.
Thank you for that. And actually, that is really the broad brushstroke point of why we are all here, which is that foreign investors and the world globally is very on the road with accepting institutional arbitration as a way of dispute resolution in commercial contracts. And we absolutely have to get onto that bandwagon because even when foreign investors are assessing risk in terms of their investment, they are assessing what kind of dispute resolution options they have. So in that context, having an institution which is reliable to resolve big public sector disputes is absolutely indispensable. Kadambari ma'am, would you like to come in with your extensive dispute resolution experience of how you see the two, institutional versus private and ad hoc, and what your thoughts are?
Yeah, thank you, Manini. At the outset, I'd like to congratulate IIAC for putting up such a grand conference, and which is very befitting for a statutory body. And I sincerely hope that it takes off in that big way from now on. Now that in the recent memorandum also, the government has very clearly indicated that if at all you have to look at arbitration in cases beyond 10 crores, then you have to look at institutional arbitration, and that too by having a very, very due care about what costs are involved. I think that is the memorandum of 2024, which indicates that you have to be cognizant of both cost as well as the fact that it should be an institutional arbitration. So there is a concept in science which is about metaverse, having parallel systems which are unseen, which are existing, which are, which exist along with the reality that we see. So when we talk about an institutional arbitration, and specifically the way the case management team, the way their entire secretariat functions alongside with the proceedings, multiple arbitration proceedings that are happening, it is like that parallel unseen world which provides the backbone to an arbitral system. So let me share with you, since you asked about my personal experiences. Let me cite about one particular arbitration case which I was handling when I was a young lawyer. The quantum of the case was only 50 lakhs. So when I was handed over this case, it was already, it was at the evidence stage. I realized that the arbitrator had already been paid a fee of 28 lakhs divided between the parties. It was 14 years old, and we were still at evidence. So this is one of the instances where, ad hoc arbitration, where it can lead to totally unstructured, unguided. Then there was a very recent arbitration case that I was engaged in. Again, in that case, it was a court-appointed arbitrator. There also, out of 28 odd hearings or more, there were only 10 orders. For the rest of the hearings, we did not know what went by. And in fact, the arbitrator was asking the parties that could you please help me restructure, what had happened in the past. So these are the two cases that immediately come to my mind when, when you compare an institution-based arbitration and ad hoc arbitration. So besides, of course, providing day-to-day support that the Secretariat does provide, it also ensures a procedural justice which leads to facilitates the substantive justice. And by itself also, I think procedural justice, if you have an award which is very sound on substantive law, still, if there is procedural lack of procedure or impropriety, then also it is liable to be set aside, and liable the very well reasoned order can be set aside only on that ground. So I think we cannot overemphasize the importance of having a system as far as arbitration is concerned. And I was also noticing that we have a mushrooming of various arbitral institutions, and how they are monitored, whether they are able to function in the manner that is perceived, that is also somehow lost in the process. I just wanted to comment on what Mr. Ajit Kumar Mishra and Mr. Ajay Kumar Arora, they just commented on very candidly. That one was, of course, the sanctity of the awards being passed by the arbitrators. Mr. Arora had also commented on the legal versus technical aspect, which is quite a debate, whether it should be the arbitrators should have legal expertise and understanding, or whether it should be left to the experts. But sir, here I would differ from your perspective a bit, maybe because I belong to the legal world. So I feel that all the PSUs, I'll just put my best case here, all the PSUs from NHAI to take any other NHI, DCL or wherever, they all had their own panel of arbitrators so far. And if you look at the arbitrators list, they were all retired engineers, mostly 90% were retired engineers, retired technocrats, and very few legal people. Still, we have faced a situation, sir, where 95%, in 95% cases, they've gone, the awards have gone against the PSU, sir. So that is...
I said strike is to be balanced. There has to be maintained balance.
Right, sir.
The composition of tribunal should be in such a manner, so it's a better combination.
Absolutely.
One member technical, another, so institutions had that option.
Yes.
But the ad hoc arbitration does not have.
That is right.
Because one party, I don't know who they will appoint. Another party may appoint technocrat or the judicial member. I just wanted to say that there is a need to change the composition of the tribunal.
Yes.
So only the institutional arbitration can do so. Because they have the team of legal people, the team of technical people, they have a team of experts also. So the composition of tribunal they can form in such a manner, so the balance be struck with all of them. So
absolutely, well taken, sir.
So just, please.
Your perspective, well taken, sir.
Thank you.
So therefore, rightly so, with IIAC also, I've just seen their regulations. They do carve out the need to have experts in the sense that if there is a lawyer applying and you are being assigned infrastructure arbitrations, then there has to be an expertise in that field. So that is where I think, or likewise, if there is a technocrat, then he must have that understanding of the nuances so that the evidence and the computation of damages, etc., can be done effectively. Point well taken, sir. Thank you.
Thank you for that, Kadambari ma'am. And this is an excellent segue to our next question and to bring on board the last, but not in any way the least speaker of the panel, Naveen sir. Naveen sir, lots of discussion here about the importance of institutional intervention and particularly in the stage of appointing the tribunal. How the institution can support the process and what are the benefits that one obtains as a party from institutional arbitration.
Yes, thank you, Mani. So like what Ajay sir said, that he was earlier a part of PSUs. So similarly, I was also a part of PSUs. So before joining IIAC, I was General Manager Legal in Bharat Petroleum. So whatever I am talking just now, that is due to my experience, whatever I has gained while handling the matters pertaining to BPCL, and prior to that I was a practicing lawyer here. So in my view, what I felt that in PSU, like Ajit sir also told, that there are three major pain point I can say. Number one is the selection of arbitrator. Number two, fee of the arbitrator. And number three is that procedural certainty or visibility of that particular arbitration process. So Ajit sir said one point, that whenever in a case of institutional arbitration you are putting a paper to management to choose an institution as an arbitral institution, management think that their power to appoint arbitrator is curtailed. There is a reason behind it. Because the PSUs, what they think, that there should be a best arbitrator who can decide the matter in an impartial manner. Prior to 2015, that all PSUs were having a clause in which their directors or chairmen were appointing an arbitrator, mostly from their existing employees. So there was a belief that employee of a corporation, but while appointing that person should not be linked with that particular dispute, but there was a belief that he will, because he will be familiar with that work culture of the PSUs, and he will give a fair award. No PSUs is thinking or anticipating also or expecting also that arbitral tribunal should give a unfavorable award in that sense. So PSUs, the expectation is whatever award is passed, that should be a just award. So thereafter what happened, then 2015 amendment came, like Minister also said in this thing, that 2015 amendment which says that employee or you cannot appoint a arbitrator. Then what the PSUs thought, okay, that this disqualification of the Schedule 5 and Schedule 7, that is linked to the arbitrators. So still I can appoint an arbitrator. Then they took view. In that we also deliberated when 2015 amendment came. Then we said, okay, that is disability is linked to the arbitrator, not to the appointing authority. So appointing authority can appoint an arbitrator. Then TRF judgment came. The Supreme Court says once you yourself is not eligible to act as arbitrator, you cannot appoint arbitrator. Then again the PSU thought, okay, what I'll do, I will give a 4-5 name, and that 4-5 name that other party need to choose. So still I will be having an upper hand in the appointing of the arbitrator process. Then they suggest 5 names. Out of 5 names, the contractor has to choose one. So there was a divergent view. One view says, yes, there is an option that contractor can choose, so this is a fair process. Other view says, no, you cannot do like this. Then the matter referred to the Constitution Bench. You all are aware that now recently the Constitution Bench has said, okay, PSU, you can maintain your panel of arbitrator, but you cannot force the arbitrator to choose, force the contractor to choose arbitrator from your curated panel. So today the PSUs are at the stage that you do not have any option or leeway in the process of appointment of arbitrator. In a way, suppose if you are choosing ad hoc arbitration and continuing with the ad hoc arbitration, the whatever panel you are having, all the panel, because it is human psychology. The moment one party says, okay, this person should be my nominee arbitrator, in case of a sole arbitrator, other party will say, I will not agree. Other party will suggest another name, and then matter will go to the court. So it is not going to solve that problem. So that for this solution is the institutional arbitration. In the institutional arbitration, you are having a panel of arbitrator. While choosing that who can act as an arbitrator, you can see that what is the qualification of the arbitrator, what is the credential of the arbitrator, and then you can suggest. And there may be a chance that other party may also agree on this thing. Or suppose in institutional arbitration you can say, okay, this is my 5 option, other party may agree, because they will not doubt that this is their man and he will be giving an award in that favor. That is one point. The second pain point is the fee of the arbitrator. Why I am saying that fee of the arbitrator? Because the PSUs, in case of a PSU, money is not a problem. A company is having a 1 lakh crore turnover, is not shying away of spending 5 crore, 10 crores or 2 crores rupees in a case of arbitration. Problem is that how I am going to take a decision. There is no benchmark that what should be the arbitrator fee. When a PSU is going into that arbitration, the first day arbitrator will say, let us decide on my fee. Now on that particular aspect in 2015 amendment, that schedule 4 was given. Then the judgments came that it said that that is not a binding thing. This is only a directory in nature. And still then in ONGC case that again the court says, okay, that party has to agree on this thing. So in case of a private party, it is very easy that that private party will say, okay, I am agreeing to pay arbitrator 5 lakh rupees per sitting fee. But in case of a PSU, because there is no benchmark, that PSU has to say that I will go back and discuss with my management and take the internal approval. While you are going to management for taking that approval, management will ask that from where this 5 lakh rupees figure you came up. There is no parameter that which arbitrator, some arbitrator is charging 1 lakh, some arbitrator is charging 5 lakh, there is no parameter. Then what the PSU will do, then he will ask lawyer or ask the arbitrator to pass an order. In view of that recent judgment, arbitrator does not pass the order. So in that particular process, what is happening, in taking a decision for payment of arbitrator fee, there is a delay. So arbitrators, then the other party, private party, immediately on first day will come up with a check, they say, sir, your fees is here. Then arbitrator thinks this PSU's fellow, they are not paying my fee, it means that they are like a bureaucratic, this is a government setup. So on the first date itself, you get a minus point, the other side get a plus point. And then that is the thing that went into the arbitrator's mind throughout that process. Whenever suppose a dispute, the arbitrator will say, that contractor will say, look sir, my bill was their final bill, but it was delayed. Or they cut so many things. Then the arbitrator back in mind, then he will see, they have not paid my fee also. For paying my fee, they took this much decision, it means that this is the thing. It is not, but because in a PSU you are dealing with that public money. It is not a private this thing. So you are accountable for this thing. In private sector, what is happening, because your shareholders are there, so majority shareholder, whatever the decision that will fall. But here in public sector, that shareholders are all 140 crores people are the shareholders of the company, because the President of India is the majority share. So their institution will help that there is a fee of the arbitrator, schedule is given, there is no need, you can always refer that particular schedule and pay that arbitrator fee, there is no requirement of any decision on that. And whenever you are going to that management also for taking any approval, you will say, look sir, I have chosen this institution, that fee prescribes like that, immediately within 1 day approval will come. Third point is that certainty and visibility of the arbitration process. In case of a ad hoc arbitration, the arbitrator or lawyer, they will decide that what will be the procedure. The parties are not aware what is my rights, how the procedure will be there, in how much time I have to file a statement of claim, how much time I have to file defense, what is the joinder, non-joinder, consolidation, everything. So the institution gives all the rules and regulation. Even a technical person also can go through that entire thing and he will understand this thing, this is the timeline in which I have to process this. So in my view, this nowadays that PSUs, if you want to have arbitration, you have no option but to choose that institutional arbitration, because what was the benefit you were thinking, that I will be having an upper hand in appointment of arbitrator, that benefit is not available now. So we have to think that which institution I have to see, and that you have to see that rules and regulation and then move to the institutional arbitration. Thank you.
Thank you for that, Naveen sir. So that brings us to the very pertinent question, which is that now that PSUs don't have control over the appointment process the way that they did, how do they gather information as to the choice of arbitrator, the person that they want to choose? And in this, I suppose, globally also, institutions are not up to that level of transparency, of visibility regarding the background of arbitrators that they're going to appoint, or the experience of arbitrators. In fact, some institutions don't even have panels. Some of the most, forward institutions don't have panels. They have, they rely on institutional experience and memory to appoint arbitrators. So the question that arises is, Ajay sir, to you, do you think that that this is a challenge around the opaqueness of the experience and the background of an arbitrator? And of course, Naveen sir has mentioned that the IIAC is leading the charge in that. How do you think it can be fixed?
I don't think so any challenge is there, because so far as the CPSUs are concerned, I think the decision is now very well, it can be taken very easily to opt for the IIAC or for the institutional arbitration, because I don't think so every single representative of the CPSU is aware that how the arbitration has turned. Everybody knows. So I think so rather we don't have any option right now but to opt for the IIAC or the institutional arbitration. Why I'm focusing on IIAC? Reason being that we are all CPSUs, public exchequer, everywhere it is involved. So IIAC is our own institution. We are either entities of the government or undertakings of the government, in one way or another connected with the government. So why not we opt for our own institution? It is our first and foremost duty to make IIAC to take IIAC at the international level. We have to make it. We have no option. This is what I have to say. So there is no challenge at all.
Okay. That's a very great answer, in the sense that it aligns the thinking of the PSUs with the thinking of the institution in terms of the experience and the background that is required for public disputes. I don't think any other institution will be better placed to understand what qualifications are required. But Sanjeev sir, would you like to come in as to how we can make the process more accessible to the PSUs, so that they are confident and comfortable that the arbitrators that are being appointed are people who will be able to manage the dispute?
So I think it's largely a mindset issue, as my fellow speakers also said, that the last 3 decades of experience suggests that invariably we go for retired judges. And it's a mindset issue. We believe that the counterparty would also be appointing the retired judges. In fact, there is a conflict in whether you are appointing the High Court judges or the Supreme Court judges, and who would be appointing whom. And I think that is the mindset which dominated the whole arbitral ecosystem so far. What is required is, and which is what the original model of unsettled model was, that there would be technical and domain expert knowledge would be there, and there would be a legal knowledge in terms of presiding arbitrator, and perhaps we would have a better system in terms of resolving dispute. But then that didn't happen. Now, today also we are in fact struggling. The arbitrators, they are all on our fingertips. Not only in India, globally I am telling you. Globally we struggle a lot in terms of finding the right set of arbitrators. There are, in terms of, because normally when we have the disputes with the government, those disputes are made mainly in the high stake matters where the technical knowledge is required, because these sectors are what? These sectors are oil and gas, these sectors are power sector, and these are high stakes involved. We need domain expertise as far as resolving those disputes are concerned. Unfortunately, not only in India, globally also we struggle in terms of finding out people. Why we struggle? For the simple reason that we ourselves, and I need to blame, all the PSUs and as private sector also, that we don't take risk in terms of promoting other domain experts. Even if, for example, IIAC also must be having number of arbitrators who are not having the legal background. But then are we really, promoting them? Answer is perhaps no. We always go with the retired judges kind of mindset. Now, retired judges are, of course, some of those judges have done exceedingly well in terms of creating that awareness. They have been, a largely contributor as far as the whole ecosystem is concerned. But as my fellow speakers also said, selection of arbitrator is always an issue because your law firms, your senior advocates, they are dominating the whole scene. That is a coterie, if I can use the word. It's a coterie which decides. There's a nexus in the same sets of people. And perhaps that is damaging the whole ecosystem. We need to come out from that. The best answer is, as Ajay also mentioned, that IIAC, for example, today, it is bringing in that level of credibility as far as institutions are concerned. There are some other institutions also in India which are bringing in that kind of, credibility. Perhaps we need to promote them. We need to also think through in terms of domain expertise of those arbitrators. And I think that is the, way to go. We don't have right now domain expertise in most of the sectors which are, which should be there in the arbitrators. And that's the reason why I said that as far as the arbitral infrastructure is concerned, we are lacking not only from a lawyer's standpoint, bench standpoint, as well as bar standpoint. There are no dedicated people on this. And perhaps institutional framework, when we promote that, perhaps then there would be dedicated bar and there would be dedicated benches and the domain expertise.
Thank you for that. And of course, there is the first step of that is to become more transparent in the appointment process. And the IIAC has already started that with having a public list of arbitrators. And there's a little section where you can click and you can get also the details of the arbitrators upon request. So at least there is now an effort to come meet the users of arbitration face to face on the requirements for expertise. So that's a great starting point. Kadambari ma'am, I'd like to bring you in on the financial administration of a dispute. One of the biggest challenges in any dispute actually is that there is one pursuing party and there is one recalcitrant party. And more often than not, the recalcitrant party wants to delay the dispute and therefore does not pay, whether it is the arbitrator's fees, which was mentioned earlier, which is a big part of the cost, or even otherwise the cost of the arbitration. So there are these, stalling of the arbitration becomes a big issue and has been responsible for delaying arbitrations. What do you think is the fix to that? Is there a fix to that, first of all? And is there a role that the institution can play in sort of plugging that stalling of the arbitration and ensuring that it continues?
Thank you, Manini. Thank you, Manini. I think you're right as far as the cost aspect is concerned. Firstly, of course, there are some international institutions where the cost, the administrative fee that they charge is exorbitant, it is prohibitive. And then the parties also take advantage of that and they inflate their claims. And usually the weaker side, financially weaker side, is the one which is put in a fix, because the general rule is divide the fee 50-50, divide the cost 50-50. So I was reading some of the rules pertaining to some of the institutions. SIAC usually likes to suspend the claims. Whenever a party is unable to pay, their rules say that the decision will be taken to suspend the claims. However, there are certain institutions, and I was going through IIAC's regulations also. The registrar has a limited power, and the registrar may, in certain cases, decide to allocate costs as per the claims and counterclaims of the parties. I think this is a very good, regulation, because this would effectively regulate the malpractice of a party inflating the costs and then making both the parties pay half and half. Secondly, I think there are a lot of cases where a lot of institutions, the practice that they have is let one party pay for the entire cost. I mean, of course, that is subject to the capability, and then ask for a partial award, a preliminary award, a partial award to secure the costs. So that can at least be enforced while the arbitration goes on. So that is another practice that one sees. The third thing is that in some of the institutions' regulations, the arbitral tribunal has a duty to assess whether the claims are frivolous or whether they are born out of some contractual matrix. So that the frivolous complaints can be claims can be done away with at the very outset. But usually it is seen that an arbitral tribunal, in a lot of cases, maybe has an interest in that, because ultimately the fee is dependent on the claims. So this is where I think there is a gap, and we need to address that gap. IIAC definitely has a council, the registrar, the chairperson, the entire council to assess. So I think this is a very good mix. It gives a trend away from even various established international institutions where this is there.
Thank you for that. So the institution can intervene, and there are meaningful applications that you can file. So Ajit sir, we'll take some last comments from you, and I'm conscious of the time, so we'll open up the floor to a few questions before we conclude.
So this is a very good question, and this is being used as a strategy by one of the parties to stall the arbitration process as such. And probably to some extent, Chairman ONGC in the first session also mentioned about the high claims, and that's also the norm today. So if you are a party who are faced with such high value claims, and you yourself know that there is not much of the value or merit in that case or the claim, you may try to stall the process, that why I should be paying ad valorem fee for this high value claim, although you are aware that later on in most of the arbitration cases the cost will be adjudicated as the cost follows the event basis, and probably you may get your cost back if you are successful in defending the claim. But it is right at the inception what kind of decision a party has to take, especially is defending this claim. So my advice, I mean, Kadambari has very nicely touched, and has also touched about the gap and what distinct advantage IIAC has in this particular case as compared to other institutions. Other institutions, what they say that they can't force a party to make the payments, but yes, they can request another party to make the fee or cost on behalf of the other party, also subject to the adjudication at the later stage. But my suggestion here, taking forward from where Kadambari left, is with a suggestion to the other party, responding party, is not to stall the arbitration process, rather let it continue with it. You contest it with the full effort. And if you find that your claims, the other side claims are frivolous, you request for early dismissal of the claims. Rather than stalling the process, you request for the early dismissal. Many institutions do support this. Unfortunately, I'm not aware whether IIAC has this or not. If they have, I mean, it's one of the most welcome stays, and if not, I'll request them to amend that. And with this, I'll...
That's a great pro tip even for practitioners to keep in mind, which is early dismissal and preliminary adjudications. We're short on time, so perhaps we can take one or two questions from the audience and then conclude the session. Anybody?
Good afternoon,
Yes.
Madam. I'm Suresh Madhavan, Chief General Manager, ONGC. And I must say I'm not a lawyer. I'm a technical person sitting on the other side. Arora sir has said, like the ideal situation would be not going for an arbitration, like not creating a situation which leads to arbitration. And Mishra sir has rightly pointed out the reason for not reaching to that ideal situation, which is fear among the officers. If the officer were to take a decision without fear, if he had taken that decision, then in most of the cases it wouldn't have gone to arbitration. Now this is the reason. So this reason has been there. So I've been CVO, I had the opportunity to function as CVO of some of the organization. There also I used to hear about this fear. So we talk about this fear of taking decision, but there is no solution as such which comes out. What can be done for this one? Sir, I draw attention towards the recent amendment which was done in PC Act, section 19A, wherein a police officer cannot take a corruption case under a PC Act without sanction from the competent authority against any public authority. So this is a protection which is given to the public officer, so that even for starting an investigation on corruption also the police officer has to take a sanction. Sir, if such a provision is made in the conduct rules of PSUs, where the vigilance cannot take up an investigation without sanction from the competent authority, this will give the required protection, a safeguard for that officer to act to act according to his conscience and with courage. And now the fear, because of the fear, they simply pass on the buck to the arbitrator. So let it go to the arbitrator, so I am safe. That is a safe side to play. So if such a amendment can be brought to the conduct rules through DP, of course with consultation with CVC, I think there can be there will be a reduction in taking the cases to the arbitrator, and the officers will be willing to take their decision then and there itself. Thank you.
It's a suggestion. Well taken, sir. Well taken.
Do we have one question, perhaps just short and crisp, and then we can wind up? Okay. Gone. Thank you very much to the panel for their insights and the wealth of experience that they have shared with us. It was certainly a panel which will put the rest of the day on a gallop run. For the rest of the panels to discuss, offshoots of what we have already spoken about. So thank you very much, and thank you to the audience for your interaction and your time.
Before we conclude, I must thank Manini. You have wonderfully conducted this stage. I'm very thankful to you also.
Thank
you
thankful
to the IIAC chairman for giving us an opportunity to be to part of this wonderful event. So I just would like to answer your suggestion, although it was a suggestion. I 100% agree with you, sir. Because in most of the cases, particularly in CPSUs, the officers are reluctant to take decisions. They are very well aware that I am going to take a very right decision. But just few minutes ago, when the Honorable Minister was here, he said something. He said कि जब हम ठीक स्पिरिट के साथ, ठीक नियत के साथ कोई निर्णय करेंगे, तो वो नियत आप माने या ना माने, मैं इसलिए नहीं कह रहा कि मैं वो एडवाइस नहीं दे रहा सर. द बेस्ट वे टू गिव एडवाइस टू अदर्स इज टू एक्ट अपॉन इट. तो मैं जो एक्ट अपॉन किया है अपने समय में पब्लिक सेक्टर में, वही आपको बता रहा हूँ कि अगर सही स्पिरिट के साथ डिसीजन लेंगे, सही नियत के साथ डिसीजन लेंगे, तो कोई सैंक्शन हो या ना हो, अगर आपके पास कोई प्रॉब्लम, अगर प्रोसिक्यूशन होना है तो होना है, लेकिन आपकी नियत अच्छी है, वो आपके पेपर्स में नहीं दिखाई देगी, आपके कंटेंट्स में दिखाई देगी. तो अगर आप राइट डिसीजन लेंगे, राइट स्पिरिट में लेंगे, कोई भी ऑफिसर आपके बाद आएगा, चाहे वो सीवीसी है, चाहे वो आपका पुलिस है, चाहे इन्फोर्समेंट है, वो इस चीज को सूनर और लेटर अंडरस्टैंड करेंगे. बाकी जस्ट बिकॉज हम सीवीसी से रिलक्टेंट होकर डिसीजन लेते हैं, क्योंकि टेक्निकल लोगों के साथ बहुत बड़ी प्रॉब्लम है. डिसीजन आज मैं हूं, मैंने लिया, कल मैं चला गया, दूसरे मेरी जगह रिप्लेस होकर के आ गया, ट्रांसफर होकर आता है, वो सोचता है मैं क्यों करूं। मेरा ये मानना है कि उसके डिसीजन को उसको मालूम होता है इसने ठीक स्पिरिट में लिया, तो प्लीज उसको जस्टिफाई करें, उसको राइट स्पिरिट में लें। ये सोच के नहीं कि उसने चला गया तो ठीक है, अब मुझे क्या करना है, होगी प्रोसिक्यूशन, बैठेगा ऑडिट पैरा, बनेगा तो बनेगा। मैंने बहुत सारे ऐसे केसेस देखे हैं जो राइट स्पिरिट में डिसीजन लिए होते हैं, और जब ऑडिट उनका बनता है, जो दूसरा रिप्लेस सब्स्टिट्यूटेड ऑफिसर आता है वो कहता है मरने, तो मैं बड़ी लाइट माइंड से और लाइट हार्टेड उनका आंसर देते हैं। वो उस एज ए रिजल्ट ऑफ विच वो जिसने राइट डिसीजन लिया होता है। तो प्रॉब्लम ये नहीं है कि सीवीसी ने को ऑब्जेक्शन या ऑब्जर्वेशन में बनाया या ऑडिट ने, प्रॉब्लम यह है कि ऑडिट पैरा जो बनता है उसको राइटली आप एड्रेस नहीं करते, क्योंकि मेरा वो सोचता है मुझे क्या है, मेरा तो डोमेन नहीं है, जिसने किया वो देखेगा। सो प्लीज इसको राइट स्पिरिट में ले। तो दैट इज व्हाट आई हैव टू से। थैंक यू।
Thanks to all the esteemed panelists for such an engaging and insightful discussion. Now it's time to felicitate our esteemed panelist and the moderator with a token of appreciation. I request and invite Ms. Smita Sehgal, DGM Legal, Engineers India Limited, to felicitate Mr. Ajay Kumar Arora, please. Please have a huge round of applause. Mr. Vinay Kumar Sindhuja, Registrar IIAC, to felicitate Ms. Manini Brar. Mr. Karan Kawal, Deputy Registrar IIAC, to felicitate Mr. Ajit Kumar Mishra. Mr. Deepak Nerwal, IGL Legal Head, to felicitate Mr. Sanjeev Gemawar, please. Mr. Satyan Kumar, Executive Director ONGC, to felicitate Mr. Naveen Kumar Singh. I request Mr. Rajinder Chaudhary, BPCL Assistant Manager Legal, to felicitate Ms. Kadambari Singh. Now I request all the panelists and the moderator to come forward for a group photograph so as to commemorate this session. Thank you. Please have a huge round of applause for the wonderful session. Thank you.
Thank you, Kanksha. We now proceed to the second technical session, where we will have an in-depth look at the IIAC Conduct of Arbitration Regulations 2023, which will be presented by Mr. Ganesh Chandru, a part-time member of IIAC. Mr. Chandru specializes in international and domestic arbitration as well as commercial litigation. He is admitted to practice in India, England, and Wales and Singapore, and is a fellow of the Chartered Institute of Arbitrators, UK, and the Singapore Institute of Arbitrators. He has been recognized in the Lexology Index Arbitration 2025 and in the Who's Who Legal Arbitration 2024. Mr. Chandru is also on the Forbes Legal Power list as top individual lawyer for ADR, arbitration and mediation. Now I request Mr. Ganesh Chandru to kindly share his insights. Ladies and gentlemen, please give a huge round of applause for Mr. Ganesh Chandru.
Thank you. Thank you, Ashish. I think this topic on IIAC conduct of arbitration regulations is perhaps one of the most important topics for the day today, because we are talking about institutional arbitration, the way forward, and why PSUs should reconsider the arbitration clauses to include an IIAC arbitration clause. In fact, we had a very inspiring speech earlier by the minister, and we had a lot of suggestions. But what I'm going to do, because one aspect which is always being said is time and cost is extremely important, and we should adhere to it as well here in this conference. We are already 20 minutes delayed. Right? So what I propose to do, in addition to my presentation, we also have a video clip. And there's also going to be another short presentation on the proposed facility of the center. So what I would do is, in terms of the salient features, the secretary had pointed out, Mr. Abneet Arora has also pointed out the salient features. So what I would suggest is, in all your bags here, the bundle that was given to you in registration material, there is this booklet called the IIAC Handbook. I request all of you to just keep it with you, and not only today, but also in your workstations or in your room, so that it's handy. This handbook contains the India International Arbitration Center Act 2019. It contains the IIAC Conduct of Arbitration Regulations 2023. It also contains the IIAC Conduct of MSME Regulations 2024. Criteria for admission to panel of arbitrators. Many of you are not only going to be coming to IIAC as parties, but also in future you may want to be arbitrators and apply to be on the panel. And most importantly, the IIAC Model Clause. I have a PowerPoint presentation, but I'm not going to go through it fully, but I request that it be played. I'll just only show you some of the salient features of the rules, because many of the rules have already been, discussed today. And in this booklet, the rules start at page 23. This is the main, rules of the Arbitration Center, which is called Conduct of Arbitration Regulations 2023. In fact, this rule, I should tell you, one thing which always is on the mind of PSUs, because I also act in matters where PSUs are involved, is whether these rules are against you can take it that none of these provisions are in conflict with our Arbitration Conciliation Act. It's completely in consonance with the Act. In fact, many of it mirror the provisions of our Act, and it has taken best practices from all over the world, from top arbitral institutions across the world, and we have also made sure the Arbitration Act is kept in mind. So if you look at the rules proper, all these things were told about IIAC and its institution of national importance. It was in fact called the NDIAC earlier, so sometimes you don't want to confuse looking at the old act. It is now called the IIAC to reflect its national kind of importance. These rules specifically, which I'm going to discuss, came into force on 31st of August 2023. So it's been in use for almost coming to 2 years now. But as rightly pointed out today by one of the speakers in the inaugural session, while we may have regulations, the most important aspect is how the arbitrators are going to deal with the case and how the Secretariat of the IIAC is going to administer this arbitration. This is the value add that an institutional arbitration can provide to you rather than in an ad hoc scenario. So these are the salient features: efficient time-bound process, there's a fast-track procedure, there's an emergency arbitrator provision, there's very important, there's an advisory panel for appointment of arbitrators, which advises the Honorable Chairperson who makes the appointment of arbitrator, and the fee structure is a very good balance of cost efficiency and is also competent, it's not too less. I'll just point out very quickly. So I'm not going to go through the entire rules because you need to look at them. It starts at page 23 onwards. Very simple. You start the arbitration with the request for arbitration, which contains all the basic details that a notice of arbitration should contain. Then a response is filed by the respondent within 14 days. And, then you, of course, need to have the tribunal constituted. The very unique provision of IIAC is there is an advisory panel which looks at the case, looks at what is the qualification required of the arbitrators, look at the panel, and a recommendation is made of certain names to the Honorable Chairperson. Of course, the decision is the Chairperson's decision at the end of the day, and he makes the appointment. In case of a sole arbitrator, one thing you need to remember that when you make a nomination, be it for a sole arbitrator or in a three-man tribunal, it is only a nomination which is to be confirmed by the chairperson of the IIAC, because we conduct conflict of interest check and make sure the arbitrator is independent and impartial. Only thereafter the arbitrator is confirmed and the appointment is confirmed. These are various days for sole arbitrator, 3 arbitrators, which you can look up. Challenge is very similar to the Act. And, fast-track procedure is extremely important. You can get an award within 6 months if parties agree to a fast-track procedure. It's akin to our 29B of the Act. Emergency arbitrator, I'll spend a minute on this. Within, 3 days after making an application and it was accepted, an emergency arbitrator is appointed. One thing I want to point out is there's nothing called emergency arbitration. Many people use it interchangeably. It's only emergency arbitrator who is appointed before the main tribunal is constituted to deal with an application for an urgent interim relief. Within 1 day, business day, it's the appointment. After the appointment is made, the challenge can be made if necessary. Within 2 business days, the parties are heard, and within 15 days, you will get your order from the emergency arbitrator. Pleadings, very similar to our Act, statement of claim, defense. One unique feature is the draft arbitral award is to be submitted to the registrar of IIAC. It's an extremely useful provision. The IIAC does not involve in the decision making of the arbitrator. It only checks certain very important aspects of whether the names of the parties are mentioned correctly, jurisdiction is established, reasoning is given by the arbitral tribunal, he's dealt with costs, interests, so that your arbitration award is not set on frivolous grounds. But on the merits, the IIAC will not get involved, and there's a time limit within which this is to be given to the IIAC, 60 days from the close of proceedings, and IIAC also has a time limit of 21 days to get back to the tribunal on the draft award. Lastly, I really request you to look at the fees. Very important. You look at page 53 of this booklet. There's a fee schedule. This follows Schedule 4 of our Act to a certain extent. Of course, administrative fees, very nominal, ranging from 15,000 to 1,50,000, depending upon the amount in dispute. You will see ONGC was involved in the case of where the Supreme Court said if there's a counterclaim, you have a separate set of fees going up to 30 lakhs. But here what we have done, amount in dispute is claim plus counterclaim. Actually, you will have a benefit if you choose this, because even if there's a counterclaim, up to item 6, it mirrors the Schedule 4. But then there are certain matters where you can't have a low fee for a very high claim, especially if it's 1,000 crore, 1,500 crores. So therefore, more than 200 crores, it's capped at 91 lakhs. But within that, there are a few other rows so that it's fair to both the parties and to the arbitrator. This is the domestic fees. Of course, emergency arbitrator, there's an administration fee of 1 lakh, and the emergency arbitrator's fees is about 7 lakhs. There's a similar table of fees for international arbitration, which is in US dollars, or it can be the Indian equivalent. For a domestic arbitration, the filing fee is 5,000 rupees, and in an international arbitration, it's about 500 US dollars or the equivalent. Here again, you have an ad valorem fee structure. It is also capped at 200,000 for the arbitrator's fees. And I think I can tell you, having practiced 30 years, I can tell you, if you choose institutional arbitration, you can budget your fees. It's extremely important for public sector undertakings especially, and you don't have the bane of ad hoc arbitration where the arbitrator is going to sit and tell you this is what my fee is going to be. So it is based on these regulations, and with that I would really encourage you to look finally at the model clause at page 95. With that I will finish. Please look at it very carefully, incorporate this into your clauses, into your contracts. any dispute, this is a typical clause arising out of connection with this contract, page 95, including any question, blah, blah, administered by the India International Arbitration Center, conduct of arbitration regulations. Please put this in expressly, state the number of arbitrators, and the law governing the arbitration agreement. Please use this because there have been case law in Singapore where since this was not said, the seat law has been taken and not the law governing the contract. So please follow this model clause. You can, if you lose this booklet or something, you can always look at it on the IIAC's website. And you have a very efficient secretariat here, which has the registrar, deputy registrar, counsel, you have the CEO, under the guidance of Honorable Chairperson. They are doing a fantastic job. And in fact, there have been quite a number of cases that have been coming into IIAC, not just by reference from court, but there are also a couple of matters which have come directly. And I think, any doubts, the Secretariat is always there to, help you. You can call them, email them, and, any doubts on these regulations, we are here the whole day, we can discuss. And if any particular PSU wants a dedicated presentation in their office or something, I'm sure any of us will be very, very happy to do that. The Secretariat is here and we can also come and do it for you. With that, I thank you very much for your kind attention. What we are going to do is, in fact, in addition to institutional arbitration, you can also come to IIAC for appointment of arbitrators. That's another feature. And it's a very nominal charge. For one arbitrator is 5,000 rupees, two is 10,000 and 15,000 rupees. So this is just for appointment of arbitrators. And now we will move on to a video clip that will be played about IIAC, and thereafter there will be a short presentation on the new facility, which is very exciting. I'm equally excited to see that. Thank you so much.
Thank you, sir.
The center is providing state-of-the-art facilities to set up every kind of convenience to facilitate international and domestic arbitrations in this region to be conducted at the center, which is self-regulating, has its own regulations and empanelment for arbitrators. The step forward was to take up the erstwhile institution, which is now housed on a vast plot of 5 acres of land in South Delhi, having a complete amenities and facilities for parking, for conducting arbitrations, etc.
In the last decade, there has been a sea change in the landscape of Indian arbitration. Government has undertaken several measures to address bottlenecks in dispute resolution. Our courts have, through their judicial pronouncements, systematically promoted a pro-arbitration regime. The IIAC has all the requisites necessary to establish itself as a premier arbitral institution. It has state-of-the-art facilities, rules and regulations consistent with best global practices, guidance and inputs of distinguished experts, and most importantly, a pool of experienced and credible arbitration professionals across disciplines.
The India International Arbitration Center is the only institute set up by an Act of Parliament. The center is declared to be an institute of national importance to promote domestic and international arbitration in India. We have state-of-the-art infrastructure for dispute resolution, from spacious meeting rooms to cutting-edge video conferencing facilities. We are equipped to deal with all kinds of dispute resolutions in efficient and professional manner. We have a pool of arbitrators bring wealth of expertise and insight to every case they handle. The reservoir of legal talent is unparalleled in its expertise. This center is located close to the airport and near important commercial and business centers in the capital. India is marching towards creating an independent and autonomous regime for institutional arbitration.
In line with its objects and functions, IIAC strives to conduct arbitration and other forms of alternate dispute resolution mechanisms, both domestic and international, as per the manner specified by its regulations. Further, Chamber of Arbitration has also been established to empanel arbitrators, both domestic and international, as per the empanelment regulations.
The establishment of the India International Arbitration Centre marks a significant milestone in India's pursuit of global recognition as a prominent player in the field of arbitration. This will not only affirm the nation's standing in the international arbitration community, albeit IIAC as an institution will foster a sense of trust and credibility among both domestic and international parties engaging in arbitration within India. I hope the IIAC will emerge as a credible frontline institution in providing a dedicated and specialized platform for arbitration and will enhance the accessibility and efficiency of dispute resolution in India.
Debates about streamlining the process of commercial disputes have been going on in India for quite some time, and the intense international competition among nations to prefer their own centers of international arbitration was another subject. But now India has launched a major initiative taking stock of both these aspects.
The India International Arbitration Centre is managed by a team of eminent persons having substantial knowledge and experience in institutional arbitration at both domestic and international level. The Chamber of Arbitration will empanel arbitrators from amongst the persons who are proficient and willing to serve as arbitrators based on their expertise and experience. The panel of arbitrators includes both experienced as well as young professionals. The Centre has an efficient secretariat to administer arbitration under a progressive set of the conduct of arbitration regulations.
There has been a paradigm shift in the traditional mindset of ADR mechanism, especially in the arbitrations. And when we talk about institutional arbitrations, IIAC has indeed taken the front lead at the national level.
The vision of India International Arbitration Centre is to promote the overall alternative dispute resolution mechanism from the grassroots level with an aim to lessen the burden of courts to the extent possible.
In arbitration, institutional arbitration has definite advantages. All over the world, institutional arbitration has attained such great heights, especially in London, Singapore, Hong Kong, and other places. In India, we have institutions which are at Mumbai, Chennai, and other places. But at the central level, to have an institution as a flagship institution is what is this India Arbitration International Centre. The Parliament is conscious of the fact that India has to be, with the growth on economic front that we are achieving, consistent with that, the commercial disputes also need to be resolved at an early date, expeditiously, and with element of certainty and consistency.
India is marching towards autonomous, independent institutional arbitration regime. I welcome you to India International Arbitration Centre, where disputes find resolution.
Ladies and gentlemen, in fact, this video that you saw is the present premises of IIAC at Vasant Kunj. But there's a proposal to move the center to the World Trade Center, which is on Ring Road, very close to the Hyatt Regency Hotel. So on that, our friend here will make some presentation as what's the plan for that facility.
Good afternoon, everybody. As we're taking forward from what we have discussed about the arbitration center that is existing at Vasant Kunj, the new facility is being proposed at World Trade Center, Naroji Nagar. That's the heart of Delhi, very well connected to the entire city. It's on the ring road. As we see forward, this is the overall site which has all the reputed public sector undertakings coming up, being the central zone. So this facility which is being developed at the World Trade Center is in one of the towers on 4th and the 5th floor. The total area of the development is 34 lakh square feet, and this is divided into multiple towers, each tower having about 9 floors. So the proposed arbitration center, India International Arbitration Center, is on the 4th and 5th floor of Tower A. So the building is already existing. A lot of departments and public sector undertakings are already operational in the premises. The facility is divided on 2 floors. One floor is dedicated for the secretariat and secretarial functionals, and the other floor, that's the lower floor, 4th floor, has the complete arbitration center. Arbitration center is being designed as a complete consolidated facility which understands the functionality of the arbitration center, allowing space for the visitors to have accommodation while they are waiting. There's a provision for keeping the records in the secured locker area, which is facilitated in the premises. There's a resource library planned, cafeteria which is being planned. The arbitration center has the state-of-the-art technology which is being integrated in the facility. Each arbitration room has complete video conferencing facility, the wireless presentation, and all the technology that can be thought of in an international level arbitration center. There are dedicated lounges for the arbitrators and the judges to intermittently discuss the cases, while the arbitration is on halt for a while. There is centralized mechanism which also gives the scheduling of each hearing that's going on in every arbitration room, which can be monitored centrally, and the hassle of moving from one space to another is restricted by use of technology. The facility which is being developed for the secretariat is also state-of-the-art with all the modern facilities. So this is a typical module of an arbitration room which is being well treated with all the aesthetics, technology being integrated, using audio system which has good acoustic understanding of the space. So that's another typology of arbitration room. So we have arbitration rooms of different sizes to understand, to have the hearing of different scale, starting from 16, 18 people in an arbitration room to smaller arbitration room of about 8 to 10 people. So that gives us the flexibility of having the cases heard in different capacities and different areas. As we were discussing, there are waiting lounges which is being created for the arbitrators, for the lawyers. There's a resource library being planned to have the archival study of the cases. This is the imagery of the secretariat that is being proposed. That's a cafeteria which also is, acts like a breakout space intermittently between the arbitration hearings. So that's the end of the slide. Any questions on the proposed arbitration center is welcome.
Thank you, Mr. Jasbir Singh, for such a lovely presentation. We extend our sincere gratitude to Mr. Ganesh Chandru for providing us with valuable insights into the IIAC conduct of Arbitration Regulation 2023, especially considering that the time we had. Now, may I please request Mr. Ashok Kumar, Executive Director, ONGC, to felicitate Mr. Ganesh Chandru. Thank you, sir. Thank you for the honors. Ladies and gentlemen, let us now take a break for lunch. Please join us for the networking lunch, and we will resume for the third technical session at 2:30. Thank you.
Ladies and gentlemen, I hope everyone had a refreshing break. We'll be starting soon. Please be seated. Thank you. We'll be starting in next 2 minutes. Please be seated. Thank you. Welcome once again. We now move on to our third technical session, which is best practices during arbitral process, a discourse. It is my pleasure to invite the moderator for this session, Mr. Vikas Mahindra. Mr. Mahindra is a partner at Keystone Partners and an expert in international arbitration. We extend a very warm welcome to you, Mr. Mahindra. We are also honored to be joined by a stellar panel of speakers for this session. Mr. Amit Jindal, Head Legal Directorate General of Hydrocarbons. Ms. Sandhya Yadav, CGM Chief Legal Services, ONGC Limited. Mr. Haseed Seth, Independent Counsel, Arbitrator and Mediator. Ms. Smita Sehgal, DGM Legal, Engineers India Limited. Mr. Siddharth Shetty, Partner, JSA Advocates and Solicitor. A very warm welcome to you, everyone. With that, I now hand the floor over to you, Mr. Mahindra. Thank you.
Thank you very much for that, and thank you everyone for joining back. I have the enviable task of trying to fit what we had originally scheduled for an hour in about 45 to 50 minutes, I'm told. So we'll do our best, try and extract as much information from my panelists as possible. But before we move on, just tying in with the theme of the conference, it's on institutional arbitration, an effective form of dispute resolution, right? And the title itself suggests that there is an answer that is there. And that answer is on face of it at odds with some developments that we're seeing in recent times, where a number of PSUs, a number of government undertakings are looking at, is arbitration the right way of dispute resolution? So the difficult question that we have for this panel, and we'll try and split it up into some smaller bits, is the problem with arbitration as a concept, or is it the way arbitration that is being conducted today? And is there something that institutional arbitration can do to make it better? Is there something that we can do during the arbitral process to make it better, so that the very legitimate concerns of the government, which has led to rethinking about arbitration, are addressed? And maybe on that note, I'll start with the person who's found a solution, and we hope to learn from that. Ms. Sandhya, I'll ask you the question. As ONGC has pioneered, and I remember having this conversation last year, incorporating an IIAC clause into your contracts, can you just talk us through what was your thinking behind it and how has it worked since?
Thank you, Mr. Vikas. So, as we have discussed in previous sessions also, there were problems in the ad hoc arbitration. I'm not going into that. So, there was always a thinking that we should shift to institutional arbitration. But the problem was that which institute? So we found solution in 2019, that was after the COVID period, that it was enacted and the IIAC was established. And 2023 regulations were notified. We done our due diligence our internal legal team examined the rules and the practices of all institutes in India, and they recommended for IIAC. We took in principle approval in December 23 itself for adoption of IIAC. We informed Chairman IIAC regarding this, and we sought various clarifications or rules, or we had certain doubts basically. And we also wanted to consult our stakeholders, business partners, vendors, contractors, the contracting parties who are the essential stakeholder to the contract. For that we conducted a workshop where we invited all representative of contractors, representative of Law Ministry, Registrar IIAC. We wanted that one-to-one discussion should be there to remove all doubts. So in fact, I had the maximum questions because we were shifting to the new field. So I was apprehensive. People will blame me that why I have done this. So and thankfully all my doubts were removed. So we were looking for a cost-effective and a faster resolution mechanism. And when we saw the regulations, everything was addressed. As we know that institutional arbitration has a established panel of arbitrators which they select after making all the due diligence. Various kind of checks and balances are there. So we are safe. And then secondly, there is a due process of law. A procedure is there. Timelines are there. These defined rules and timelines are very essential for timely conclusion. Arora sir was saying that one case was pending since or concluded after 20 years. We have a case which has not yet concluded, still in Supreme Court, and the contract was, I think, of 1994. So it's still going on. And the most important, the other part is administrative support which the institute provide. Otherwise, only parties have to make all the arrangements. We are always on the toes and the arbitrators are not happy with our arrangements. The venue, the hotel and the various, they always complain. So the most important thing which the institute does is the overall monitoring of the process, right? So there is someone whom we can look forward. Otherwise, in ad hoc, we have to move to the court. We file litigation for fees also, for conflict of anything we have to approach the court. So a lot of legal expenses are there. So considering all these features which were there in IIAC, there was one doubt that IIAC is at the inception stage itself. There is no track record. So as an ONGC, a Maharatna and part of government, we always supported the government cause and their initiatives. And the vision of our, I think, Prime Minister of India was to make India a international hub, arbitration hub. So we thought that we will be part of this journey. The IIAC will be groomed. We will also be part of this growth of IIAC. So that is the reason how we have decided to do it. So in 24, after making that workshop, we made this clause as a part of our tender document. There is a standard clause where IIAC has been written. And what else we are doing is we are proactively telling our contractors to amend the existing contracts so that whenever any dispute arises in the existing contract, we can refer it to IIAC. So recently we convinced one of the contractor when he raised dispute. The first case has been referred to IIAC already, and I think one is more in the pipeline. So proactively we are doing all these efforts, and whenever any support is required from IIAC, for example, in the recent case, the tribunal has set a date, to decide whether this matter should be referred to IIAC. I'm not, sure what will be done. So, with the same set of arbitrators, can we refer the matter? Can we adopt the IIAC as a rules and the conduct they can conduct? So that is also we would like to take. Thank you, Vikas.
No, thank you very much. That's deeply insightful, right? Because I mean, you've addressed so many different things. The perception for the layman is government departments act with a heavy hand. You just put it into your contracts and you force all of your contractors to follow. But the fact that you did that exercise painstakingly, conducting the workshop, persuading them, and I think what you said on even in existing clauses you have been able to persuade them is actually extremely insightful. And, we heard the Secretary of the Department of Legal Affairs earlier this morning telling all the PSUs who to adopt IIAC as the administering body. Ms. Sandhya set the roadmap for it, and I think we all just have to get working on it. Maybe the answer to making arbitration more efficient is just adopting IIAC, and I can just bring the session to the close. But since we have a few more minutes, I'll probably do a little bit more. So what we'll do in the next half an hour, 40 minutes, is go through different stages of arbitration, and we'll try and see, is there something that we can do better, either through institutional arbitration or as counsel and arbitrators? And I'll try to get the feedback of the people here in the room for that. And I'll start with Mr. Amit Jindal, I'll start with you on the constitution of the tribunal, which is really the first step. And I think it's worth comparing what the practice is today and then seeing can it be done better. So my question is, in your experience, the process of constitution of an arbitral tribunal, is it smooth, is it painful, and are you satisfied as a user?
Good afternoon, everyone. First of all, I congratulate Sandhya ma'am and ONGC for getting out of ad hoc arbitration phase and to enjoy this tremendous facility of IIAC in hosting the arbitration matters. While working in DGH as well as earlier, we have handled various ad hoc arbitration matters, international as well as domestic. Presently also, during the last 3-4 months, we have got new 5 arbitration matters. So, in ad hoc arbitration, appointment of arbitrator is always a pain, starting from the day we receive a notice of arbitration until the date we appoint the arbitrators. Because first of all, you need to see who is the arbitrator from the other side. I have to appoint senior one, then to go to government to seek approvals, and thereafter whether he is agreeable to fourth schedule or not. Then maybe what kind of demands he is having, certain other demands, maybe like Sandhya ma'am quoted that hotels and facilities. So in ad hoc arbitration, we arrange it like we have a function at home. So every time they have new demands, maybe related to vehicle, maybe related to hotels, maybe related to some other facilities. It's a painful process actually. So when we see this kind of institution coming up in India, that too in a legislative manner, yes, we appreciate that. The government has initiated a very good framework, and this is a national importance project that was cited, I think. And when we see regulation 12, 13 and 14 of the IIAC, that also provides a very good mechanism of appointment of arbitrator. Within 14 days, a party has to appoint arbitrator. Thereafter, the other party has also that similar period. And fees are settled. You have control over the fees. Yes, given a choice, I would go for institutional arbitration when I have already seen the nightmare of the ad hoc arbitration. In what I miss in ad hoc, I must share with you. That is, first thing, there is no timeline. There is no control over the arbitrator fee. There is no supervision over the judgment. In case you have any grievance against the arbitrator, tribunal or anything or process, then you have to go to court only. No other mechanism. In court you might be spending a year or 2 years. There was an issue with us relating to neutrality of arbitrators. We spent about 2 years in court to get it decided because there was no other process. Section 14 was there and we have to go to court. We have approached Delhi High Court, Supreme Court. There was no remedy for that actually. And in case IIAC would have been there, might be we could have resolved that within a month or so. That was the world's highest arbitration matter, high-stake arbitration matter, maybe highest in India also. And we lost 2 years for just a bias issue to get it decided from courts. And really, I think IIAC would do a great job in arbitration arena, and I wish them all the best.
Yeah.
Thank you.
No, thank you. And I think, again, there are a few themes you touched which are very important, right? One is there are so many difficult decisions you have to take in an ad hoc arbitration, which you feel very uncomfortable doing, because, even things like negotiating fees with the arbitrator, trying to tell them use this facility instead of that, because ultimately they are your decision maker. And now what an institution is able to do is to come in between and say, I will insulate you. Let me have those difficult conversations, because I've appointed them, I will probably appoint them again. So there is a degree of accountability to the institution, which is not there in ad hoc. So I think great points there. So thank you so much for sharing those, Amit. We'll then move to the next phase of arbitration, right? And this is something which people have recognized as important, but is not happening often enough. Case management. Now, the Commercial Courts Act already says that, even in commercial disputes in court, you need to have a case management conference, but we are seeing that in ad hoc arbitrations particularly, it's not happening as often. So with that, maybe I'll turn to my right now, Hasid, in your experience, what is the biggest contributor to delay in arbitration, and can a case management conference at the very root nip it in the bud and address some of these issues? What's been your experience?
Thank you, IIAC, ONGC and the Law Ministry for organizing this conference and this opportunity to share some views. What Vikas has asked is very important, because the initial meeting and the PO1 pretty much decides the tone of the arbitration, even if it's an institutional arbitration, because the latitude which the arbitrators have along with the parties to frame a procedure suitable for arbitration gives the arbitration its flexibility. One of the challenges which introduces delay, particularly in India-seated arbitrations, domestic arbitrations, is that most of the stakeholders, the lawyers, even the arbitrators, come from a court background. And their idea of evidence and procedure is exactly what they know from the court background. How to prove the documents, witnesses, examination, discovery, document production is all essentially some version borrowed from the court procedure. So I think a case management conference where these things are proactively understood, that what is going to be rough idea of what the evidence is going to be presented, and then devising procedures which would make it easy. So for example, all these different tools are available. Everything from the IBA rules for taking evidence in there's really nothing much international about it. They can be easily applied in domestic arbitration, and we have had success in convincing the parties sitting as arbitrators that adopt them, because having no rules, is that then we are in territory of fighting about whether this request is overbroad, not, and what procedure to follow. Then one big change I think which rules can bring in is memorial style pleadings, that you go all in with your pleadings, evidence, arguments, everything rolled into one. It is worth trying it out for smaller disputes, at least, so that you have one-time filing and that's about it, and nothing else. Because what our domestic procedure from the adversarial pleadings is, you have one round of pleadings, you have document submissions, then you have witnesses bringing in more documents attached to their affidavit of evidence, and then there are always some enterprising folks who want to introduce evidence even after the arguments are over. So this is unsustainable in arbitration because it's borrowed from courts, and somehow that has kind of an aura of due process, that this is the process where everybody needs to follow, and this is what's sanctified. But I think the change can come from institutional arbitration, either through case management or a protocol which is prescribed, where all these options are provided, at least, if not prescribed. Thank you.
Thank you. very valid points, and I think you also touched upon what role an institution can play in this, which is really give parties guidance. And like you said, a lot of times arbitrators coming in, especially from a judicial background, may not know these things, not because they don't want to do it, it's simply a question of they may not know. So if an institution can give some guidelines or some rules to say, hey, this is possible, do you want to explore it? Maybe more people will start adopting it. So thank you for sharing that. And with that, maybe just on the international perspective, I look to you, Siddharth. You've clearly done a lot of international arbitrations, and I know a case management conference in those arbitrations is super crucial and important. But can you share light on what are the kind of things that parties must look to include in such a initial case management conference? And is it a fetter on your flexibility, or is it actually necessary?
Thank you, Vikas. You have touched upon a very, very crucial aspect, one of the key aspects in any arbitration. Honorable Mr. Justice Hemant Gupta, esteemed dignitaries from the Ministry of Law and Justice, my fellow panelists, my friends from the media, ladies and gentlemen, namaste and a very good afternoon. Case management conferences, I'll just come straight to the answer because of the paucity of time. Case management conferences provide clarity, opportunity to cater to the relevant requirements of the particular case, an organized manner of progression of the matter, and most importantly, certainty and trust. A well-crafted procedural order number 1, and you asked, is there something that we should be looking at when we are drafting a procedural order number 1? A well-crafted procedural order number 1 minimizes procedural skirmishes and aids legal professionals like me who handle multiple matters. From the standpoint of litigants as well, who, as Ms. Yadav mentioned, are the most important stakeholder in the arbitration ecosystem, there is predictability and no surprises. If one looks at the Indian jurisprudence, there are many examples which suggest that principles of case management hearings increasingly find integration in our arbitration mechanisms now. This is to ensure efficiency and to streamline the dispute resolution process. Section 19 of the Arbitration and Conciliation Act empowers arbitral tribunals to determine their own procedures, subject of course to the agreement of the parties, and this helps tribunals to conduct a case management effectively. There are various judicial precedents as well which emphasize the importance of having a structured and a more definite, process followed in the arbitrations. The timelines for expedited hearings that we have in the Arbitration and Conciliation Act and the requirement to pass an award within a certain time frame, they all show and indicate the adoption of case management principles in our arbitration jurisprudence. And like you mentioned, taking a cue from the success of case management hearings in international arbitrations, they now find mention in our Commercial Courts Act as well. But how does one ensure that a case management hearing or a procedural order number 1 does not become an exercise in futility, and it does not unnecessarily fetter flexibility? So in my experience, regular monitoring of matters by tribunals, a periodical monitoring, ensures that there is momentum. In genuine cases where there is a need to deviate slightly from the agreed procedure or timelines, there should be flexibility to maneuver such situations. However, there are situations as well where lawyers and parties alike try to manipulate the process, and there it should be rigid enough so that there is no mockery of the system. I doubt there is anyone in this August gathering today who can suggest that a case management conference or a procedural order is a waste. Most institutional rules, and I was very happy to see even the IIAC rules, Rule 25, and Mr. Chandru threw some light on that, provides for a case management conference. Some institutional rules make it mandatory. ICC, I believe, makes it mandatory. CIAC has a provision, LCIA has a provision. So I can confirm from my experience that a well-defined structure at the very start of the arbitration process ensures that tribunals do not hold unnecessary hearings, So costs are taken care of. I have just 2 or 3 concerns which I have faced with case management hearings, where often at times terms of reference are also drawn. In multi-phase arbitrations, these early stage orders or procedural orders tend to become obsolete over a period of time. So as a practitioner, I always insist that when we are moving to the next phase of the arbitration, we have a fresh procedural order and we do not rely on procedural order number 1. And secondly, I have seen that when terms of reference are drawn, some parties during the currency of the arbitration or later when matters get to court try to misuse expressions used in terms of reference to suggest that the contract itself was modified, which can never be the case. And this is a guidance note for all the dignitaries present here, that when terms of reference are being drawn, please take due care to ensure that what you write there are no errors, because that can be misused to suggest the contract was amended or modified. A terms of reference is at the end of the day a document of convenience. It can't modify the underlying contract. So those are my 2 cents so far as this is concerned.
Thanks so much, Siddharth. And some very well made points there also. And just for the benefit of people who may not have seen a procedural order number 1, one of the things that arbitrators usually put in a procedural order number 1 is a procedural timetable. And it's not the timetable for the first few stages of the arbitration. In fact, the most important date in that procedural timetable is the last one, which is the hearing dates. And why is that important? And you would have, I'm sure, experienced it in your own arbitrations where, availability of arbitrators is a problem. Today, if you want to schedule a hearing with an arbitrator, they'll say the next 3 months of mine are full already. But imagine if you have a procedural timetable which says 12 months down the line or 18 months down the line, I am going to reserve 1 week or 2 weeks for this hearing. They can't then say I don't have availability. And if let's say there are 3 arbitrators, they all come together and set that date. And that date is like sacrosanct. You cannot move. Come rain, come shine, move mountains, that date cannot move. Like Siddharth said, build some flexibility, provide yourself, if there is some slippage, can you still meet the hearing dates? But if you do that, you already have your dates set. The institution ensures your fees are set. So predictability both in terms of time and cost starts getting inbuilt from day 0 itself. So thank you so much for sharing that, Siddharth. On that, then I'll move to the next phase. So you've now started the arbitration, set a case management conference. Now comes, party time. You have to submit your pleadings. Hasit already alluded to a memorial approach also. But Smita, I'll turn to you now on this issue. In document-heavy arbitrations, and I'm sure everyone here in this room probably deal with document-heavy arbitrations on a day-in, day-out basis. How can counsel and arbitrators, while they're filing pleadings, while they're giving evidence, how to navigate in a document-heavy arbitration? Do you have some guidance and tips on that?
Very good afternoon to all of you. I'm grateful to IIAC and Ministry of Law and Justice and ONGC for having me here. And I commend IIAC for this conference. For the first time, it has drawn or recalibrated attention to the law officers of CPSEs. This is a significant departure we have seen in the last 20 years, at least in all the conferences which have been going on. In my experience of more than 2.5 decades of handling arbitrations and disputes, this is the first time I've come across, such a significant departure, and that's very, very major, and that probably sets the trend and tone. Now come to your question. We all know that in arbitrations, major arbitrations which involve a lot of documentation, you spoke about mid-arbitration stage, but the very first stage is even when you're preparing for the arbitration or even when you're preparing defense for the arbitration. Because the claimant in almost all cases where the contractor is the claimant from the very day of the award of the contract would be already preparing for the arbitration. So all his documents are well prepared. Probably he would also have an expert acting for the specific communications which are sent out during every single stage of the project. So he's preparing for the arbitration. Whereas the public sector would be, our objective is the project should meet the timeline, the project should, be commissioned mechanical completion, commissioning has to be carried out on time. So, and there is also a movement of the officers in that sense, that when you are a large organization with your presence across the country, there would be movement of officers. So, and when there is a site movement or a site closure, gathering of these documents becomes the first most important thing. And I would say in all this process, it is the law officer who is the person who bears the cross. So once the documents have been gathered, once the pleadings have been placed, and when we come to this stage, mid-arbitration stage, to my experience, it is very, very important to have a very specific system for document management, which is presently not happening in ad hoc arbitration. I remember the year 1998 when I started out, my career in law. I was just a young lawyer who had just passed out of law school, and the large law firm, we were handling one of the largest arbitrations, which was BPCL, then it was KRL, which was then Kochi Refineries. So the amount of documents which was, you can understand, the amount of documentation, but to a large amount, last 20 years it has been streamlined, but ad hoc arbitration, it is not happening. We have seen cases where in the ad hoc arbitration, arbitrators have changed, presiding arbitrator on account of death has probably changed twice or thrice, and the documents are, totally at wherewithal, and there is a real difficulty in proceeding ahead. So in this system, in this context, it's very important to have a document management system which sets an easy access of documents and easy display of documents, which at the same time maintains the confidentiality of the nature of the documents, easy access during the trial, during all the stages of hearings. So this is very, very important. I think with a system with emphasis being on institutional arbitration, and with IIAC coming in the picture, a significant change would be made in this direction in domestic institutional arbitration.
Thank you very much for that, and that's a point worth making, very importantly, because a lot of people have faced that problem. And we don't want to be penny wise, pound foolish, because I know document management systems cost money. I mean, nothing comes for cheap. But investing that, like you said, even during the course of the project, and at least if not that, once the arbitration starts, from the get-go, instead of trying to do all this during the hearing, is money well spent. So thank you so much for sharing that, Smita. Now, I'll move to the next question I had, and here, Hasit, I'll probably turn to you. In the stage of, when pleadings are being filed, documents are being exchanged, one stage that comes across in domestic arbitration very specifically is the stage of admission, denial of documents, and marking of documents. Quite a chic anecdote. I started my practice in sort of London and Singapore, where I'd done arbitration for about 10 years. I'd never come across this stage. So the first time I come to an Indian arbitration or domestic arbitration and they say marking of documents, I was shocked to see that the 3-member tribunal is spending 3 days just writing Exhibit C1, Exhibit C2, putting a stamp and seal. Is this necessary? Is there a better way to do it? Can we bring some efficiencies at that stage?
Yes. So the admission denial process that we have and marking of documents, interestingly, in the US, the Federal Rules of Evidence, as used in trials, has the same procedure. Yet they have thousands of documents in discovery, tens of thousands actually in ordinary cases, and yet all this marking and all that is carried out with help of computerized systems. So that makes it easy. The other aspect which I saw in civil law countries when I did an arbitration in one of them is that there is a presumption that you won't file fake evidence. So there are like domestic laws around it. I mean, so nobody would file fake. But I have heard from, like a friend from Indonesia, that it's quite common to file fake evidence. So how does a tribunal, if you are an arbitrator, decide that, like, let's admit everything? Or let's, like, filter out another thing. So there are tools available that, in the sense that you get everything marked as the parties have done, and then allow authenticity challenges. So this is what is the standard best practice that is used. But I think there are ways in which parties could minimize costs inter se. That's what happens in USA by both the parties agreeing to what are known as stipulations, that these documents we don't have objections to mark. But our culture, because as I said in my earlier comment, comes from court, it's necessary to object to marking of each and every document. So that makes it even more adversarial. So I think there is need for protocol guidance, especially around, and if you look at almost all institutional rules, including ancestral ones, are very silent about the evidentiary part of procedure because they want to allow for variations of civil and common law systems and all that. That's why they are not prescriptive. But I think there is a need for protocol in domestic arbitration so that it moves away from the court procedure and into a zone where there are enough due process guarantees that you don't have mischief played around, but yet you have things done fast.
No, thank you again. I mean, that's a pet peeve of mine, so thank you for seeing it so eloquently. And there are ways and means of doing it, right? You don't have to start from one end of the spectrum and move almost to the other end. So you don't have to say, I will assume everything is authentic. Equally, you don't have to say everything I will assume is not authentic. There is a way, a midway point that you can do. And in fact, there's a practice that I encountered when I was doing some arbitrations in Bombay, actually, where the council do inspection of documents outside of the arbitration. Instead of getting all originals into an arbitration hearing, the council go to each other's offices, especially when there are emails or any originals, you inspect them. And then what happens is you are able to narrow down out of 10,000 documents, maybe you'll say there are 50 documents which I really want to contest or there is some issue about it. But this practice of existence admitted, content denied, frankly, I think we need to move beyond. But thank you for sharing that. So this is on pleadings and evidence, and I think in the interest of time, I'll move to the next phase, which is pre-trial preparation, right? So now we've submitted the documents, evidence has been filed. At that stage also in international arbitrations, it's quite common to have what's called a pre-hearing conference. And in a pre-hearing conference, you're looking at logistics, etc. Sandhya, maybe I'll look to you to say, in your experience, after the pleadings have been filed, is it worth all of them sitting together and having a check on what's happened and planning for the future? Is there any merit to that, or is it just a wasted opportunity?
Well, it's always good to give the opportunity of, to parties to, if they have any kind of objection to any part of the pleading or anything. Because after, filing everything and starting the hearing and conclusion, there is hardly any chance. So that is quite, I think, important. But as a client perspective, I have a certain wish list from the institute and from the arbitration process that most importantly, it has to be, there has to be timely completion of the proceedings. It has also to be cost effective. Wherever necessary, we should have the virtual hearings because there is a cost involved in the transit, stay, flights, arrangements, everything. And even the client from their place can put their arguments. So from that perspective, and the most important part is the fair and reasonable award and adjudication. That is the most important thing because when we are talking about that there should be restriction on filing of appeal, there should be less court intervention. We forget that if the award is not reasonable, parties will go to court, certainly. And if the award is fair, means it is as per the terms of the contract, it is they have not traveled beyond the their contractual conditions, then certainly there is higher chance that both the parties will accept. We have done that in an international arbitration. There is a case when both the parties, ONGC and the other party, they have not challenged, which means it was quite fair. And in international arbitration, I have seen a very important thing that there is a e-filing and everything, paperless kind of process. Plus, they have strict timelines, 9 to 6 hearing, break of 15 minutes for tea and half an hour for lunch or whatever. And they follow the schedule. Not even a single minute is exceeded. So they're very disciplined. And the end-to-end process is monitored. One example I can share with all of you that there has to be very much transparency in the system. So in one of the matter, we received refund of administrative cost, which is very, very, unusual thing in our country. We hardly get any refund. Whatever we pay, it is gone. So what they do is they keep the track of expenses item wise, and they share with the parties that under this head so much expensive, and the balance they return to the parties, administrative fees. So my expectation from IIAC is also the same, that administrative fees should be displayed or transparent and should be shown to parties. Thank you.
I'm sure Justice Gupta is taking note of that one, but points very well made again, Sandhya. I think it's worth having that check in the between, because if you've an excellent case management conference and if the next time you're meeting is only the trial, if there is some issues that have arisen in between, you don't have the opportunity and you may end up derailing the trial. And instead of that, if there is some hearing in between, it just gives you an opportunity to vent. And also equally, all of the logistics that you talked about, should it be a virtual hearing? Should it be a physical hearing? Where should it be? Who will bear the costs? What are the arrangements that need to be made? Instead of every hearing, you deciding, okay, tomorrow it will happen here, tomorrow you do this, you just fast track it, get all of that done and dusted when you're thinking about logistics. So go to the hearing, think about the trial, think about the merits of the matter. I think, again, points very well made. I'll again move then to Amit in the same sequence we did last time. In your experience, and it comes to a point that Sandhya made, which is the quality of an award is actually the ultimate end goal of this entire process. So you should design it such that, it's properly considered. And in that vein, I have a slightly controversial question to you. In advance of a hearing, is it useful for a tribunal to circulate the list of questions to you, saying, listen, I've read your pleadings, these are 20 things I want you to address? Or do you think that would suggest some sort of bias, and should the tribunal be careful about it? What's your view?
Yeah, thank you. A very good question. Recently, we have faced the same situation in international arbitration matter. So, surprisingly, tribunal asked us a question. Learned Attorney General of India was representing us in that matter. And in between the arbitration proceedings, tribunal asked a question. So, Mr. Attorney, let us know whether there is gas or no gas. What is your case? So everybody taken it as a surprise, and attorney have to say that I'll come back to you on this tomorrow. So that was a surprise moment for us. And the real-time experience we faced about your question, the key questions should be circulated or not. So my answer is yes, very much. The reason behind it, the parties can understand what is there in the mind of tribunal, first thing. Secondly, we can also assume that tribunal has gone through the issue. They have read the file. Because most of the tribunal in these days don't read the file, they come to hearing, they don't have any idea about the matter. So by circulating these kind of questions, we know that they have gone through the matters. They know what is the subject matter, where is the dispute, what is the admitted fact, which is in dispute, which document has been denied, which has been admitted. So those things are very sure in our mind. And the key questions should be circulated. But I have a question for that. They should not prejudge the issue. They should not have biased question in mind. The tribunal or the nominee arbitrator should forget who has nominated him. While sitting in a tribunal, he should work like a Panch Parmeshwar. He has to decide the matter in a very ethical manner, without prejudging the issue, only after having a look at the entire case, cross-examination, if there, or affidavits or documents on record, he should decide the matter. This is my thank you.
Thank you. Again, excellent points all around there. I'll move to another aspect of pre-trial preparation, which often comes in the kind of matters that the people in this hall have encountered, which is experts, right? I mean, increasingly in arbitrations now, we see a lot of experts. In international arbitration, sometimes there is a practice to get the experts to meet before the hearing, try and say, okay, I agree with you on X, I don't agree with you, so limit the scope of disagreement. In your experience, Smita, especially given your role, you work as consultant, you guys are inherently experts. What is your view? Is it worth doing that exercise, or do you just think they're going to come back and say, I disagree on everything?
So let us understand, when we talk about arbitration and dispute resolution, we must never lose sight of the fact that what is up there on the table, it is resolution of the dispute. And whatever it takes, it must go into the resolution of the dispute. So to specifically answer your question, when there is a matter of technical expertise, say regarding commissioning or pre-commissioning, which involves a certain technical expertise, if the witness is to be examined or expert witnesses are brought in by, it could be witnesses brought in by the parties other than witnesses brought, called for by the arbitrators. So keeping in the spirit of resolution of the dispute, and also I just take a cue from what Sandhya and Amit said, that, see, why are we saying that all the awards are challenged? When there is a resolution of disputes, both the parties should be happy about it. If they are not happy about it, they will go on litigating in an adversarial manner. So taking a cue from all of that and stepping backward and looking at the process of expert evidence, I don't think there is a harm if experts were to confer especially in technical matters, because that will bring clarity to the arbitrator. Because at the end of the day, the shift is to happen to assisting the arbitrator to arrive at the most fair and just, end result. So from that perspective, it would be a welcome measure.
Thank you. And I think, again, excellent point there. We then move to the next stage of arbitration, which is really the meat of it, the trial. And we'll explore if there are things that we can do to enhance efficiencies there. And here, Siddharth, I'll turn to you. In international arbitration, it's often the practice that you start with opening submission. So you start arguing the matter first, then go to cross-examination, and then closing submissions, which is usually in writing. Do you think that practice is desirable in India? Or, what's your view?
Sure, Vikas, thank you. And before I take that, I would also want to maybe say a few things about the memorial approach, because it all ties in with this. And I heard Ms. Sehgal, I heard Mr. Seth on their perspective regarding a memorial approach or a similar all cards on the table approach, where pleadings and evidence are everything is filed together at the very start. This is a hallmark of ICC arbitrations and other civil law jurisdictions, civil law influenced procedures. But the suitability of this approach, so far as Indian context is concerned, depends on various practical, cultural and legal factors. Because memorials approach is not something which is very commonly used in common law jurisdictions. And in my experience, and that's something which Mr. Seth also touched upon, this may not be very practical for India. Also answering your second part of the question, because we carry the legacy of court-like procedures, where we are used to following a certain sequence of pleadings, claim, defense, rejoinder. We then move to the stage of evidence, and then arguments followed by written submissions. Indian practitioners I have seen, including me, we are not always prepared in that sense to have a full-fledged pleading and evidence at the very start, especially when there is no discovery and production which has happened. We've seen that with Indian clients, we've seen that with various other foreign clients, that crucial documents are held back from the tribunals, from the other side. There are various Privy Council judgments commenting on this practice, and therefore that does not really work in our system. Front loading of all the evidence at the very commencement is also not very appropriate in smaller disputes, because it's not cost effective, it's very expensive. Now, taking specifically the question that you put regarding opening submissions, so because any procedure, so far as it ensures fairness and equal treatment, should be okay. However, the procedure that we generally follow in India is not that. We start with pleadings, how the case develops, what evidence is there. We then move to the next stage of cross-examination. What are we able to elicit from the witnesses, and then we go to the argument stage. But since there is party autonomy, there is that freedom which parties enjoy. They are free to develop any specific procedure that may want. In some cases, witness actions are dispensed with. There are arbitrations which are decided on the basis only of documents and oral hearings without the need for any elaborate evidence or cross-examinations. Opening submissions are requested by some tribunals at the very start, even in domestic arbitrations, where they want to get a context of what the dispute is like, and that actually helps. The opening submissions at that stage are not very elaborate. They are skeletal submissions because you're giving an overview of the respective positions of the parties, and that helps tribunals to make an effective procedural order number one and an effective case management hearing to decide what they're going to face as the arbitration progresses. But I still believe that having a full-fledged opening submission even before witnesses have been cross-examined may not align with the legislative intent that we have in India and the procedures that we follow in India.
Fair. Okay, thank you so much, Siddharth. I'm trying to rush forward because I'm really keen to stick to time. I know I have about 5 minutes from what the moderator has told me, and I want to address a couple of questions before I go to audience for one. So Amit, very quickly to you. And Siddharth mentioned this briefly, which is equal opportunity to present a case to the parties. And in international arbitration, as you will know, the arbitrators say, okay, we have 1 week of trial, claimant you have half, respondent you have half, you do what you want. Is that approach possible in India? Because, parties will say, I want to fully cross-examine my witness, I don't know, over 20 days. But is that approach desirable, possible?
Looking at my experience in recent days, we have applied that in India itself. Yes. In an international arbitration matter, which was taking place in India, in that we have applied the same rule. There were 14 witnesses from both sides to be cross-examined by both the parties. And we equally distributed the available time of 23 days amongst all the witnesses and parties. And we also kept 2 days as reserve in case of any spillage, and that happened. Saturday and Sunday we worked, and then we concluded the hearing. Maybe somewhere around 27 working days we hold that hearing.
No, fantastic. I mean, great to see that in practice also it has worked. And on something similar but slightly different, Hasid, I'll probably turn to you. Again, something that's very close to my heart is transcription. The way evidence is recorded today in most ad hoc arbitrations is, the arbitrator dictates the question and answer to the stenographer. Do you think that's the better way to do it, or is transcription slightly better? What's your view?
I met Justice Michael Wong, who is from Singapore. He has written an essay in that ARB 40 essay about his experience of doing an arbitration in India as such, and it won some prize, in the IBA competition. I think transcription should be the only way, because it will force you to change the style of cross-examination. What cross-examination style we have right now actually is suitable for a criminal trial. It is not suitable for a civil trial. But making people change it, I think technology is the only way we can make people change it. That everything you say is recorded. That's about it, the only way to go about it.
And just for people who may not be familiar, in transcription, what happens is you record everything. So if, let's say, a lawyer is asking a question, the question comes exactly as the lawyer has asked, not how the arbitrators has paraphrased it. And if the witness answer, it comes exactly as the witness answered, not as how the arbitrator paraphrases. And giving you just numbers, right? If in a stenographer-led evidence, in an hour you can complete 20, maybe 30 questions, in transcription, you can do 5 times that much in the hour. So you can complete about 150 questions. So imagine the efficiency improvements that you can achieve. So that's something that I'd strongly urge people to consider. The very last point before we conclude, Smita, to you, costs. At the stage, in arbitration, a lot of times, either, costs are dismissed off as, winning party to bear the cost without really a reasoning to it, or proper costs are not awarded. Do you think that's a problem? Is there something that we can do there to make it more efficient?
Yes. So again, that's one of my entreaties to IIAC. What is the spirit of arbitration? No party should walk out of the room feeling defeated. If we are to bring down the number of litigations, number of Section 34 petitions in this country, number of 37, number of SLP arising from arbitral awards, it is important to contain everything within that award. Let not any party walk away feeling defeated. This is the spirit of arbitration. So in that spirit of the arbitration, while the contract may say that parties, costs will be shared by the parties, while certain powers have been given to the arbitrator in the act itself, I think some kind of reasoned approach has to be there, because especially when the claims are awarded along with the interest. Let us understand that. So some kind of balance has to be struck there. Instead of blanket, let the winning party walk away with the entire cost. So that's...
Thank you. And I think a proper cost regime is probably at the very bedrock of efficient arbitration, because it reduces frivolous actions. So if you sanction parties to say, you won the arbitration, but you filed this frivolous application, so I'm going to deduct X amount of cost for you, people will also be a little more careful. They'll say, okay, I don't want to file frivolous actions, let me be a little more considerate. And with that, at 1 minute before what I promised the organizers, I think I bring this panel, at least on our end, to a close, and I thank the panelists for an absolutely lovely session. I thoroughly enjoyed it. With the moderator's permission, if we have a couple of questions from the audience, we can take it, but otherwise I'm in your hands. Okay, I'll take that as a yes for 2 questions if we have, please.
Sir, I am Rajendra Babu from ONGC. I am looking after the procurement policy. I have a basic question on the policy related matter. All CPSUs follow the government policies regarding the procurement. As regards the arbitration, there is a circular from DOE in 2024. It allows only arbitration up to 10 crores. Whereas, we are discussing about the encouraging the arbitration, whereas the government guidelines says other way. So what is your comment on that?
Please, Smita.
I'm so glad that you asked this question, because today we are navigating in a scenario where there is an equal thrust on mediation as well as arbitration. So the way we understand it is, when there is a circular of June 2024 which says that there shall not be advocating for no arbitration beyond 10 crores, and the Mediation Act having been enacted in 2023, and then there are guidelines also to that effect. What is mediation? It comes as a first step. So in all disputes, there should be an effort necessarily through mediation to bring the dispute to a closure. In the event that is not happening, then we go in for arbitration for less than 10 crores. That's what I would say.
I think sir has a different take.
Finally,
sir is asking whether why we are
the
not
limitation of 10 crores
implementing it.
The arbitration, finally, whatever you are discussing, you can go only up to dispute amount of 10 crores only. So beyond 10 crores, government doesn't allow to go for the arbitration.
Sir, and I think you're asking this question at an excellent forum, given the kind of representation we have from the government. And I think I take optimism from the fact that this morning we had the law minister, we had the secretary of the Department of Legal Affairs, both batting for arbitration. And I think the circular came in at a point in time where the government really felt anguish at arbitration, and legitimately so. They had a number of the reasons to be disappointed with it. But hopefully in this session, with this deliberations, they see that the problem is not arbitration. It is arbitration the way it used to be done. And with IIAC, with the kind of benefits that all of us talked about, all of those limitations can be overcome. So hopefully the government will also clarify its stance and make it clear that it's not limited to that, but we are hoping people in the audience can make that happen. Last question. All right, then. I think you have lots to think about. We're all here in the room, so you can please come back and ask us anytime, either during the breaks or later. All that remains for me to do is to thank all the panelists for an excellent deliberation, and I thank all the audience for being such patient listeners and for all the valuable contributions. Thank you.
I sincerely thank you, sir, for adhering to the strict timelines. Thank you so much, sir. Thank you to all our esteemed panelists for an exceptionally enriching and thought-provoking discussion. Your insights have truly added great value to the proceedings. Now it's time to felicitate our distinguished speakers of this session, for which I would invite Mr. Vinay Kumar Sandhuja, Registrar IIAC, to felicitate Mr. Vikas Mahindra. Requesting Dr. Venkateshan, General Manager Legal, GAIL India, to felicitate Mr. Amit Jindal. Now I call upon Mr. Karan Kawal, Deputy Registrar IIAC, to felicitate Ms. Sandhya Yadav. Mr. Ashish Padam, to felicitate Mr. Haseed Seth. Requesting Mr. Gautam Taneja to felicitate Ms. Smita Sehgal. Ms. Quilin Talukdar to felicitate Mr. Siddharth Sethi. Also requesting all the moderator and the speaker to come forward for a group photograph. Thank you so much. Please have a huge round of applause for a wonderful and brilliant session. Thank you so much.
We'll just begin our next session in about 2 to 3 minutes. I would request all the speakers, all the panelists to please be seated so that we can just begin the session.
May I request everyone to please be seated so that we can start our next session?
I think we are good to go, so we can just start. So we've now come to the final technical session of the day, and it is my pleasure to introduce the moderator of the session, Mr. Kanu Agarwal, advocate on record and partner at Pramati Partners. Let me also introduce the panelists for the sessions. We have with us Mr. Shreyas Jasimha, founder, Arna Law, counsel and arbitrator. We have with us also Mr. Avneet Singh Arora, director, Department of Legal Affairs, Ministry of Law and Justice. We then have Mr. Manmeet Singh, partner, Cyril Amarchand Mangaldas. We also have Mr. Ajay Thomas, independent arbitrator and ADR consultant. And lastly, but not the least, we have Mr. Abhishek Gupta, Central Government Standing Counsel, Delhi High Court. Over to you, Mr. Agarwal.
Hello, everyone. At first, I would like to thank IIAC, ONGC, and the Ministry for perhaps giving this young boy an extremely generous opportunity to be a moderator in this August gathering. To my understanding, this might perhaps be the youngest panel, and we intend to keep it open, short, and precise. For full disclosure, I wish to first say that I do not perhaps have as much experience in arbitration and specifically arbitration practice as most people in this room. I am primarily a litigator whose experience in arbitration is largely shaped at the section 34 or 37 or the SLP stage. And therefore, my interventions and my questions may perhaps be more court-oriented, and I wish to inform the gathering of my limitations. Now, in my understanding, why this topic that this panel is going to discuss today, that is the future of arbitration ecosystem in India and what we can learn from international jurisdictions, is important because arbitration as a venture, as an enterprise in the entire world, arises from two important international instruments. The first is the model law of arbitration, perhaps the most famous one, and the other is the New York Convention. And in that sense, arbitration naturally is an internationalized venture, as opposed to, say, domestic laws, which are a reflection of the sovereignty of the country. Arbitration is always international in nature. So it is these two instruments that have sown the seeds of arbitration across the globe. And thereafter, the arbitration ecosystem in various jurisdictions has evolved on its own. Again, I am not a person who believes in ipso facto lifting of best of practices from other jurisdictions and applying them to India, because India is a unique country and we are a unique set of people and we perhaps require unique solutions. But there is nothing wrong in trying to guess or trying to take what are the best practices from across the world, and that is why this session, I believe, is an important one. To kickstart the session, I would straight away go to the only government panelists on the panel, Avneet ji. Avneet ji, can you guide us as to what is the governmental policy as far as the legislative agenda is concerned on the Arbitration Act as it exists today, and what are the legislative changes that may be in the offing? Obviously, everything is ultimately left to the Parliament, but what is the ministry thinking about them?
So thank you, Ganu. As you have said the context rightly, that possibly picking up ipso facto the best practices from various jurisdictions may not be the solution for a country as large as ours. So if we can break an arbitration process into 4 stages, and I'll come to the legislative part at the end, just to give a background, there is the law which governs arbitration, which is the statute. There is the arbitral process, which is more procedural in nature. There is the arbitral awards, which then comes, and there could be a possible post-award intervention by court, where you say you are predominantly involved. So that could include either a challenge to the award or enforcement of the award. So these are the broad 4 areas where we are looking at improving our sub-steps to ensure that arbitration ultimately becomes efficacious. So the bottom line of learning for all these stages is to see how other jurisdictions are doing something different from what we are doing. To begin with, I think 2015 amendments, which we highlighted in the first session, also were a step in the right direction. For example, an international practice of independence and impartiality of an arbitrator did not exist statutorily pre-2015. So that was a best practice we picked up from the IBA list, which talks about the disclosures to be made by the arbitrators, and then see that they are independent and impartial. So this is something which is good for the ecosystem. So therefore, this was a great intervention which we took up in 2015 legislatively. Coming to the procedure, I think it's been a work in progress. We all, since morning, we have been hearing the advantages of institutional arbitration versus ad hoc arbitration. Internationally, possibly the number will be something like a 99% institutional and 1% ad hoc, which possibly in India is the other way around. So having considered and debated the entire day on the advantages of institutional arbitration, I believe procedurally it is the right time for us to maybe move towards institutional arbitration. And then coming to the third stage of awards, I think enough has been said about the quality of arbitrators and the consequent quality of awards. So if the quality of arbitrators improves, automatically the awards improve, and then the possibility of court intervention reduces. And as far as the enforcement is concerned, again, various legislative interventions are being considered to be taken to ensure that enforcements happen quickly. So this is about the context of how the arbitration process runs and where learnings can improve our entire ecosystem. As far as the legislative interventions are concerned, something like an emergency arbitration is what we are, which is under consideration. The bill was in public domain, and all of us are aware that there's a provision which has been proposed for emergency arbitration, which is again a global best practice. How much it suits our jurisdiction, we will only come to know when actually we adopt it statutorily. There is otherwise no bar, the institutions are taking it up, and that is one example that comes to mind where we are trying to come up with global practices. Another recent development has been the judgment of the Supreme Court in the Balasamy case, where modification of an arbitral award has been taken up by the court by the scruff of the neck. Again, in international jurisdictions, Singapore, UK does provide for modification of an arbitral award, but does it suit our jurisdiction is the next question. On one hand, we feel that there should be finality to awards, but if we give a power to modify, does it suit our requirement? Should we go for a limited modification of an award? Is again, we will have to see how far it suits our requirement. So these are things which are being deliberated, and let us hope, as you said, we do not pick up as is what are the best practices and try to tailor-made it to our requirements. So that will possibly be my opening remarks.
Just a follow-up question from what you have indicated, Avneet-ji. You talked about the importance of institutional arbitration. You are a government representative. Can you enlighten us as to how the private sector can really step up and help ensure that institutional arbitration is given a further push? I see that it is the PSUs and the government that is helping it give a push. Is there something that the private sector can also do?
I think possibly the private sector is much more equipped and enabled to pick it up even more quickly. Because with government there will be some policy interventions where the mandate will come of either doing something or not doing something. For a private sector, it is as simple as picking it up as a clause in their agreement and get it going. Because admittedly, the private sector is more inclined to ensure that the arbitrations are concluded more efficaciously so that their dispute resolution also happens quickly and the money or the time which is stuck in the dispute doesn't impede their otherwise aspirations to grow further. So I think for the private sector, the simplest way of doing it is to pick up a clause which provides for institutional arbitration. And obviously, the choice of which institution to go for would depend upon the performance and the market-driven rate with which the institution is performing. So I think it's a low-hanging fruit for private sector to that extent.
Thank you so much. With this, I think I'll move on to the real nitty-gritty of an arbitration clause. And for that, I move to Manmeet-ji. As a legal practitioner, what do you think is the real anatomy of an arbitration clause? And how do you think that framing a correct or a lucidly drafted arbitration clause really helps in the entire process and specifically really helps in ensuring that the hiccups that we often see with regard to appointment of arbitrators, or for that matter even involving third parties to arbitration in a given set of circumstances, can be resolved or at least the hiccups can be minimized?
Thanks, Kanu. I think it's absolutely imperative to have an arbitration provision which is clear, crystal, certain as to various aspects. Just the very reference to arbitration should be mandatory, it should be made binding and final. The arbitration clause should bring out the difference between seat and venue. There is so much litigation we've seen in this country on this aspect. The arbitration clause must provide very clearly for the process of appointing arbitrators. Now, there is a way around all of this for solving some of these threshold issues which arise in any arbitration process, which is that most institutions have a model clause, right? So today, as we are making this push towards institutional arbitration, in my view, but the parties would be at an advantage if they were to work with the model clause, because it takes away some of these uncertainties which arise from bespoke drafting. So unless there is a reason to make the drafting bespoke, and then you have to make sure that you are being very, very certain, there may be some advantage in just staying with the model clause, because these model clauses are then perfectly in sync and harmony with the rules of the institution. So some of these threshold issues would not come in the way of an efficacious arbitration process.
That's a very important point you have raised. I'd like to have a follow-up question with you on the aspect of seat and venue, and that is something that may really interest the audience, especially the people from PSUs, because they often have to deal with that issue. Even as on date, according to me, Supreme Court has rendered 4 separate 3-judge bench judgments on the distinction between seat and venue. How important do you think it is for PSUs to ensure that that dichotomy between seat and venue does not arise, in order to ensure that the litigation is minimized, that too at the threshold, let alone at the stage of 34?
Oh, I think this is very important. Where you move for your interim relief would be determined by that. Then, of course, as you said, it is relevant for the 34. It is relevant for what arbitration rules would apply to the dispute. Particularly in national commercial arbitration, it becomes very important. Therefore, having the seat versus the venue very clearly laid out is absolutely imperative. And I think now this issue is well understood. But in spite of that, we see arbitration agreements, arbitration clauses, where there is ambiguity. And therefore, my earlier suggestion that parties would be much better off sticking with a model provision where some of these issues are taken care of, and then they would be in sync with the rules of the institution.
Thank you, Manmeet-ji. Is it possible, do you think, while drafting an arbitration clause, that some of the issues with regard to institutional arbitrations and their best practices with regard to case management or costs can be included in order to ensure that when the arbitral process actually starts, that is carried out in a far more coherent manner?
So it can be done. Arbitration clauses can be made bespoke, but then the risk you run is the more you provide, the more the risk for something which may be inconsistent with the rules, something may get left out, there may be scope for interpretation. So as far as costs are concerned, very often we see there is provision for costs. But if you look at the rules of various institutions, all these things are provided for in detail. Be it international institutions and even Indian institutions like IIAC today cover aspects such as cost. Of course, there are aspects where we can borrow certain practices. Like for instance, today we have award of cost only happening at the final stage. Maybe there is scope to look at costs being awarded at an interim stage so that every time a frivolous application is filed, there is a consequence for it. It need not await the allocation of cost till the very end. So very often we see that a party wanting to delay the process would file multiple applications. So these are some of the aspects we can consider. But my own personal view is that the more we write in the arbitration agreement, the more scope for ambiguity, the more scope for litigation.
Thank you, Manmeet ji, for your insights specifically with regard to drafting of clauses, and I believe is very important, especially for this audience. With this, I guess we move to a more interesting, rather than a drafting aspect, we move to a more interesting aspect, seeking for sort of out-of-the-box solutions. I go to you, Shreyas ji. How do you think technology can be leveraged in arbitrations in India, and how do you think it can really unleash the potential of arbitration? How can we use these buzzwords of artificial intelligence, or as the previous session referred to, transcription? How can we use it in order to make the entire process better?
Thank you, and thank you for correctly recognizing me as a mischief maker, as an out-of-the-box maverick in this room. Despite my gray hair, I continue to think like that. I have a few ideas for IIAC and the Government of India to consider, which I think are critical to bridge the digital divide in dispute resolution. This is a phenomena that is observed not just in India but in multiple countries, especially in Africa and Asia. What I have as a proposal is the following. Can we not have access to the best databases, legal technologies as a library? Can the subscriptions not be obtained by institutions? Can there not be by right access to this digital library by each party, irrespective of their standing? Can there not be by right access to their counsel, irrespective of size of their practice? These are questions that are not being asked in London, New York, and Singapore, I can assure you that, or Paris. But this is also the seat where the G20 met. This is where we talked about Vasudhaiva Kutumbakam. And today, I come with two badges. One as a speaker here, and another, which is an event that I just attended at Vigyan Bhavan, on Yoga Connect. And I'm just bridging the gap between the pursuit of inner peace and now here the pursuit of peace beyond. And this is important, especially in an age of AI, where computer systems are not being hacked. Human beings and human behavior is hacked. Therefore, the answer to a technology-driven form of lawfare, that is, weaponizing the law, weaponizing approaches to applying the law, even in a private law context, the solution to that is not just more capital and more technology. The solution to that is in what we already know civilizationally. And so the answer in terms of dealing with the promise of technology and the threat of technology, I think, is to not shut our ears and doors. Of course, we will say, like the famous precept to say, Ano Badriyantu Vishwataha, let noble ideas come to us from every space, including perhaps a GPT or a Perplexity, it doesn't matter, welcome. But the access must be radically open. Right now, a good international arbitration database will cost 12 lakh rupees per year, at least. Maybe with some discounts we'll have something less. Some lawyers have access, others don't have access. And some are told if a road contractor can buy a crane and do their job, then why can't a lawyer obtain this? The question is, do you keep it with you at all times? Or is it a specialized equipment that you obtain access to when you actually require it? So the issue of technology is very material. I also, coming from the coders of the south as opposed to the coders of the north, because the word code in the north of India means your department, sir, department, Mr. Arora, the code that is written in black and white. But to us in Bangalore, to South India, and to Hyderabad, code means something else, which is how technology is written. And there, I posit that arbitral institutions must also consider engaging with the ODR movement. Currently, the ODR movement is held by various private players. Of course, they're growing. But there is a cross-fertilization of private interests between arbitrator, owner of a database, owner of a platform, owner of other services, allied services. And how much confidence will it give to a party if I knew that Coca-Cola owned the building, constructed the building, owns all the software, and then I have a case against Coca-Cola when I'm going to be participating in even in arbitration? So I think the wonderful opportunity that IIAC has is this tabula rasa, and to do things very differently, using access to 21st century ideas, but molding it in a way that will help people not just in India. India has always helped itself, but helped others to show how they can help themselves. And so therefore, the way in which this is dealt with can hopefully help people across Asia and Pacific and beyond.
Very important points, I guess, made by Shreyasji. I think I'd like to carry forward this discussion on out-of-the-box ideas. What are your views on third-party funding in India, specifically related to arbitration?
Again, third-party funding is called access to justice in many other parts of the world. In fact, the Lord Chancellor of the UK courts called it that in his paper many, many years ago, and said that third-party funding or TPF may be sounding a technical sounding name, but be it questions of champerty, maintenance, even within the common law, have been done away with for many years, decades, in areas such as insolvency and other areas. But let's take that example for a minute. If we ask ourselves and look at the shareholding of ARCs, do we see legal practitioners? Do we see other professionals who are buying an interest in the outcome? Are they participants in the legislative, in the professional process? I'm not talking about any other country, I'm talking about India. And then there is, of course, a burgeoning industry of private funded capital towards litigation and arbitration that is live and kicking in India. Look at the state amendments to the CPC. Some states permit costs to be given to third parties who are not parties to the litigation. I therefore think that burying our head in the sand from a regulatory perspective is not going to be helpful. My own personal view is that we regulate it, have body of third-party funds if need be, and if you have to do it, drip feed it, you can do it in IFSC. And IFSC is the last point I wanted to bring to your attention, which is I think India does need over time an international commercial court. We need specialized ways in which we can deal with some of these topics. And I think if you want to have a sandbox and test some of these ideas in a regulated space, rather than exposing it to all of India, doing it in an island offshore India, such as IFSC, may be an excellent way to test some of these ideas.
I certainly live by the mantra, what you can't control, you must regulate, as far as the government is concerned. Moving on, perhaps to more simpler and more court-oriented topics, I'd move to Abhishek ji. Abhishek ji, as a central government standing counsel yourself and your personal experiences in the field, what do you think there are the legislative reforms or the institutional reforms that can be brought by the ministry or as a matter of best practices by this gathering as members of PSUs and their institutions in order to ensure that the arbitral process in India is strengthened?
Thank you, Kanuji. Good evening to all the dignitaries. My sincere gratitude to IIAC, Ministry of Law and Justice, and ONGC for inviting me to this teleconference. So, Kanuji, to answer your question, without the fear of being castigated by any member of the bench, because today we are only amidst law officers, PSU officers and officials from ministry, I think there is a need for institutionalization of the arbitration process, not just a need for institutes, but then there is also a need to institutionalize the entire process. Judicial supervision cannot be a pretext for judicial interference. Nowadays, we have courts which have assumed the de facto role of appointing authority, in which more often than not, they are converting these Section 9 petitions for interim relief into a Section 17 petition before the arbitrators. And then they are also donning the hat of an appointing authority under Section 11. So, and then moreover, they're also granting status quo while deciding the Section 9 petition. So this practice of appointing the arbitrators by the courts, this needs to be curbed. I think there is a need for giving more power and more proactive role to the institutes in which they can appoint the arbitrators, they can terminate the mandate of the arbitrators, they can substitute the arbitrators even in an ad hoc arbitration. For example, in Singapore, IIAC is the default appointing authority in all the matters of appointment of an arbitrator. Similarly, in Hong Kong International Arbitration Center performs that role. So we need to recognize that these roles need to be separated from the judicial organ of the state, and they need to be performed by a specialized institute. And while we talk about the arbitration ecosystem in India, there is a tendency to telescope the activity only on the metropolitan cities, Delhi, Bangalore, Mumbai, and we tend to focus more on the multi-billion-dollar disputes, construction disputes, oil and gas disputes, and we tend to lose a sight of small vendors, small traders who might have disputes running into a few lakhs. So it's a tall order for them to battle it out on the court at each and every stage of the arbitration proceeding, be it a Section 11, be it a Section 14, or a Section 29A. So our endeavor should be that the journey should be smooth for them, so that because they do not have the resources or the wherewithal to spend so much of time in courts to hire lawyers for court. And in fact, I'm telling you from personal experience, there are so many Section 11 petitions which go uncontested. There is hardly any appearance from a respondent who might be a small vendor or a MSME party. And these petitions are allowed by the court ex parte. And the parties only surfaces when the matter goes to an arbitration. So all these things need to be considered by legislature. Amit ji is here. These need to be considered by the courts while considering any reforms. Secondly, I also wish to flag one issue, and this is at the risk of antagonizing most of the audience here and all the arbitration proponents on this panel. I feel Section 34 has to be widened, it has to be broadened, the scope of interference has to increase. Contrary to the popular perception, contrary to the practice internationally, we have to devise a peculiar Section 34 which fits our local needs, which feeds the needs of the nation. Section 34 can also be made conditional on the agreement between the parties. This happens in Australia, this happens in New Zealand, this also happens in UK, where the contours of interference under Section 34, that is dependent on the agreement between the parties. The parties may decide to waive that appeal altogether, or the parties may decide to broaden the scope of interference so that it can be a substantive appeal or review on merits. I say this because this is driven by the office memorandum, and I do not blame the government for that. It's actually driven by the vagaries of the arbitration system and the bitter experiences, and reflects the failure of the arbitration to retain and reassure the biggest litigant of the country. So whatever drawbacks the arbitration system had, at least there is one assurance to the government that there is a recourse available in the courts. If that recourse is taken away, and if you only limit the grounds of interference to one or two grounds which are superficial, according to me, 90% of the awards are upheld on as it varies basis. So that needs to change. And because see, every time you can't look globally to improve upon your arbitration act, you also have to introspect, you have to look at your local factors. There are a lot of practices which can be adopted from the local courts also. In fact, how you conduct an arbitration proceeding, one must do some training at the local courts level, at the district level, to understand how evidence is recorded, how cross-examination is conducted, how the documents are to be marked. So, you can't be blindsided by what is happening globally. One also has to look at the local factors, which also show some tendency that you have to have a supreme form of appeal. And in fact, what I'm saying, that is also echoed by the learned solicitor. So I'm sure you'll cut me some slack on that, because he's also of the view that there has to be a broad scope of interference under 34.
I quite see you have raised two extremely important points, but I'll keep my question on the first point and I'll keep the second question for the rest of the panelists. What more can be done in order to take arbitration to the tier 2, tier 3 cities? Because in my personal experience, I don't wish to further comment on it, but to really argue a 34 in a district court in the heartland is a very difficult exercise. What can institutions like IIAC, or for that matter the Judicial Academy in Bhopal or in other places, what can they do in order to ensure that whatever little remedy that a person has under 34 can be exercised properly with some adjudication at the district court level? Because in most jurisdictions it would go to a district court. Not every high court in the country has original jurisdiction.
Right. So I think for starters, these institutes can also start opening the regional centers. Like you can have a regional center in South, you can have a regional center in West, in Northeast. So that needs to be done. And in fact, there was some talk that a concept of a gift city, like similarly you can have a concept of an arbitration city. So, and then of course, the district courts, they have to be sensitized on what is the scope of interference under 34, training programs have to be conducted. And I think they have to be taken into the mainstream. And that can only happen when you frame your policy so as to suit those people. Right now, we are only framing policy for big disputes, for multi-million dollar disputes. We are straying away from the local centers, from the other regional parts of the country where actually arbitration needs to prosper.
I think that's extremely important. Moving on to the ever energetic Mr. Thomas. As an arbitrator yourself, Mr. Thomas, how do you think we can twin mediation, especially with the new act in the offing, with arbitration in order to ensure that the entire process is carried out efficiently and perhaps altogether avoided if the mediation succeeds?
Well, let me start off with my thoughts about the institutional arbitration versus ad hoc arbitration debate, I have a few thoughts to proffer on that. And I am quite sure that 90% of you in the audience are convinced that institutional arbitration is the way forward. But to those 10% who are still not convinced, I'd like to share something that I've come up with. It's a quotation with a lot of inspiration from Nani Palkiwala and his book, We the Nation, The Lost Decades. So it goes something like this. Ad hoc arbitration in India is like a Rolls Royce of 1920s vintage. Stately, because it's dominated by a lot of retirees. High fuel consumption, because the arbitrator's fees are based on the number of sittings and not on an ad valorem basis or on a per daily basis. And thirdly, it takes almost an eternity to complete a journey. Institutional arbitration, in my view, on the other hand, can be likened to a shiny new Honda Accord. It will take you to the same destination with greater speed, higher efficiency, and most importantly in the Indian context, with dramatically less fuel consumption. So, ladies and gentlemen, the 10% of you in the audience who are not convinced that institutional arbitration is the way forward, I hope this convinces you that this is the only way forward. Now, coming back to the question of twinning arbitration and mediation. There used to be a saying a few decades ago in the world of dispute resolution that mediation is mediation and arbitration is arbitration, and never shall the twain meet. Well, mediation and arbitration are actually two distinct processes. Now, if you were to look at the DNA of these two processes, they're very different. Arbitration in its DNA is very close to litigation, whereas mediation is very different in its DNA from arbitration because there is no decision which is given in a mediation. It's the mediator gets the two parties to come to a mutually acceptable solution. So these two processes, are not mutually exclusive. And today, in today's modern world, you find that notwithstanding the DNA of these two processes are different, there is a sort of blurring of lines between arbitration and mediation. I say blurring of lines because that the solid reservations that people had that to keep these two processes apart, now that's kind of going away. That resistance is going away. You find mediation and arbitration used to be complementary processes. And you find that, in a lot of contracts actually for that matter, you'll find two-tier arbitration clauses. I believe a lot of PSUs in India today already have a two-tier arbitration clause or a three-tier arbitration clause, when it comes to construction and infrastructure disputes, where you have a DAB as a standing body, then you have mediation, and then you have arbitration. So today you find that the blurring of lines between these two distinct processes has happened. There is more buy-in into even merging these two processes into one seamless dispute resolution process. You don't see so much of that in India, but if you go to more progressive, I wouldn't say progressive, I'm not suggesting that India is not a progressive jurisdiction at all, but I'm just saying if you look at the more popular hubs for arbitration, like Singapore, for example, they have experimented with these hybrid processes like ARB, MED-ARB, 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 and a whole lot of different processes where you're trying to combine the two processes into one seamless dispute resolution process. So it's very important for us also in India to actually look at these hybrid processes of dispute resolution where you're combining elements of arbitration and mediation. I was just going through a latest study. Once in 2 years, the Queen Mary University of London, the School of Arbitration, along with White and Case, does a study, a survey on international arbitration. Just got a copy of this report. It's available for free on the internet. Now, there was one aspect of this study which showed that, or one results of this study or survey was that in the international context, 87% of respondents favored solving international disputes through international arbitration, either together with ADR, 48%, or as a standalone mechanism, 39%. So if you see internationally also, there is a trend definitely in favor of using both these processes together into one seamless dispute resolution process. Now, talking about mediation and arbitration and how do you, and the blurring of lines, in the Indian context and as a relatively young arbitrator, I think there's one aspect there's a certain provision in the Arbitration Act which we often ignore. That's Section 30. Now, Section 30, I believe, is one of the few examples of a provision in a statute where there is a sort of an obligation on an arbitrator to try to settle the dispute using the mechanism of mediation, conciliation, and other processes. It's not necessary that the arbitrator himself has to sit as a mediator, but the arbitrator should definitely explore the possibility of a mediator being appointed in the course of an arbitration if he or she thinks there's a possibility of a settlement. And from the little I've seen as an arbitrator and talking to experienced arbitrators, very rarely is Section 30 of an arbitration statute invoked in arbitration. And I think that's also something that we need to, it's an aspect of the Act which is, or it's a process or a procedure which is already inbuilt into Act. It's been there since 1996. I think that's also something as arbitrators, I think a lot of arbitrators need to introspect and look at why don't you use this provision, the Section 30 provision in the Act. This reminds me again of the words of former chairman of the ICC Commission on Arbitration in ADR, Paul Jalinas, who I believe Shreyas knows reasonably well. Now, Mr. Jalinas had once said, and I quote, "In the conscience of every arbitrator, there is a mediator who is asleep. The only question is, how do you wake him up So how do you wake up this mediator who is asleep in every arbitrator? So one suggestion I have, to wake up this mediator in every arbitrator is probably to give some sort of a statutory recognition to these hybrid processes in the Act itself. And I'm looking at an example of, say, Schedule 4, which introduced the ad valorem system of, albeit non-mandatory, you had the concept of an ad valorem schedule of fees was introduced into the Indian psyche, into the Indian arbitration psyche, courtesy Schedule 4. Now, what it did is that it gave a lot of, it did introduce a whole lot of lawyers and arbitrators to this concept of ad valorem, which was hitherto not present in India. Ad hoc arbitration was common with per sitting, fees charged on a per sitting basis. So I honestly believe that if these hybrid processes could be in some way institutionalized into the Act itself, you will find greater benefits accruing to the arbitration process from having mediation also walking side by side along with the arbitration process.
Thank you, Mr. Thomas. On a lighter note, the Honda Accord is discontinued in India, and I believe successful mediations will increase manifold if the lawyers and arbitrators are paid their full fees in the event of a successful mediation.
So let's replace the Honda Accord with the Toyota Camry. And I say that because, ladies and gentlemen, this analogy with the automobile industry is extremely important. Because a lot of people think that institutional arbitration is a Maruti 800. It is not. Please remember that. Institutional arbitration is not a Maruti 800, if I draw an analogy. There are costs involved, but the costs which are involved help and assist to a very large extent in ensuring that the process of arbitration through an institution is conducted in a cost-efficient and time-bound manner.
Thank you. Thank you, Mr. Thomas. I will move on to, if I have some time, I'll move on to two questions that I had to the panel, and they may be slightly controversial. So Shreyas, the first question is to you. The elephant in the room is the June 2024 circular, let's face it. The government saying that they do not wish to go for arbitration for disputes that are valued above 10 crores is something that everyone is thinking about. I don't wish to express my comments on it, and neither do I wish to express my comments on what is the fate of 34. However, I do see a problem. I believe the problem is one of instilling legitimacy. As far as government institutions are concerned, as far as PSUs are concerned, there is a looming concern on the legitimacy of the entire process. It is because this legitimacy is in doubt that there are calls for the broadening of 34. What are your thoughts in order to ensure that the entire procedure is strengthened and perhaps some legitimacy is instilled in the entire process?
Arbitration, much like freedom, comes with responsibility. So my constitutional law professor used to tell me that what is contract? Contract itself is constitutionally speaking, is a branch of administrative law. If we were let's say, a fully state-run economy, contracts would be just a code which everybody follows as a matter of administrative rule. Because we have chosen to have a mixed economy with state participants, with private participants, the issue of contracts itself is opened out almost by delegation, not only to institutions and enterprises, but also to individuals. So there is an undoubted constitutional legitimacy to all forms of agreements. And an agreement by law, by contract, derives legitimacy from this source. Arbitration is just one form. It's in the plumbing of ideas. You cannot blame the pipe for the water or the sewage that it is contained in it. This is about piping, not about content. We can have filtration systems, we can have other systems to improve the potency or otherwise the portability of the contents of the plumbing. But don't blame the pipe. I personally think it's a bit of a passing phase. The journey that we have of welcoming foreign capital apace will necessarily compel us to embrace the fact that we will have to deal with arbitration both domestically and internationally at scale. And that scale, even one small project, will cost more than 10 crores. So we will have to see if this is commercially feasible to maintain this position. I want to quickly say that I've seen arbitrations, let's say in Hong Kong, where the simultaneous transaction, you raise a very important point about one way of having legitimacy is to take English out of it. What is the percentage of India that speaks English? Very small. Why is arbitration in English? ನಾನು ಕನ್ನಡದಲ್ಲಿ ಮಾತಾಡಬಹುದು, ನಾನು ತಮಿಳಲ್ಲಿ ಪೇಸலாம், ಹಿಂದಿ में बात कर सकते हैं. But why don't we open it out? We can have simultaneous transactions. There is an experiment in Hong Kong called eCamp. When one person communicates in one language, it's translated simultaneously into 4 others. I know. So therefore, this is not just for the high and mighty. These are techniques that are available to increase access. And the moment you increase access, you give power to people, they themselves will infuse it with right conduct, and therefore the word that you use, legitimacy, which I posit already exists.
Thank you, Shreyasji. I think I go to my last question, and perhaps equally controversial to our government panelists and Manmeet ji. Although I do believe that institutional arbitration and the development of what I would call as the arbitration bar, of which maybe I'm not a part of, is helping developing a specialized arbitration regime in the country. What more can be done by institutions? Institutions, according to me, are doing enough, but there is perhaps something more to be done in order to ensure that arbitration stops being this litigator and judge centric. First, to the government panel.
So I think the way forward, as we have been deliberating since morning, is first to have an ecosystem for institutional arbitration, which is yet to fully get established in our country. That apart, I think even otherwise, if we see the provisions of our Act, predominantly all provisions start with a catch which says unless otherwise agreed by the parties. So that is the most potent weapon that is available with the disputing parties to include everything under the sun as to how they want their dispute to be adjudicated in their contractual terms, to which I invite reference to what Manmeet ji was referring. So arbitration clause becomes the most important clause to improve upon the vagaries which exist or which we feel exist as far as disputing parties are concerned. There is no bar under law to say that if it's a construction dispute, I would want to have a civil engineer decide this, or I would want this to be done in this period, or I would want that this is the fees that is payable to the arbitrators. So as far as ad hoc arbitrations are concerned, assuming for a second if we want that to continue, there is no bar for the disputing parties to agree explicitly the procedure that they want to adopt as far as adjudication of disputes is concerned. Coming back to your question of what more institutions can do, I think there is no dispute that we are still developing as far as the institutions are concerned. Singapore is a jurisdiction which is well recognized across the globe to have done something well as far as the efficacy, the time-bound nature of how disputes are adjudicated. So I feel the most important thing that comes out for Singapore is that arbitration is a service there, more than it being about how the law is interpreted by the institution. They offer it as a service. So you have options. You have options of expedited trial. You have an option of improving your procedures. You have an option of where in the recent rules of 2025 that IIAC has come up with, they say even prior to the constitution of the tribunal, the institution can have a pre-administrative conference. So even before the tribunal enters reference, the parties and the institution can agree that this is how we will continue with the arbitration, subject to what the rules overall say. That apart, there are also certain aspects of, for example, an early dismissal provision, where the claim which is made by a party is manifestly without merit. So there's an option under Rule 47 of the new IIAC rules which say that the tribunal can decide at the first instance, should I go ahead and go for a full throttle trial or a full throttle arbitral process at all. So these are things which I feel can be adopted by institutions and the parties to offer arbitration more as a service as far as the process is concerned. The law will remain as is. I mean, there is always a scope for improving the statutory or the legislative framework, for which I think everybody agrees a lot has been done. But that apart, adopting what is in your hands and improving it to be shown as something where parties have options to tailor-made it to their requirements is, I think, the way ahead.
Manmeet, your thoughts on it?
To take off from what Avijit said, I think institutions do maintain, say, a panel of arbitrators. But I think what we need to do is go down the path of some of the more specialized, having specialized arbitrators where they can be selected for their sector specialization, not just experience, but that also requires a mindset change. Today, parties are in the mindset of appointing retired Supreme Court and High Court judges who may have the experience but may not necessarily have the sector specialization. So if we have to have India as a hub for institutional arbitration, we need to offer a pool of specialized arbitrators. We need to be able to discern that this person has the relevant qualifications and experience for, say, an IP arbitration, as opposed to just appointing somebody who may have 30 years of experience at the bar or having been a judge, but may not have the relevant sector specialization. So I think that is one. The other is that there are certain aspects which, if you look at the SIAC rules and the ICC rules and the LCIA rules, they have a hyper focus on measures to improve efficiency. Now, I'll give one example. For instance, every institution provides for a case management conference to set out the procedure for arbitration. But if you look at some of these international institutions, their rules will have specific aspects which can be considered, like, for instance, setting out time limits, setting out the page limits. Now, while it is free for any panel to evolve these rules of procedure, but at the same time, once you put them in the rules that these are things you must consider, then automatically it invites the attention of the panel to focus on some of these aspects so that cross-examination does not go on endlessly. Oral arguments don't go on endlessly. If we have to offer arbitration as a service to the international community, then we need to have processes which ensure that everybody is focused on efficiency, everybody is focused on reducing cost. And then there are certain aspects, for instance, scrutiny of awards, which, while we do have in some institutional rules processes for checking if there are any obvious typographical errors, etc., but we have to go beyond. Subject to the liberty of the tribunal to render its decision, arbitral institution rules abroad also allow the flexibility for the institution to offer comments on the substantive aspects. Now, of course, nobody is pushing a certain decision, but the ability to look for consistency, the ability to look for whether the evidence has been considered. So that will go a long way in promoting institutional arbitration, because then participants will begin to see the benefits of adopting institutional arbitration once the awards start getting upheld, once there are quick decisions. So I think these are some of the aspects which can be considered.
Very important points, sir. Just taking cue from what Manmeet ji has said, I wish to come to you, Mr. Thomas. I wish to put a hypothetical to you, because this is a PSU-centric crowd. Suppose I am an officer of a PSU and I have retired, say, at the age of 60. I have some experience in arbitration, but I do have a sector-specific specialization. What opportunities does the Indian education system or institutional arbitration centers provide this individual in order to gain further knowledge to practice as an arbitrator himself? Is it possible for IIAC to, say, partner up with leading national law institutions and provide an on-campus course for, say, a 1-year course or maybe a 2-year course, in order to help these people and further utilize their potential in order to create this specialized arbitrator who can assist maybe retired judges or maybe people who have 30 years of litigating experience, and then we can have a balanced arbitral tribunal as a whole?
Well, if you're looking at organized courses specifically catering to arbitration, there are a lot of NLUs who already offer master degrees and PGDM diploma courses actually in arbitration. NLU Delhi, for example, has recently launched a fantastic initiative, which is a postgraduate diploma in arbitration. which has been funded by a large grant given by Justice Indu Malhotra. And if you were to look at the faculty who teach on that course and the course curriculum, I think that's one course which I would think is a fantastic addition to the Indian arbitration training scene, albeit offered by a university, but by industry professionals. Secondly, I would say, if you're looking at arbitration training, the gold standard when it comes to arbitration training and accreditation are the courses offered by the Chartered Institute of Arbitrators. So I believe if the IIAC were to be getting into a sort of MOU with the Chartered Institute of Arbitrators, then you would be rolling out courses in India which are considered as the gold standard and which are kind of the entry-level qualifications to be on the panel of arbitrators at most leading institutions, including the SIAC, the HKIAC, the AIAC, and other international institutions.
Thank you, Mr. Thomas. I think with this we come to the end of our panel discussion, and I think I can open the panel to questions from the crowd if there is any.
I would like to add something.
Certainly, sir.
About the courses, we have entered into a MOU with Royal Institute of Chartered Engineers, Chartered Surveyors, London, where we are conducting mediation courses. We have done 2 sessions, others may be in line. In respect of arbitration training, as you have said that somebody is a construction expert, some expertise in a particular subject, and he wants to be an arbitrator, we have entered into another MOU with Manipal Law University. We are giving training in arbitration. One session we have conducted, the others may be in view. That is training to give the basics of arbitration and how the award is to be written. So we are already, but they are the smaller steps. I will say we have taken baby steps, we will go ahead. Thank you.
Sometimes I believe it would have been better if Sir spoke on this subject first. If there is any other question.
Sir.
Am I audible? Yeah. So I have a suggestion, since Shreyas mentioned about technology and IIAC having its own technology platform. Recently, Silicon Valley Mediation and Arbitration Center had formulated guidelines for the use of AI and ChatGPT, to what extent and what should be the disclosure and all of that. So I think while scrutinizing awards by IIAC, my suggestion would be that perhaps the use of AI, ChatGPT, etc., the guidelines should be formulated at all levels while drafting of awards and in the proceedings.
Thank you, ma'am, for raising that. I am a member of the Silicon Valley Arbitration Mediation Center, and they came out with these rules 1.5 years ago. And Justice Vishwanathan, KV Vishwanathan, it came out one evening. Next day morning, he was quoting from it at the arbitration conference. So the arbitration ecosystem is highly porous when it comes to ideas. And let me tell you what we are working on next in the Silicon Valley Arbitration Mediation Center. We are working on a group on quantum computing. I'm on that subcommittee. And we're all wondering what are we supposed to do. But that's like way out there. So, but I agree that this thought leadership, sir, Justice Gupta ji, we should encourage it within our institutions. Many institutions have study groups, working groups, user groups. This is the kind of dialogue that we need on an ongoing basis. And that is what the structure of committees provides. Otherwise, it becomes episodic, and it takes so much effort to organize a conference like this. But if you keep up this energy and samvad, while between one such event and the other, then you can actually filter a lot of wonderful ideas through.
Thank you, sir. I guess this is the end of it. This was a... I'm sorry.
Gathering here, also of the ministry officials. Section 50 of the Mediation Act contains a provision regarding protection in respect of actions taken in good faith. It accords that kind of protection to the central government, the departments, the officers, etc., etc. So maybe when deliberation is being done on the Arbitration Act, for the amendments, something of this nature could probably be introduced, because then it will give a fillip to the parties, the stakeholders, towards moving towards accepting the arbitral awards, so that the further litigation is cut down. Thank you.
Thank you, ma'am.
Sir, one thing. Under MSME Act, conciliation is mandatory before converting into the arbitration. Is the same thing under Arbitration Act also?
I don't think that is mandatory under the Arbitration Act. Maybe something that Avneet ji may want to point out.
It's not mandatory under the Arbitration Act. The MSME Act of 2006 under Section 18 provides for statutory mediation and statutory arbitration, agnostic of whether there is a clause to facilitate the MSMEs to have an efficacious dispute resolution mechanism, whereas the Arbitration Act is more party autonomy driven. So therefore, under the Arbitration Act, it is not mandatory.
With the permission of the chair, I had one concern, because very rarely do you get the opportunity to be part of such an august gathering, where we have relevant people who really take decisions relating to policy in arbitration in India. Now, whilst we are all here promoting the concept of institutional arbitration, a big concern I have with institutional arbitration is this mushrooming of institutions with absolutely no control over quality. I would call it, institutions are popping up like cycle repair shops in the 1980s. So while we have IIAC here as a gold standard of sorts, something needs to be done to ensure that the good name of this concept of institutional arbitration is protected. Something needs to be done to ensure that there is some sort of minimum quality when it comes to institutions in India today. Right now, it's a free-for-all. There are absolutely no controls over anybody to set up an arbitral institution in India, and that's a huge concern. I think when I look at, I've been a flag bearer for the concept of institutional arbitration for a very long time. Great admirer of that concept, but this is a big concern, a big fear that
I think we have tickled the interest of Justice Gupta here. I would really want to have his thoughts on this.
The concern shown by my friend Ajay Thomas is genuine and actually relevant, but the ball is in the government's court. In 2019, Arbitration Council of India was conceived to grade arbitral institutions and arbitrators both. But unfortunately, it has not come into effect. Once it is given proper shape, probably there can be some grading. Like universities, we have a NAC grading. Something of that can eliminate, or at least make people aware of the status of the arbitral institutions and the arbitrators also. As of now, we don't have any data how many arbitrations are conducted in the country and what is the status. Only data available is when the matter goes to the court, and that court also doesn't have a data of how many are Section 34 petitions. So everything is in a gray area. So let's see.
Adding to that, sir, if it's not just arbitral institutions, but also the ODR companies. Yeah. SEBI, for example, has its list of companies that are providing ODR. Each company claims that its set of rules, it de facto works as an institution. And de facto has, it's called almost like it's the users as potential customers. So there's a certain process that has been unleashed, which will also have to be addressed.
Even ODR institution will be institutions covered under the scope of Arbitration Council. What is their credibility, how they conduct, whether they meet the standards of arbitration, fairness, transparency, all these things would be relevant. But the decision has to be by the government. Good legislative step taken. Actually, that is, if Arbitration Council of India is established, that will also curtail the power of the court for appointment of an arbitrator. One problem, one solution leads to end of many problems.
I guess we must end with the wisdom of Justice Gupta. And I guess, I believe, I hope that this was an enlightening session for everyone. And I thank again the Ministry of Law, ONGC and IIAC for this opportunity, and I thank on behalf of the panel.
Indeed, sir, it was a very proactive session. We thank all the panelists for such a lovely session, and whatever discussions we had, it was great. So now I would request Ms. Suganya to please felicitate our moderator for this session, Mr. Kanu Agrawal. Next, I would request Mr. Shaurya Saraswat to please felicitate Mr. Shreyas Jaisimha, founder, Arna Law, Counsel and Arbitrator. Now, I would request Ms. Sonali Samal to please felicitate Mr. Avneet Singh Arora, Director, Department of Legal Affairs, Ministry of Law and Justice. Next, I would request Ms. Amrit Kaur to kindly felicitate Mr. Manmeet Singh, partner, Cyril Amarchand Mangaldas. Moving on, I would request Ms. Arya Verma to kindly felicitate Mr. Ajay Thomas, independent arbitrator and ADR consultant. Lastly, I would request Dr. Akanksha Tripathi to kindly felicitate Mr. Abhishek Gupta, Central Government Standing Counsel, Delhi High Court. Once again, thank you, sir. I would request all the panelists and the moderator to please have a group photo.
A huge round of applause for a brilliant session moderated by Mr. Kanu Agrawal. Thank you. To formally bring this session to a close, I now invite Mr. Ganesh Chandru, part-time member of India International Arbitration Center, to deliver the vote of thanks. Over to you, sir. Thank you.
Thank you. On behalf of the India International Arbitration Center, it gives me immense pleasure to have the last session, which is vote of thanks, and it's 15 minutes given for that. I'll not take that much time, very few minutes. But we have to thank a lot of people. First, the Ministry of Law, Department of Legal Affairs, the Honorable Minister, Law Minister, Shri Arjun Ram Meghwalji, who gave such a inspiring speech today and encouraged all the stakeholders here, the PSUs, to consider having institutional arbitration, especially IIAC. And to the Law Secretary, Dr. Anju Rathi Rana, Mr. Ajay Kumar Arora, Joint Secretary, Mr. Avneet Singh Arora, Director, Department of Legal Affairs, Ministry of Law. Thank you very much for taking this initiative along with IIAC to put this together. And to Mr. Arun Kumar Singh, Chairman of ONGC, for his practical speech where he gave his experience from the industry of several years, which actually set the ball rolling for the conference today. And to all the other personnel from ONGC who have been here today. And to Mr. Moses, Secretary, Department of Public Enterprise, who was here this morning as well. Thanks to him. And thanks to all the speakers, the moderators, who've come in all from all over India. I think Shreyas gave a flavor of Kannada, Tamil, and Hindi, and English, of course, which really is, I think I've met people from all corners of the country, truly a national conference. And of course, at IIAC, it's very important that I do mention all the names, starting, of course, from our leader, Honorable Justice Hemant Gupta, the chairperson, for all the guidance, and the CEO, Mr. Naveen Kumar Singh, Mr. Vinay Kumar Sandhuja, the registrar, Karan Kanwal, assistant deputy registrar, Ashish, Padam, and Akansha, the two counsel who have been comparing and keeping us on the edge of our seat. And to all the law students who have been volunteers from various law schools, they've done a fantastic job. To our media friends for covering this, and to Ms. Bhumika as well for covering this event. And finally, to this wonderful venue, this superb summit room at Bharat Mandapam. We can all be proud of this facility. And it's really fitting that the India International Arbitration Center's conference, with the support of the Ministry of Law and of course the PSUs today, is being held here. Thank you all, and have a great rest of the weekend. Thank you so much.
Thank you, sir, for your gracious words. Ladies and gentlemen, with that we conclude our conference proceedings for today. We now warmly invite you to all join us for high tea. We hope the enriching discussions will continue informally over the refreshments, and that today's sessions have offered invaluable insights and takeaways for everybody present over here. Thank you once again for your kind presence and participation. We look forward to welcoming you at our future events. Have a wonderful evening. Thank you.